and continuing Epstein's crimes. And Great St. James became an instrumentality of those crimes. The document goes on to other entities involved in the abuse. Number 30, defendant Poplar Incorporated is a corporation established and organized under the laws of the Virgin Islands. Poplar Incorporated was incorporated November 22nd, 2011. Epstein was president and director of Poplar Incorporated, and its purpose was described in corporate filings as, quote, holding property for personal use. Defendants Indike and Khan are secretary and treasurer of Poplar Incorporated, respectively. A certificate of incumbency provided to the Department of Planning and Natural Resources also lists Epstein as president of Poplar Incorporated and expressly authorizes the incorporators to conduct, quote, transactions related to permitting matters submitted on behalf of Great St. Jim, LLC, unquote. Number 32. Poplar Inc. is listed as the signatory for the 2017 annual report for Great St. Jim, LLC, and the signature appears to be Jeffrey Epstein's. The petition for probate and letters of testamentary filed by the Epstein estate lists Poplar Incorporated as holding title to Great St. James. Thus, Poplar Incorporated participated in carrying out, concealing, facilitating, and continuing Epstein's crimes. Number 33. Defendant Plan D, LLC, is a limited liability company established and organized under the laws of the Virgin Islands. In its original articles of organization, filed October 19th, 2012, and its annual report filings, Epstein's pilot, Larry Vasosky, was listed as Plan D, LLC's sole manager and member. However, the July 31, 2019 annual report revealed Epstein as the principal behind Plan D, LLC. I'll share with you, that's only half of the document. This barely scratches the surface of this complex web that authorities have had to untangle to understand what Jeffrey Epstein and his associates were doing. Thank you to Save America Movement for their work on this reading and the Trump Epstein Memorial Reading Room.
Thank you so much, Miles. And we are now officially in our second hour of our 24-hour live stream, Cover to Cover Up, a public reading of the Epstein files from the Donald J. Trump and Jeffrey Epstein Reading Room in Lower Manhattan. We are raising money for World Without Exploitation. So thank you, everyone, for tuning in. Thank you for being here. And I am now joined by political strategist Steve Schmidt of The Warning. Steve is a member of the Save America Movement Steering Committee. Steve, why is this event so important to Sam? Oh, Steve is not with us yet. I apologize. This is the nature of live streaming for 24 hours. So let me actually just turn back to reading something while we wait on Steve, who I know is joining us momentarily. So I'm reading from a court order. This is the United States District Court from the Southern District of New York, the United States of America versus Ghislaine Maxwell, defendant. This is Allison J. Nathan, District Judge. On March 5th, 2021, defendant Ghislaine Maxwell submitted to the court an application for an order authorizing a subpoena pursuant to Rule 17c3 of the Federal Rules of Criminal Procedure. The proposed subpoena was directed at a law firm that represents alleged victims of the defendant. As is standard for Rule 17c subpoenas, the application was made ex parte and under seal on the ground that it reveals defense strategy. A number of court cases are cited. Rule 17c3 provides that, quote, after an indictment is filed, a subpoena requiring the production of personal or confidential information about a victim may be served on a third party only by court order, but before entering the order and unless there are exceptional circumstances, the court must require giving notice to the victim so the victim can move to quash or modify the subpoena or otherwise object. I will get back into this shortly, and we will have other guest readers, but I do think right now we have Steve Schmidt joining us, so let me turn it over to him. I will get back into this shortly, and I will but I do think right now we have. So let me turn it over to him. I will get back into this shortly, and I will but I do think.
On March 19th, the line prosecutor sent a lengthy email to a prospective pro bono attorney for one of Epstein's victims who had been subpoenaed to appear at a deposition. The email listed the attorneys representing Epstein, the targets of the investigation, and recounted in detail the investigation that had been conducted to that point. The email did not reveal the fact that Epstein had signed the NPA in September 30, 2007. On May 30, 2008, Jane Doe 5, who was recognized as an Epstein victim by the office, received a letter from the FBI advising her that, quote, "This case is already under investigation. This can be a lengthy process, and we request your continued patience while we conduct a thorough investigation," end quote. The May 30th, 2008 victim letter to Jane Doe 5 also acknowledged the victim's rights under the CVRA. In May 30th, 2008 victim letter to Jane Doe 5 also acknowledged the victim's rights under the CVRA. In
Looking. I'm ready. All right, we're back. Let's see where I was exactly. So, consistent with the rule on March 12, 2021, in a sealed ex parte order, the court required defense counsel to provide notice to alleged victims whose personal or confidential information may be disclosed by the proposed subpoena. The court also gave the victims an opportunity to object or request modifications of the subpoena as required by Rule 17c3. You're ready to go back to Steve? Okay, so we are ready to go back to Steve Schmidt. We are live. Gotta love live events. We're doing great.
Steve Schmidt here. Pleasure to be joining in the reading this afternoon on this important issue, which is being swept under the rug and covered up by so much of the corporate media. In mid-June of 2008, Mr. Redacted, the attorney for petitioners, contacted the line prosecutor to inform her that he represented Jane Doe 1 and later Jane Doe 2. Redacted asked to meet to provide information about the federal crimes committed by Epstein against these victims. The line prosecutor and Redacted discussed the possibility of federal charges being filed in the future. Redacted was led to believe federal charges could still be filed, but no mention whatsoever of the existence of the NPA or any other possible resolution to the case. At the end of the call, the line prosecutor asked Redacted to send any information that he wanted considered by the office in determining whether to file federal charges. The line prosecutor did not inform Redacted about the NPA. On June 19, 2008, Redacted sent an email to the line prosecutor requesting to meet and discuss the plans. On June 23, 2008, the line prosecutor sent an email to Lefkowitz stating that the Deputy Attorney General had completed his review of the Epstein matter and determined that federal prosecutors of Mr. Epstein's case was appropriate. Accordingly, Mr. Epstein had until the close of business on Monday, June 30, 2008, to comply with the terms and conditions of the agreement between the United States and Mr. Epstein. On or about 27 June 2008, the office called Redacted to provide notice to his clients regarding the entry of Epstein's guilty plea in state court. According to Redacted, the line prosecutor only told him that Epstein was pleading guilty to state solicitation of prostitution. He was not told that the state plea was related to the federal investigation or that the state plea would resolve the federal crimes. Redacted claims he was not told his clients could address the state court. Redacted. In contrast, the line prosecutor claimed she told Redacted that his clients could address the state court. Redacted. On or before 30 June 2008, the office prepared a draft victim notification to be sent to the victims. The notification was designed to inform the victims of the provisions of the deferral of federal prosecution in favor of state charges. The notification letter began by describing Epstein's guilty plea in the past tense. On 30 June 2008, Jeffrey Epstein entered a plea of guilty to violations of federal statutes forbidding the solicitation of minors to engage in prostitution and felony solicitation of prostitution. Later, a substantively identical letter was prepared for Epstein and his counsel's review. On June 30, 2008, the office sent an email to Epstein's counsel, quote, "The FBI has received several calls regarding the non-prosecution agreement. I do not know whether the title of the document was disclosed when the agreement was filed under seal, but the FBI and our officers are declining comment if asked." That same day, Epstein pled guilty to state law solicitation of prostitution charges. Immediately following the 30 June 2008 hearing, the line prosecutor told one of the victim's attorneys that Epstein had pled guilty today in state court. Also after the plea, the line prosecutor emailed the assistant state attorney a copy of the NPA to be filed under seal. July 1st, 2008, email DE 362-38. On June 30, 2008, based on what had been told by the government, Jane Doe, 1, thought that the office was still investigating and pursuing her case. She did not receive notice that Epstein's state guilty plea affected her rights in any way. She had been told that the state plea had connections to blocking the prosecution of her case. She would have attended and tried to object to the judge to prevent the plea from going forward. According to line prosecutor, Redacted, did not tell her that Jane Doe number 1 wanted to meet with her before a resolution was reached. Redacted. On July 3rd, 2008, as specifically directed by the office, Redacted sent a letter to the office communicating the wishes of Jane Doe number 1, Jane Doe number 2, and Jane Doe 5 that federal charges be filed against Epstein. We urge the Attorney General and our United States Attorney to consider the fundamental import of the vigorous enforcement of our federal laws. We urge you to move forward with the traditional indictments and criminal prosecution commensurate with the crimes Mr. Epstein has committed. And we further urge you to take steps necessary to protect our children from this very dangerous sexual predator. On 7 July 2008, the line prosecutor corresponded with Epstein's counsel seeking his signed agreement concerning a notification letter to the victims before beginning the distribution of some of the civil compensation provisions of his NPA. The notification did not provide the full terms of the NPA. On 10 July 2008, Epstein's counsel continued to protest victim notification as evidenced by an email to the line prosecutor stating, quote, "We respectfully request a reasonable opportunity to review and comment on a draft of the modified notification letter you intend to mail before you send it." On 10 August 2008, Jane Doe 1 and Jane Doe 2 filed a motion seeking release of the NPA. On 14 August 2008, the line prosecutor emailed Epstein's counsel stating the court has ordered us to make the agreement available to the plaintiffs. On 18 August 2008, Lefkowitz wrote the line prosecutor that Epstein objected to disclosure of the terms of the NPA, but that Epstein would cooperate with the government to reach an agreement as to the substance of the notification to be sent to the government's list of individuals. Based on the agreement, the information contained in the notification should be limited to one, the language provided in the agreement dealing with civil restitution, paragraphs 7 and 10, and two, the contact information of the selected attorney representative. We object to the inclusion of additional information about the investigation of Mr. Epstein, the terms of the agreement, other than paragraphs 7 to 10, and the identity of other identified individuals. On 21 August 2008, the government sent a letter to Epstein's counsel stating that copies of the victim notifications will continue to be provided to counsel for Mr. Epstein, end quote. Jane 2, number 2, was not informed of the contents of the NPA until 28 August 2008, when the line prosecutors provided a copy to Redacted. On September 2nd, 2008, the line prosecutor sent an email to Epstein's counsel stating, I will start sending out the victim notifications today. In accordance with your request, I've changed the language regarding the victim's right to receive a copy of the agreement. On September 2nd and 3rd, 2008, the office sent Jane Doe 1 and other identified victims amended notification letter stating, quote, the United States has agreed to defer federal prosecution in favor of this state plea and sentence, end quote. On September 16, 2008, attorney Redacted, who represented several Epstein victims, wrote to the line prosecutor to object to the restitution procedures established in the NPA after learning that another attorney established through the NPA would be making unsolicited contacts to the victims. Mr. Redacted explained that the letters were misleading because they referred generally to a waiver of, quote, any other claims for damages, quote, without informing them that this waiver might include a valuable punitive damage claim against an alleged billionaire. On September 17, 2008, the line prosecutor sent an email to state attorney Redacted, Kirchner, explaining that the NPA contained confidentiality provisions that required us to inform Mr. Epstein's counsel before making any disclosure. Around this same time period, Jane Doe 1 and Jane Doe 2 filed actions in Palm Beach County seeking money damages from Epstein from sexually abusing them. Eventually, they received monetary settlements of their lawsuits. In moving for monetary judgment, petitioners make the following arguments in support of their contention the government violated their CVRA rights. The government violated petitioners' rights and confirmed under the CVRA 1. When the government was negotiating and signing the NPA, when the government sent letters telling petitioners to be patient while the government completed its investigation, and 3, when the government did not tell the victims that the state plea would extinguish the federal case. Petitioners also claimed the government violated the rights to be treated with fairness under the CVRA by concealing the negotiations of the NPA. Additionally, petitioners contend the government violated their rights to reasonable and accurate notice when it concealed that the NPA and the federal investigation were implicated in the state court proceeding. In moving forward responding to summary judgment, the government contends that there is no right to notice or conferral about an NPA. It was reasonable for the government to send letters to victims while continuing to investigate the case because the government could not assume that Epstein would plead guilty, and the line prosecutor contacted petitioner's attorney about the state court plea hearing. The government also claims it did not violate the right to reasonable, accurate, and timely notice because the CVRA did not create any right of notice to state court proceedings, and in any event, the government gave notice. The government asserts it did not treat the victims unfairly and used its best efforts to comply with the CVRA, including complying with the Attorney General's guidelines for victim assistance. Furthermore, the document argues the petitioners are equitably stopped from challenging the NPA because they relied upon the NPA in their state court civil actions against Epstein. Lastly, the government contends that petitioners are judicially estopped from challenging the validity of the NPA because they have asserted mutually inconsistent positions, namely that the NPA is invalid in federal court but was binding on Epstein in state court. 2. Summary judgment standard. The court may grant summary judgment, quote, if the movement shows that there is no genuine dispute as to any material fact and the movement is entitled to judgment as a matter of law, end quote. The stringent burden of establishing the absence of a genuine issue of material fact lies with the moving party. Celotax Corp. Versus Contretti, 47 S 317 323, 1986. The court should not grant summary judgment unless it is clear that a trial is unnecessary. Anderson versus Liberty Lobby, Inc., 477 U.S. 242, 255, 980, 1986. And any doubts in this regard should be resolved against the moving party. Atticus versus S.H. Kress and Company, 398 U.S. 147, 157, 1970. The movement bears the initial responsibility of informing the district court of the basis for the motion and identifying those portions of the record which it believes demonstrate the absence of genuine issue material fact. Celotax Corp. 477 U.S. at 323. To discharge this burden, the movement must point out to the court that there is an absence of evidence to support the non-moving party's case. After the movement has met its burden under Rule 56, the burden of production shifts, and the non-moving party must do more than simply show that there is some metaphysical doubt as to the material facts. Matsushita Electronics Industrial Company versus Zenith Radio Corp. 475 U.S. 574 386, 1986. A party asserting that a fact cannot be or is genuinely disputed must support the assertion by citing to particular parts of materials in the record or showing that materials cited do not establish the absence or presence of a genuine dispute, or that an adverse party cannot produce admissible evidence to support the fact. Essentially, so long as the non-moving party has an ample opportunity to conduct discovery, it must come forward with affirmative evidence to support its claim. Anderson, U.S. at 257. Quote, a mere scintilla of evidence supporting the opposing party's position will not suffice. There must be enough of a showing that the jury could reasonably find for that party. Walker v. Darby. If the evidence advanced by the non-moving party is merely colorable or is not significantly probative, then summary judgment may be granted. 3. Discussion. The CVRA was designed to protect victims' rights and ensure their involvement in the criminal justice process. The CVRA was enacted to make crime victims full participants in the criminal justice system. The statute enumerated the following 10 rights. The right to be reasonably protected from the accused. 2. The right to reasonable, accurate, and timely notice of any public court proceedings or any parole proceeding according to the crime, or of any release or escape of the accused. Number 3, the right not to be excluded from any such public court proceeding unless the court, after receiving clear and convincing evidence, determines that testimony by the victim would be materially altered if the victim heard other testimony at that proceeding. 4, the right to be reasonably heard in any public proceeding in the district court involving the release, plea, sentencing, or any parole proceeding. 5, the reasonable right to confer with the attorney for the government in the case. 6, the right to fully and timely restitution as provided in the law. 7, the right to proceedings free from unreasonable delay. 8, the right to be treated with fairness and with respect for the victim's dignity and privacy. 9, the right to be informed in a timely manner of any plea bargain or deferred prosecution agreement. 10, the right to be informed of the rights under this section and the services described in Section 5013C of the Victims' Right and Restitution Act of 1990, 42 U.S.C. 10607C, and provided contact information for the Office of the Victims' Rights Ombudsman of the Department of Justice, 18 U.S.C. 377(1) parenthesis A and parenthesis. This court previously held the following with respect to the Crime Victims' Rights Act. First, the rights under the Crime Victims' Rights Act attached before the government brings formal charges against a defendant. Does v. United States 181S 8. Second, the Crime Victims' Rights Act authorizes the rescission of reopening of a prosecutorial agreement, including a non-prosecution agreement, reached in violation of a prosecutor's conferral obligations under the statute. Doe v. United States. Third, Section 3771, parenthesis D, Section 5 of the CVRA authorizes the setting aside of pre-charge prosecutorial agreements, despite the fact that the particular statutory enforcement provision expressly refers to the reopening of a plea or sentence. Fourth, the reasonable right to confer in the case extends to the pre-charge stage of criminal investigations and proceedings. Fifth, the federal sex offense crimes involving minors allegedly committed by Epstein renders these petitioners crime victims under the CVRA. Sixth, questions pertaining to the equitable defense are properly left for a resolution after development of a full evidentiary record. Here it is undisputed that the government entered into an NPA with Epstein without conferring with petitioners during its negotiating and signing. Instead, the government sent letters to the victims requesting their patience with the investigation even after the government entered into the NPA. At a bare minimum, the CVRA requires the government to inform petitioners that it intended to enter into an agreement not to prosecute Epstein. Although the binding effect of the NPA was contingent upon Epstein pleading guilty to state charges, that contingency was out of control of the government. The government's hands were permanently tied if Epstein fulfilled his obligations under the NPA. Thus, petitioners and the other victims should have been notified of the government's intentions to take that course of action before it bound itself under the NPA. Had the petitioners been informed about the government's intention to forego federal prosecution of Epstein in deference to him pleading guilty to state charges, petitioners could have conferred with the attorney for the government and provided input. And thank you, Eliza. And back to you.
Hey, everybody. It's Katie Fang here from Katie Fang News. As many of you know, I had the privilege of being able to be at the Trump Epstein reading room before it was open to the public. I was able to be there to look at these volumes, to spend time with David Garrett and the other incredible people who wanted to bring the reading room to you, the American public. I also had the privilege of being able to spend time with the very first Epstein victim survivor, Danny Bensky. to come to the reading room where we are having this filibuster take place today. And so it was equally as important for me to be able to spend this time with you as we do this 24-hour filibuster reading the Epstein files. I invite you to continue to listen. At this time, I'm going to be sharing with you some pages, an excerpt from the government of the the Virgin Islands. They brought a lawsuit against the estate of Jeffrey Epstein, as well as the 1953 trust, which just 2 days before Epstein's alleged suicide, he actually revisited his last will and testament and transferred all of his property into this trust. And so it's not only the estate, but the trust that were sued. This lawsuit was ultimately settled for $105 million plus half of the proceeds from the sale of Epstein's Little St. James Island. And there was also $80 million in improperly obtained economic development benefits that were clawed back from the estate of Jeffrey Epstein to be able to go into a fund to help victims and survivors of Jeffrey Epstein. But I want you to listen carefully to what I'm about to read to you from this lawsuit, because it clearly sets forth some of the schemes, the fraud, and the frankly criminal activity that was being perpetrated by Jeffrey Epstein and others in his orbit to help facilitate his sex trafficking ring. It begins with the beginning of the page that we're kind of like mid-paragraph from the paragraph before, from the page before, and it says, construction at Great St. James after 2016 to continue the scheme to carry out and conceal his trafficking and sexual abuse of young women and children in the Virgin Islands. These actions are also indicative of the Epstein enterprise's disregard for Virgin Islands law. The Epstein enterprise used the Virgin Islands' land, resources, people, and laws for its illicit purposes. Rather than participating lawfully in this community, the Epstein enterprise took advantage of the secluded nature of the islands in furtherance of its crimes. I'm just going to briefly interrupt and say that this is also very similar to what we know about Epstein's Zoar Ranch, that 10,000-acre ranch in Santa Fe, New Mexico, in terms of its kind of secluded nature, its isolation. Moving on. As a result of its deplorable and unlawful conduct, the Epstein enterprise has subjected the Virgin Islands to public portrayals as a hiding place for human trafficking and sex crimes. Subsection C. The Epstein enterprise fraudulently concealed its conduct. The Epstein enterprise fraudulently concealed its actions to prevent detection by the government of the Virgin Islands. This is paragraph 74. The secluded properties at Little St. James and Great St. James were repeatedly used by the Epstein enterprise as the locations for unlawfully soliciting, transporting, transferring, harboring, receiving, providing, isolating, patronizing, maintaining, deceiving, coercing, and sexually abusing young women and children, and concealing these crimes. The Epstein enterprise was able to hide the trafficking ring from law enforcement, despite the fact that Epstein was a registered sex offender. Given the isolation of the Little St. James and Great St. James and the nature of the crimes and of the victims targeted by the Epstein enterprise, the activities of the Epstein enterprise were not readily detectable. Moreover, Epstein's great wealth and power likely made witnesses reluctant to report their observations to the local law enforcement. This is now paragraph 76. Upon information and belief, the Epstein enterprise prevented its employees from cooperating with law enforcement. Employees and others were required to sign confidentiality agreements that prohibited them from speaking to or sharing information with law enforcement. If they were contacted by law enforcement, they were to notify the Epstein enterprise and be represented by Epstein's counsel. Paragraph 77. The employees were directed not to communicate or interact with guests visiting Little St. James, and were also directed not to disclose to anyone events that occurred on the island. Monitoring a sex offender with his own private islands and the resources to fly victims in and out on private planes and helicopters presented unique challenges and allowed the Epstein enterprise to limit scrutiny by the government of the Virgin Islands. I'm going to interject here as well. That does also sound familiar. That same MO that we hear right now was one that we were hearing when it came to Zorro Ranch as well, with the private airstrip and the ability to fly in and out without FAA observation. Paragraph 79. Sexual Offender Registration and Community Protection Act requires sex offenders to register in their resident jurisdictions and to make periodic in-person appearances to verify and update their registration information. Paragraph 80. Epstein renewed his registration each year in the Virgin Islands. In addition, beyond this statutory requirement, the Virgin Islands periodically visited or attempted to visit Little St. James to conduct additional address verifications. Paragraph 81. At his last verification in July 2018, Epstein refused to permit Virgin Islands Department of Justice investigators, assisted by United States Marshals, to enter Little St. James beyond its dock, claiming that the dock was his, quote, front door, end quote. Instead, Epstein arranged to be met at his office on St. Thomas. Paragraph 82. Epstein also misled the government regarding his travel plans. On March 19, 2019, the Virgin Islands was notified that Epstein would be traveling to France for 10 days on the private plane owned by Plan D LLC. His notification form did not disclose travel to any other countries. It was later found by law enforcement authorities that Epstein also traveled to Vienna and Monaco during that trip. Paragraph 83. Similarly, the Epstein enterprise sought to prevent DPNR from conducting routine site visits, permitted and potentially damaging construction activity on Great St. James. The Epstein enterprise repeatedly objected to DPNR's inspections, referring to them as, quote, invasions, end quote, of Epstein's constitutional right to privacy in his home, which he described and defined as the entire island. These DPNR inspections are required for all construction, and Virgin Islands residents are required to cooperate with the inspections to assure compliance with the law throughout the construction phases. Paragraph 84. These efforts represent Epstein Enterprise's intent to conceal its unlawful activity on Little St. James and Great St. James. 85. The Epstein enterprise also created numerous corporations and limited liability companies in the Virgin Islands to help conceal its unlawful activity. Most of these companies were created in 2011 and 2012, soon after Epstein registered as a sex offender in the Virgin Islands. Paragraph 86. Epstein's pilot, Larry Vysotsky, is identified as a member or co-member in companies that service and maintained the planes that the Epstein enterprise used to traffic young women and children. Freedom Air Petroleum, LLC, registered November 28, 2011, to hold assets. And JEGE, LLC, registered October 19, 2012, to hold assets. Paragraph 87. Other Epstein entities include LSJ Employees LLC, registered October 27, 2011, to provide services. Southern Financial LLC, registered February 25, 2013, to provide services. And LSJ Emergency LLC, registered December 2, 2015, to provide services. Paragraph 88. Some of these companies held considerable assets. Financial Informations, Inc., incorporated November 18, 2011, also known as Southern Trust Company, Inc., had assets of approximately $391 million in 2015. And Financial Trust Company, Inc., incorporated November 6, 1998, had assets of $212 million when it publicly filed its last balance sheet in 2012. Paragraph 89. Although often absent in the original incorporation or registration documents or annual filings, Epstein ultimately appeared as president, director, manager, or sole member of each of these companies. Upon information and belief, the of corporate entities, some of which may still be discovered, was to allow Epstein to shelter his assets in order to fund, carry out, and conceal his identity and pattern of criminal conduct. Paragraph 90. The estate continues to engage in a course of conduct aimed at concealing the criminal activities of the Epstein enterprise. Please note, if I may, that this lawsuit was filed back in 2015. 2020 was an amended complaint on this lawsuit. And so this is present tense language in the lawsuit back then, back in 2020. On November 24th, 2019, Epstein's estate filed an expedited motion for establishment of a voluntary claims resolution program in the Superior Court of the Virgin Islands. According to the motion, the proposed program was to be designed to establish an independent and voluntary claims resolution program for purposes of resolving sexual abuse claims against Jeffrey E. Epstein. Motion, at 1. Paragraph 91. The program proposed by the state, whose executors are trustees of the 1953 trust and officers in at least 2 Epstein entities, imposes confidentiality requirements and requires any claimant accepting an award under the program to sacrifice any other claims against any person or entity arising from or related to Mr. Epstein's conduct. Motion, at 5. It acts to conceal the criminal activities of the Epstein enterprise and shield its participants from liability and accountability for the injury they caused to the victims. Paragraph 92. 2 days before his death, Epstein amended the trust in his last will and testament. Upon information and belief, he did so as a part of a pattern and ongoing effort to conceal and shield his assets from potential recovery by claimants. Subsection D. The Epstein enterprise violated numerous Virgin Islands laws. Paragraph 93. The pattern of criminal activity engaged in by Epstein and other participants in the Epstein enterprise violated 14 VIC sections 605 and 607 of the Criminally Influenced and Corrupt Organizations Act, CICO. Paragraph 94. The Epstein enterprise also violated Title 14, Chapter 3A, the Virgin Islands Uniform Prevention of and Remedies for Human Trafficking Act, relating to trafficking of persons. Title 14, Chapter 24, relating to child protection and child abuse and neglect. Title 14, Chapter 81, relating to prostitution and related offenses. Title 18, Chapter 85, relating to rape and sexual assault and other related offenses, as well as other Virgin Islands laws. Paragraph 95. The Epstein enterprise violated Virgin Islands laws by engaging in the human trafficking of underage girls and young women and commercial sex with young women and underage girls by force, fraud, entitlement, or coercion, which serve as predicates to the Epstein enterprise's violations of CICO, which, as you guys can imagine, is basically like RICO. It's the Virgin Islands version of RICO, the Racketeering Act. Paragraph 96. Certain participants who recruited women and underage girls to be trafficked and forced into sexual servitude themselves were sexually trafficked and abused by the Epstein enterprise and may be afforded the protections of 14 VIC Section 145. Paragraph 97. Specifically, Plan D LLC knowingly and intentionally facilitated the trafficking scheme by flying underage girls and young women into the Virgin Islands to be delivered into sexual servitude. Plan D LLC repeatedly made flights from the mainland to St. Thomas with Epstein and underage girls and young women for the purpose of engaging in sexual activity on Little St. James. On some occasions, they would transport Epstein and female children by helicopter to Little St. James. On other occasions, Epstein and the young women and girls would be transported by boat. Paragraph 98. Great St. Jim LLC and Nautilus Inc. knowingly participated in the Epstein enterprise and facilitated the trafficking and sexual servitude of young women and underage girls by providing the secluded properties at, from, or to which Epstein and his associates were able to transport, transfer, receive, maintain, isolate, harbor, provide, entice, deceive, coerce, and sexually abuse underage girls and young women. Paragraph 99. The Epstein enterprise engaged in a continuing course of unlawful conduct. Paragraph 100. After Epstein's suicide, the Epstein enterprise continued to exist as each of the participants continued to conspire to prevent detection of the breadth and scope of the Epstein enterprise's criminal wrongdoing and to prevent accountability. These conspiratorial acts are ongoing. Paragraph 101. The conduct of the Epstein enterprise offends the core purpose of the Virgin Islands Uniform Prevention of and Remedies for Human Trafficking Act, 14 VIC Section 131 et sequitur, and violates CICO, enacted to, quote, curtail, criminal activity and lessen its economic and political power in the territory of the Virgin Islands by establishing new penal prohibitions and providing to law enforcement and the victims of criminal activity new civil sanctions and remedies, end quote. 14 VIC Section 601. Paragraph 102. The Epstein enterprise is an illicit enterprise within the meaning of 14 VIC Sections 604 and 605. Paragraph 103. The government is entitled to recover civil penalties, damages, and other remedies, and to extinguish and recoup from the Epstein enterprise any and all financial and other benefits, and any personal and real property that was used during the course of or intended for use in the course of the conduct or criminal activity in violation of the laws of the Virgin Islands. The government is entitled to obtain through divestiture, forfeiture, or other equitable relief all properties and instrumentalities used by the Epstein enterprise in the criminal pattern of trafficking and sexual abuse in the Virgin Islands, including but not limited to Great St. James and Little St. James, and all other remedies and penalties permitted by law in the interest of justice. Subsection E, the Epstein enterprise used corporate entities to defraud the government and fund its criminal activities. Paragraph 104. In October 2012, the Southern Trust Company applied for economic benefits from the Economic Development Commission, EDC. The EDC is a subsidiary of the Virgin Islands Economic Development Authority, the EDA, a semi-autonomous governmental instrumentality created and governed pursuant to 29 VIC Section 1101. Paragraph 105. In sworn testimony at a public hearing on the tax incentive application conducted by the EDC on November 15, 2012, Epstein and his attorney Erica Kellerhals described Southern Trust Company as providing, quote, cutting-edge consulting services, end quote, in the area of, quote, biomedical and financial informatics, end quote. Paragraph 106. The EDC granted Southern Trust Company a 10-year package of economic incentives running from February 1st, 2013 until January 31st, 2023 that included a 90% exemption from income taxes and 100% exemptions from gross receipts, excise, and withholding taxes in the Virgin Islands. Paragraph 107. Between 2013 and 2019, Southern Trust Company employed 13 different individuals, not including Epstein. Of those 13 individuals, 11 served in administrative or support roles, 6 as personal administrative or executive assistants, receptionists, or as a driver helper, 1 as an office manager, 1 as a clerk, and 3 in accounting and or payroll functions, parentheses, though only 1 was licensed as a certified public accountant, end parens. There was 1 network administrator / IT manager and a second who was added in 2019. Paragraph 108. In fact, several of those individuals seemed to perform other personal services for Jeffrey Epstein. Though he was reported by Southern Trust Company to be resident of the Virgin Islands, the network administrator IT manager was issued a Florida driver's license, which listed an address in Miami. Further, he appears in fact to have served as Epstein's driver and picked up luggage and cargo from Epstein's private planes on his behalf. Paragraph 109. Another executive assistant lived at, and then we have a series of redactions that are presumptively a physical address in New York, New York. Epstein's address book lists various units in this building as providing, quote, apartment for models, end quote. And she is publicly identified as a model. As noted above, the Epstein enterprise used modeling opportunities and contracts as a pretext for recruiting underage girls and young women into its sex trafficking scheme. Paragraph 110. During several time periods, Southern Trust Company affirmed to EDC that it had no employees who were non-residents, even though it employed non-residents. Paragraph 111. Despite having only 1 full-time employee working on information technology during the bulk of this period, Southern Trust Company reportedly generated net income of $50.3 million in 2013, $67.5 million in 2014, 52.8 million in 2015, and 4.8 million in 2016, and 17.1 million in 2017, with aggregate income of 117.8 million in 2014, 170.6 million in 2015, 175.3 million in 2016, and 192.4 million in 2017, or aggregate income for the period of $656 million. Paragraph 112. For the period between January 1st, 2013 and December 31st, 2017, Southern Trust Company received tax exemptions totaling $73.6 million. Paragraph 113. As of December 31st, 2017, Southern Trust Company, Inc. elected to file its income tax as an S corporation, which elects to pass corporate income, losses, deductions, and credits through to its sole shareholder, Jeffrey Epstein, for tax purposes. For this time period, Epstein's income tax exemption was $71.3 million. Paragraph 114. Based upon these facts, it is clear that Southern Trust Company did not perform the, quote, informatics, end quote, business represented to the EDC and could not have generated the business income attributable to that business. Instead, upon information and belief, Southern Trust Company existed to secure tax benefits for Epstein, to employ individuals associated with the Epstein enterprise, and to provide a source of income to support his criminal activities and properties in the Virgin Islands. And then the lawsuit moves on to count 1, human trafficking, trafficking an individual, violation of the Criminally Influenced and Corrupt Organizations Act, CICO, 14 VIC, Section 600 et sec, and 14 VIC Section 133. Paragraph 115. The government restates and realleges paragraphs 1 to 115 of this complaint as if fully set forth herein. And there's a couple more paragraphs I'm going to read to complete count 1 before I hand it over. Paragraph 116, at all times material herein, each defendant directly and indirectly participated in or associated with the Epstein enterprise, an illicit enterprise. Paragraph 117, the Epstein enterprise engaged in 2 or more occasions of conduct that constitute criminal predicate acts as defined by CICO, including but not limited to knowingly recruiting, transporting, transferring, harboring, receiving, providing, obtaining, isolating, maintaining, or enticing female children and young women in the furtherance and performance of forced labor, sexual servitude, and commercial sexual activity in violation of Virgin Islands laws codified in 14 VIC sections 133 to 138. Paragraph 118, defendants through a pattern of criminal activity acquired and maintained directly or indirectly an interest in or control of the Epstein enterprise or real property. Paragraph 119, defendants benefited directly and indirectly from the pattern of criminal activity conducted by the Epstein enterprise. And paragraph 120, at all times material herein, the defendants engaged in said pattern of criminal activity that was not isolated but was related to the affairs of the Epstein enterprise in violation of CICO 14 VIC section 600 et sequitur. And I will hand it over now to our next reader. Thank you all.
Thank you so much, Katie, for reading for us. We are now in our 3rd hour of our 24-hour stream, Cover to Cover Up, a public reading of the Epstein files from the Donald J. Trump and Jeffrey Epstein Reading Room in Lower Manhattan. I'm here with the Save America movement. I'm Eliza Orlins, and while we read, we are raising money for World Without Exploitation, and you can scan the QR code on your screen to give to this group doing such important work. I am now joined by Academy Award nominated filmmaker Julie Cohen. Julie, thank you so much for joining us here today. If you wouldn't mind introducing yourself and, saying a little bit about what brought you here, and then I'll let you take it away. Thank you.
Absolutely. I'm really honored to be here today. I'm Julie Cohen. I'm a documentary filmmaker. I've directed or co-directed films like RBG, Everybody, and my name is Polly Murray. I'm here today because even if the people in power in our country don't think that sexual assault survivors need and deserve justice, a lot of Americans do, and I'm one of those Americans. I am picking up at the start of page 154. Please see the attached letter, which was filed this evening. Are you available for a call on Monday? We anticipate that this issue will be addressed at our final pre-trial conference at 11 a.m. on Monday. Thanks, and the name is redacted. The next email, courtesy copy of today's ECF filing. Please note my new office address and preferred email address. It's from an attorney. I'll go ahead and read the address for those trying to watch this for information. Bobby C. Sternheim, Esquire, Law Offices of Bobby C. Sternheim, 225 Broadway, Suite 715, New York, New York, 1007. Next, the from and to are redacted. These are some examples of the information that was released, and it is a link to a Miami Herald article and a CNN article. Next, again, it's redacted who it's from and to. Not sure who's being protected here. Subject, Epstein, release of USMS information. Can you forward me the more problematic articles? And the response to that, again, with redactions. As you are undoubtedly aware, there has been some press coverage since yesterday about the release pursuant to the Freedom of Information Act of some USMS records. I just spoke with the Associate General Counsel of the USMS, who wanted me to provide us with the actual source materials, USMS 11S, equivalent of 302S, that were inadvertently released because they were not in all circumstances accurately reported. And he wanted to make sure that if we are concerned about any harm to our investigation from the release, that we have the original materials. He also offered to serve as the POC, point of contact, if we have any questions. The name is redacted, Chief of Criminal Division of the United States Attorney's Office, Southern District of New York. The next email, who it's from and to, are redacted. Subject, travel approval request, Friday, 24th of May, 2019. All approved. Response to that, again, in connection with the Epstein investigation, we'd like to please request permission to travel for approximately 3 days next week for meetings and interviews in West Palm Beach, Florida. As of now, we tentatively expect to fly down Tuesday night and return on Wednesday or Thursday, and will keep the time frame as short as scheduling allows. Unfortunately, we're still trying to pin down timing for interviewing the victims, so depending on the timing, it will either be me and blank or redacted and redacted. But we wanted to ask for permission now either way, so we weren't doing it super last minute after the holiday on Tuesday. And also, same as last time, we'd like to ask permission to reserve a conference room at the hotel for the interviews, please. Thanks very much. Signed, redacted. That gets a response of thank you, and the next response, approved. On April 23rd, 2019 at 8:02 p.m. For the same cases below, United States versus Epstein, 2018 RO 1618, an investigation relating to the enticement of minors for sexual activity, Redacted and I would like to please request permission to travel for approximately 3 days next week for meetings and interviews in West Palm Beach, Florida. As of now, we tentatively expect to fly down Tuesday night and return on Friday, though we will shorten the time frame if scheduling allows. Please let us know if any information would be helpful, and thanks very much. Signed, Redacted. A response to that comes to and from Redacted. Redacted and I would like to please request permission for traveling for United States versus Epstein, an investigation relating to enticement of minors for sexual activity, for 2 days of meetings and interviews in West Palm Beach and/or Fort Lauderdale, Florida.
So hopefully he's not going
As of now, we're hoping to fly down next Wednesday night and return on Saturday. Please let us know if any other information would be helpful. Thanks as often. Redacted, Assistant U.S. Attorney, Southern District of New York. The next email comes to the New York Southern District Chambers. Good evening. Attached, please find the government's opposition to the defense's motion in limine in the above captioned case. Pursuant to the court's order, the government will file a redacted version on the public docket on Friday, October 29th. Respectfully submitted, Redacted, Assistant United States Attorney for the Southern District of New York. Included next is a manuscript that actually looks sort of like some kind of academic report. The title of it is Facilitators and Barriers to Child Sexual Abuse Disclosures, a Research Update, and it's covering the periods 2000 to 2016. Abstract. Identifying and understanding factors that promote or inhibit child sexual abuse disclosures has the potential to facilitate earlier disclosures, assist survivors to receive services without delay, and prevent further sexual victimization. Timely access to therapeutic services can mitigate risk to the mental health of survivors of all ages. This review of the research focuses on CSA disclosures with children, child sexual abuse disclosures with children, youth, and adults across the course of life. Using Keightley and Stogden's literature review framework, 33 studies since 2000 were identified and analyzed to extrapolate the most convincing findings to be considered for practice and future research. The centering question asked, what is the state of child sexual abuse disclosure research, and what can be learned to apply to practice and future research? Using Braun and Clark's guidelines for thematic analysis, 5 themes emerged. 1. Disclosure is an iterative, interactive process rather than a discrete event, best done within a relational context. 2. Contemporary disclosure models reflect a social, ecological, person and environment orientation for understanding the complex interplay of individual, familial, contextual, and cultural factors involved in child sexual abuse disclosure. 3. Age and gender significantly influence disclosure. 4. There is a lack of life course perspective. And 5. Barriers to disclosure continue to outweigh facilitators. Although solid strides have been made in understanding child sexual abuse disclosures, the current state of knowledge does not fully capture a cohesive picture of disclosure processes and pathways over the life course. More research is needed on environmental, contextual, and cultural factors, closure processes, and pathways over the life course. More barriers continue to be identified more frequently than facilitators, although dialogue forums are emerging as important facilitators of child sexual abuse disclosure. Implications for practice in facilitating CSA disclosures are discussed with recommendations for future research. All right, and now here's that full report. Introduction. Timely access to supportive and therapeutic resources for child sexual abuse survivors can mitigate risk to health and mental health, well-being of children, youth, and adults. CSA disclosures have the potential to facilitate earlier disclosures, assist survivors to receive services without delay, and potentially prevent further sexual victimization. Increased knowledge on both the factors and the processes involved in CSA disclosures is timely when research continues to show high rates of of delayed disclosures. Incident studies in the United States and Canada report decreasing child sexual abuse rates, while at the same time global trends from systematic reviews and meta-analyses have found concerning rates of CSA, with averages of 18 to 20% of females and 8 to 10% of males. The highest rates found for girls in Australia, 21.5%, and for boys in Africa, 19.3%, with the lowest rate for girls, 11.3%, and boys, 4.1%, reported in Asia. These findings point to the incongruence between the low number of official reports of CSA to authorities and the high rates reported in prevalence studies. For example, a meta-analysis conducted by Stoltenberg, Van Zendorn, Usser, Bakerman-Cronenberg et al., combining estimations of CSA in 217 studies published between 1980 and 2008, revealed the rates of CSA to be more than 30 times greater in studies relying on self-reports than in official report inquiries, such as those based on data from Child Protection Services and from the police. That's 4 in 1,000. In other words, while 1 out of 8 people retrospectively report having experienced CSA, official incidence estimates indicate only 1 per 250 children. In a survey of Swiss Child Services, Meyer, Moeller, Quo, et al. Further found 2.68 cases per 1,000 of CSA disclosures, while in a recent prevalence of delayed, partial, and non-disclosures in children indicating a persistent trend toward withholding CSA disclosure. It is our view that incidence statistics are likely an underestimation of CSA disclosures, and this drives the rationale for the current review. Given the persistence of delayed disclosures, with research showing a large number of survivors only disclosing in adulthood, these issues should be a concern for practitioners, policymakers, and the general public. The longer disclosures are delayed, the longer individuals potentially live with serious negative effects to their health and mental health, such as depression, anxiety, trauma disorders, and addictions without receiving necessary treatment. This also increases the likelihood of more victims falling prey to undetected offenders. Learning more about CSA disclosure factors and processes to help advance our knowledge base may help professionals to facilitate earlier disclosures. Previous literature reviews examining factors influencing CSA disclosure have served the field well, but are no longer current. Important contributions on CSA disclosures include Payne and Hansen's original review covering the literature largely from the pre-millennium era, followed by London, Bruck, Ceci, and Schumann's 2005 subsequent review, which may not have captured publications affected by lag to print delays so common in peer-reviewed journals. These reviews are now dated and therefore do not take into account the plethora of research that has been accumulated over the past 15 years. Other recent reviews exist, but with distinct contributions to the dialogical relational processes of disclosure, CSA disclosures in adulthood, and delayed disclosures in childhood. This literature review differs by focusing on CSA disclosures in children, youth, and adults from childhood into adulthood over the life course. Method. Kitely and Stogden's systematic review framework was utilized to establish what has been investigated in CSA disclosure research through various mixed methods to highlight the most convincing findings that should be considered for future research, practice, and program planning. This review centered on the question, what is the state of CSA disclosure? Research and what can be learned to apply to future research and practice. By way of clarification, the term systematic refers to a methodologically sound strategy for researching literature on studies for knowledge construction, in this case the CSA disclosure literature, rather than intervention studies. The years spanned for searching the literature were 2000 to 2016, building on previous reviews without a great deal of overlap. Retrieval of relevant research was done by searching international electronic databases, PsycInfo, PsycArticles, Educational Resources Information Center, Canadian Research Index, International Bibliography of the Social Sciences, published international literature on traumatic stress, sociological abstracts, social service abstracts, and applied science index and abstracts. This review searched peer-reviewed studies. A search for the gray literature was beyond the scope of this review because unpublished studies are not subjected to a peer-reviewed process. Keyword search terms used were child sexual abuse, childhood sexual abuse, disclosure, and telling. Thanks very much. I'll leave it here in the middle of this study.
Thank you so much, Julie. I am now joined by a survivor. We have Natasha Stoynoff, who bravely stepped forward in 2016 to accuse Donald Trump of sexual assault. Natasha, we are truly honored to have you with us here today. Thank you.
Hi, my name is Natasha Stoynoff. I'm a journalist and author, and one of the many women who came forward in 2016 about Donald Trump's sexual misconduct and assaults. I was at the Donald J. Trump and Jeffrey Epstein Memorial Reading Room over the weekend, and as soon as I walked in, I became very emotional. It will make an incredible impact on anybody who sees it. I'm going to read 9 pages from one of the volumes. And I've only read this once before, and I tell you, it is horrifying, as all the other pages are. This is from volume 31E, New York 302-7571, serial 216. The date of entry is 08/09/219. The first 2 pages are heavily redacted. Blank, 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 protect source hereinafter. Blank. Date of birth, all redacted. Was interviewed at the law office of her attorney, blank. Office telephone number in the presence of Mr. Blank. Blank was born in Binghamton, New York. Now the rest of the page is mostly redacted. She moved to South Carolina with her mother and brothers during approximately her last year of elementary school. Blank remained on blank until she was approximately 16 years old. She recalled she possibly started 11th grade there prior to moving to South Carolina with her mother and brother. Now I'm on to the next page, which is mostly redacted. Blank advised that until recently, Blank was the only individual alive to whom Blank confided incidents of abuse she endured when she was a child, detailed herein. Blank's mother also knew about what happened to Blank. But her mother is deceased now. Blank never would have written down what happened to her. She did not keep a formal diary, and she did not make any recordings of any kind regarding the incidents. Blank advised she met Jeffrey Epstein when she lived on blank. The rest of the page is redacted. And now here comes the story. At one point, when Blank was approximately 13 years old, her mother asked Blank whether she would like to start babysitting. Her mother was so excited about the prospect and thought Blank would be a great babysitter. When Blank agreed, her mother put an advertisement for Blank babysitting service in the package she provided to renters and owners. Soon after the ad went out in the packets, Blank's mother received a telephone call from a man who indicated he and his wife needed a babysitter for the child for the night. Blank could not recall how she traveled to the man's residence. However, she remembered thinking she hoped it would be a quick babysitting job so she could go back to enjoying the rest of her day. The house where Blank met Jeff was a villa condo in the Sea Pines plantation area. She was unaware of whether he owned it or rented it. However, he probably rented it through her mother for an unknown period of time. The residence had a lot of books in it, and specifically, there was one room similar to a library that included a large number of books. Blank recalled knocking on the front door, and the man she came to know as Jeff answered the door. Jeff appeared to be alone in the home. Blank specifically recalled wondering where his wife and child were. She never saw them. Jeff offered Blank cocaine, an alcoholic drink, and weed that day. Blank recalled that while she had tried each previously, cocaine once before and alcohol and marijuana more than once previously, she had never before used all three at the same time. After accepting the drugs and alcohol from Jeff, everything got blurry and like a dream. Blank clarified that things slowed down, which made her think later that something additional was added to her drink. While at the house, Jeff forced Blank to give him oral sex. When asked if she could clarify what she meant by forced, Blank stated there was no verbal threat, but that yes, Jeff physically put his hands on her. He grabbed her hair and shoved her head down there. She remembered seeing his penis and vaguely thinking, oh, that's a grown man's penis. She stated, I wasn't sober. She did not recall the rest of the time she was with Jeff that day, other than laying on a bed in a fog after the oral sex. To her knowledge, no other individual showed up at the house while she was there. Blank was not aware of how long she was at Jeff's house. However, when she left, it was still light outside, and she recalled being semi-conscious. Thinking back, Blank stated she was embarrassed to say that, and now I'm on page 4, that while she was at the house, still in the fog, she thought, my friends are going to love me. I found a guy with drugs. However, when she left, quote, I wasn't telling anyone anything about what happened with Jeff. Jeff did not pay or give Blank any money with respect to the babysitting job he was supposed to have done. Blank initially stated she thought she had approximately 4 interactions with Jeff within one span of time, which was possibly a few weeks. She subsequently recalled possibly 6 initial contacts. At that point, there was a break in time, after which she had additional interactions with Jeff. The day after she met Jeff, at around noon, Blank approached her mother to ask for food money. Blank's mother told her Jeff wanted her to come back that day to babysit. Blank did not tell her mother what happened the previous day with Jeff. Blank explained she was worried she would screw up her mother's business. And she also recalled knowing at the time how important Blank's babysitting job was to her mom. Her mother was proud of her. Blank was afraid she would get into trouble for the things she had done the day before. During her second interaction with Jeff, Blank remembered being back in Jeff's house. He asked whether she said anything to her mother about their previous contact. She responded no, and he replied, good girl. Also remembered looking around the house and noticing there were no toys. She remembered wondering whether Jeff really had any kids. Thinking back to that day, Blank remembered feeling heavy, and the weirdest feeling came over me. And before she knew it, she saw a substance on her knee that she thought at the time looked like snot. Jeff wiped it off. Blank was frozen. Quote, part of me wanted to look, but I couldn't turn my head. Blank stared out the window of the office as she described the events of that day. While describing the incident, Blank stopped briefly and said she remembered the pants she wore, red sweats with silver material on the knees. The incident took place in the library den area with all of the books. Jeff seemed nervous that day, and again, he did not pay her for the scheduled babysitting job. Blank recalled she left the house quickly that day. Blank could not recall how she first came to know the man's name was Jeff. She just always knew that was his name. He may have told her his name, or, page 5, her mother may have said his name on any number of occasions back then. Her mother may have also learned his name if he filled out any real estate paperwork. With respect to the last name Epstein, Blank possibly heard Jeff's last name during the time she had contact with him. Her friend, Blank, also mentioned the name Jeff Epstein to her recently, and she recalled hearing the name Epstein in a movie starring Barbra Streisand and Nick Nolte some time ago. A few months ago, Blank told her close friend, Blank, whom she has known since both lived on blank, some of the details regarding her contact with Jeff when she was young. Blank recalled she made a statement to blank regarding Jeff, and blank responded with words to the effect of, "You told me that when we were kids." At that point, blank vaguely recalled talking to blank when they were young about the incidents that occurred between herself and Jeff. Not long after, blank sent blank a text asking, "Do these names sound familiar?" Blank then sent a text to blank containing the name Jeffrey Epstein, as well as other names. Blank did not feel comfortable providing the additional names at the time of the interview. Soon thereafter, blank sent a photograph to blank via text message and asked something to the effect of whether blank knew the name of the person in the photo and, "Is this the guy?" Blank advised looking at the person in the photograph. Took me back, and she had a fleeting thought that he reminded her of Lurch from the Addams Family. Blank told blank to turn on the news, which blank stated she does not generally watch. Jeffrey Epstein's face was one I couldn't forget, she said. She then told blank about a sex ring and indicated that Jeffrey Epstein got into trouble years ago, but received a slap on the wrist regarding something that happened in Florida. Blank later viewed the image blank sent her with her friend and neighbor. Blank told blank, quote, "That is the person who caused me great harm and affected my entire life. He's a nightmare." Blank advised the photograph blank sent her was still saved in her cell phone messages. Upon request by the agents, blank accessed the image, and before she showed the picture to the interviewing agents, blank asked whether she could crop the photograph to include only the man she was referring to. Essentially, page 6, cropping out one or more individuals also included in the picture. Blank's attorney, Mr. Blank, offhandedly mentioned the word president while looking at the image on Blank's cell phone. The agents asked whether Blank would be comfortable explaining why she wanted to crop the photograph. When Blank hesitated, Blank's attorney advised Blank was concerned about implicating additional individuals, and specifically any that were well known due to fear of retaliation. The agents advised Blank she could crop the image to show only what she felt comfortable with, if she felt it was necessary. Administrative note. Blank agreed to allow the agents to take a photograph of the cropped image attached electronically. Of note, the particular image sent to her by Blank was recognized by agents as a widely distributed photograph of Jeffrey Epstein and current United States President Donald Trump. The cropped image Blank provided to the agents only included Jeffrey Epstein. Blank advised the agents she was 100% positive the man in the photograph was Jeff, the man detailed above, who she initially believed she was hired to babysit for, and who sexually abused her multiple times, beginning when she was approximately 13 years old on Blank. 13 years old. While observing the image in the presence of the agents, Blank advised she had not seen Jeff in a long time, and that he looked a little older in the photograph than she remembered him. Blank advised the person wasn't that unattractive back then. With respect to the other individuals she cropped out of the image, Blank advised they were someone she had met. No further information was provided. Blank advised she learned Jeff took Polaroid photographs of her engaged in sexual activity, possibly during their first interaction with him, and definitely during her third interaction. Blank stated that during her third interaction with Jeff, which happened within a few days of the second incident, Blank opened a drawer in the house and observed a lot of photos. She saw photographs of herself, but was not sure whether all the photos included in the drawer were of her. She wanted to take all the photographs to try and piece together the holes in her memory as to what had happened during her previous interactions with Jeff, and also because she was embarrassed that she was naked in the pictures. However, Jeff caught Blank looking at the pictures. He became very angry when he caught her. Next page, page 7. When asked what Jeff did when he caught her looking at the pictures, Blank stated, "He raped me. Jeff bent her over and raped her, and it wasn't vaginal." Jeff called Blank a stupid bitch and stated that being nosy isn't good for you. He told her she was going to get herself in trouble, and now she owed him. Blank advised that was the point when the threat started. That was when he turned. Blank recalled Jeff also said some words to her in a different language that she did not understand. When Jeff got nervous, he sometimes sounded different. He sounded like he had a lisp, did not have a thick New York accent. Blank recalled Jeff had an eye tooth that looked like a snaggletooth at that time. She recalled he was not terribly ugly. He also dressed well and wore cardboard shirts and penny loafers. He had a habit of changing the pennies in his loafers frequently, and they were almost brand new pennies. Blank stated she had only seen children's penises at that point in her life. She did not recall any additional abnormalities with respect to Jeff's body. However, Blank qualified her statement that most of the time, Jeff abused her from behind. She did recall that with respect to 2 additional people who abused her, one was not circumcised. Blank is aware of the uncircumcised man's identity. However, she was not comfortable providing it at the time of the interview. Blank reiterated that during her 3rd interaction with Jeff, he started out behind her, raping her every possible way, orally, vaginally. At that point in her life, Blank had large breasts, which made her very uncomfortable. She would beg to keep her shirt on during her interactions with Jeff. He made fun of her breasts, sometimes saying nice things, and other times telling her he knew why she was disgusted with her breasts. Jeff used objects to sexually assault Blank. He specifically recalled that on at least one occasion, he used beer bottles and a golf club handle to rape her anally and vaginally. Blank also remembered Jeff attempting to fit his entire hand in her mouth. At some point, Jeff told her, "If you don't want this to happen to you, you need to go find me friends." On approximately the 2nd interaction, Jeff asked Blank, "Do you have any friends who are pretty?" Blank recalled thinking Jeff did not think she was attractive back then. Page 8 of 9. There were times when Jeff was raping Blank that he pulled her hair, covered her mouth and nose at the same time, and put his hand on her throat. She thought the act of placing his hand on her throat was more of a threat than actually attempting to strangle her. She did not recall him squeezing her throat. She did not recall Jeff binding her body during the sexual assaults. He never full-on punched her. However, he squeezed her bottom and breasts and would yank her nipples to the point the actions were very painful. She stated, quote, "I would have given anything for him to have given me a cocktail again. It would have been nice to have not been aware." Believing she would continue to be raped and sexually assaulted by Jeff, she gave in at some point and told him, "Yes, I'll find some friends." Jeff wanted young, fresh meat girls, virgins. He told her, "Don't bring me any niggers." She said she never brought any friends. At this point in the interview, her attorney, Barry Blank, Esquire, advised the following. At Epstein's request, she at times met people on the beach and may have told them something to the effect of, "If you want a party, go to Epstein's." Following Blank's statement, Blank shook her shoulders and head in the affirmative. She clarified that after what Jeff had done to her, she did not want it, the rapes and sexual assaults, to be repeated, and she decided finding other girls for him, strangers she found in town, might spare her more abuse. With respect to her adult life, Blank advised Jeff's abuse and the abuse she endured by others associated with him caused her to shut down. She became fearful after being threatened for her whole life. She stated, "I haven't said anything yet, so imagine once I do." She expressed deep concern over being one of the first victims to come forward and any ramifications she may suffer due to it. Blank indicated that due to the time that had elapsed since the events involving Jeff occurred over 30 years, she had difficulty remembering exactly when some of the interactions occurred and in what order. Blank recalled that during her 4th or 5th interactions with Jeff, there were 2 other men in the house as well. She advised she may know the name of one man, but she did not feel comfortable providing it at this time. Jeff was introducing her to these pigs. Jeff bragged and showed the men the things he'd done to her. Jeff made a statement to the effect of, "This is why fresh meat is good. You can do whatever you want." 2 more paragraphs. The men masturbated as Jeff sexually assaulted her. During that interaction, Jeff penetrated her vaginally with both objects and his penis. She remembered that at some point she was alone with the two men after Jeff did his sick shit and excused himself because he was planning for other girls to show up at the house. She described the two men as fat and disgusting. Both were older than Jeff. Both of the men had southern accents. She recalled Jeff's big thing was vaginal fresh meat. That's the end of that. And I'll just say this in closing. I hope that taking part today helps raise the voices of these women who were so incredibly brave to step forward and talk about their abuse. And I hope that soon, like tomorrow, they receive the full transparency and justice they want and deserve. Thank you for listening.
and Delayed Disclosures in Childhood, McIlvaney 2015. This disclosure review differs by focusing on CSA disclosures in children, youth, and adults from childhood and into adulthood over the life course. Method. Cottigley and Stoggins' 2014 systematic review framework was utilized to establish what has been investigated in CSA disclosure research, though various mixed methods to highlight the most convincing findings that should be considered for future research practice and program planning. This review centered on the question, what is the state of CSA disclosure research and what can be learned to apply to future research and practice? By way of clarification, the term systemic refers to methodologically sound strategy for searching literature and studies for knowledge construction, in this case the CSA disclosure literature rather than intervention studies. The years span for research for literature were 2000 through 2016, building on previous reviews without a great deal of overlap. Retrieval of relevant research was done by searching international electronic databases, PsycInfo, Psych Articles, Educational Resource Information Center, Canadian Research Index, International Bibliography of the Social Sciences, published international literature on traumatic stress, sociological abstracts, social service abstracts, and applied social service index and abstracts. This review searched peer-reviewed studies. A search of child sexual abuse, disclosure, and telling. A search of the 9 databases produced 322 peer-reviewed articles. Selected research terms yielded 200 English publications, 1 French study, and 1 Portuguese review. The search was further refined by excluding studies focusing on forensic investigations, as these studies constitute a specialized legal focus on interview approaches and techniques. As well, papers that focused exclusively on rates and responses to CSA disclosure were excluded, as these are substantial areas unto themselves, exceeded the aims of the review question. Review articles were also excluded. Once the exclusion criteria were applied, the search reviews yielded 33 articles. These studies were subjected to a thematic analysis as described by Braun and Clark, 2006. This entailed 1, multiple readings by the 3 authors, 2, identified patterns across studies by coding and charting specific features, 3, examining disclosure definitions used, sample characteristics, and measures utilized, and 4, major findings were extrapolated. Readings of the articles was initially conducted by the authors to identify general trends in a first level of analysis, and then subsequently to identify themes through a deeper second level analyses. A table of studies was generated and was continuously reviewed as the selection of studies was refined. See Table 1. Key findings. First level analysis of the studies identify key study characteristics. Trends emerged around definitions of CSA disclosure, study designs, and sampling issues. First, in regard to definitions, the term telling is most frequently used in place of the term disclosure. In the absence of standardized questionnaires or disclosure instruments, telling emerges as a practical term more readily understood by study participants. And here I'm going to hold this up because this is a chart which goes on for many pages and it's very hard to read. So with everybody's permission, I'm going to go back to reading what I was reading prior. Examples of this usage were found in the research questions, interview guides, and surveys examined. Quote, how and when do people decide to tell others about their early sexual experiences with adults? Parens, Hunter, 2011, page 161, and parens. Quote, some men take many years to tell someone that they were sexually abused. Please describe why it may be difficult for men to discuss the sexual abuse. Parens, Easton, Salzman, and Willis, 2014, page 62, and parens. Quote, participants were asked a series of open-ended questions to elicit a narrative regarding their experience of telling, end quote. Parens, McIlvaney, Green, and Hogan, 2012, page 1160, and parens. Quote, who was the first person you told? End quote. Parens, Schaefer, Leventhal, and Annis, 2011, page 346, and parens. There was sound consistency between studies defining disclosure in multifaceted ways with uniform use of categories of prompted, purposeful, withheld, accidental, direct, and indirect. However, defining the period of time that would delineate a disclosure as delayed varied widely across studies, where in some studies viewed 1 week or 1 month as a delayed disclosure, i.e. Hershkowitz et al., 2007, Kogan 2004, Sean Brucker, Meyer, Moen Kuo, Schinder, and Landhold 2012. Other studies simply reported average years of delay, sometimes as long as from 20 to 46 years. Easton 2013, Johnson and Lindblad 2004, Smith et al. 2000. Second, the number of qualitative studies has increased significantly over the last 15 years. This rises in response to a previous dearth of qualitative studies. Based on Jones's 2000 observation that disclosure factors and outcomes had been well documented through quantitative methods, in a widely read editorial, he recommended, quote, qualitative studies which are able to track the individual experiences of children and their perception of the influences upon them, which led to their disclosure of information, are needed to complement, end quote, parens, page 270. Third, although a few studies strive to obtain representative samples of quantitative investigations, Herkowicz, Horowitz, and Lamb, 2005, Kogan, 2004, Smith et al., 2000, sampling was for the most part convenience-based, relying on voluntary participation in surveys and consent-based participation. In file reviews, Collings, Griffiths, and Kumalo, 2005, Prieb and Sverdin, 2008, Sean Brucker et al., 2012, Ungar, Barter, McConnell, Tuddy, and Fairholm, 2009a. Therefore, generalizability of findings is understandably limited. The qualitative studies used purposeful sampling as is deemed appropriate for transferability of findings to similar populations. Some of those samples contained unique characteristics since they were sought through counseling centers or sexual advocacy groups. These would be considered clinical samples producing results based on disclosures that may have been delayed or problematic. This might presumably produce data skewed toward barriers and bring forward less information on disclosure facilitators. Through an in-depth second-level analysis, this review identified 5 distinct themes and sub-themes beyond the general trends as noted earlier. Theme 1, disclosure is viewed as an ongoing process as opposed to a discrete event, iterative and interactive in nature. A sub-theme was identified regarding disclosure as facilitated with the dialogical and relational context is being more clearly defined. Theme 2, contemporary disclosure models reflect a social, ecological, person, and environmental perspective to understand the complex interplay of individual, familial, contextual, and cultural factors involved in CSA disclosure. Sub-themes include new categories of disclosure and a growing focus on previously missing cultural and contextual factors. Theme 3, age and gender are strong predictors for delaying disclosure or withholding disclosure, with trends showing fewer disclosure by younger children and boys. One sub-theme emerged that intrafamilial abuse / family-like relationship of perpetrator has a bearing on disclosure, delays, or withholding. Theme 4, there is a lack of cohesive life course perspective. One sub-theme includes the lack of data within the 18 to 24-year-old emerging adult population. Theme 5, significantly more information is available on barriers than on facilitators of CSA disclosure. Sub-themes of shame, self-blame, and fear are uniformly identified in disclosure deterrence. Disclosure is an ongoing process, iterative and interactive in nature. Disclosure is now generally accepted as a complex and lifelong process, with current trends showing that CSA disclosures are too often delayed until adulthood. Parens, Collin, Vazina et al., 2015, Easton 2013, Hunter 2011. End parens. Knowledge building about CSA disclosure has moved in the direction of understanding this as iterative and interactive process rather than a discrete one-time event. Since the new millennium, disclosure is being viewed as a dynamic rather than static process and described, quote, not as a single event, but rather a carefully measured process, end quote, parens, Alaja, 2005, page 455, end parens. The catalyst for this view originates from Summit to 1983, who originally conceptualized CSA disclosures as process-based, although this notion was not fully explored until several years later. Examinations of Summit's 1983 groundbreaking proposition of the CSA accommodation, parens CSAA, and parens model produced varying results as to whether his 5 stages of secrecy, helplessness, entrapment, and accommodation, delayed, conflicted, and unconvincing disclosures, and retraction or recantation hold validity. For a review, see London, Bruck, Sessi, and Schumann, 2005. However, the idea of disclosure as a process has been carried over into contemporary thinking. Recently, McIlvaney, Green, and Hogan, 2012, and Perens detailed a process model of disclosure wherein they describe an interaction of internal factors of external motivators, which they liken to a, quote, pressure cooker, unquote, effect, preceded by a period of containment of the secret. Moreover, this and other studies strongly suggest disclosures are more likely to occur within a dialogical context, activated by discussions of abuse or prevention forums, providing information about sexual abuse. Thank you all so much for listening to this, and I will pass it over to the next person. Thank you to Eliza Orleans for moderating this for the next God knows how many hours. Just incredible that she's doing this. Thanks, everybody.
Thank you so much, Julie, and thank you everyone who is joining us. We are now officially into hour 4, and I am joined now by Nathan. Nathan, which last name should I use? Your online one? Nathan Jun. He is a political content creator, and he does a lot of economics, policy, and media analysis. He's brilliant. He's a friend of mine. I'm so glad that he's here with us today to do some reading. I will let Nathan take it away from here. And Nathan, if you wouldn't mind introducing yourself and telling everyone why this was so important for you to be here today. Thanks.
Do we know where she left off at? Yeah. It's a large book.
That's a good question. Where did I leave off? I don't have my glasses. I think I laid off. I left off somewhere.
Okay.
Right here. Okay.
All right. As Eliza said, my name is Nathan Jun. I'm an immigrant, and my sister is a. Ooh, this is powerful. My sister is a survivor of sexual assault and rape. So this is meaningful for me for that reason, but also I'm here because Congress demanded that the full files be released, and we are still 5 months later waiting for the files to be released, and the files that they did release were redacted, and they did not redact the survivors, and their safety and well-being has been compromised. And a lot of people might say that this is performative, but for me personally, this feels at least like I am participating in something that will hopefully create the necessary movement to create a mountain to get the files released full and to get the survivors redacted for their safety. And that is why I'm here. So, picking up where we left off. Recently, McIlvaney, Green, and Hogan detailed a process model of disclosure wherein they described an integration of internal factors with external motivators, which they likened to a pressure cooker effect, preceded by a period of containment of the secret. Moreover, this and other studies strongly suggest disclosures are more likely to occur within a dialogical context, activated by discussions of abuse or prevention forums providing information about sexual abuse. The term dialogical simply means to participate in dialogue. Key dialogical vehicles identified in these studies were providing sexual abuse information through prevention programs, being asked about sexual abuse, and being prompted to tell. Contemporary models of CSA disclosure reflect a socio-ecological perspective. Knowledge on CSA disclosure has been steadily advancing toward a holistic understanding of the complex interplay of individual, familial, contextual, and cultural factors, where at one time factors examined and identified were predominantly of intrapersonal factors of child victims. Knowledge construction has shifted to fuller socio-ecological person and environment explanations. Social ecological explanations open up more opportunities to intervene in facilitating earlier disclosures. Alagia proposes an ecological mapping of what individual, interpersonal, environmental, and contextual influences impede or promote CSA disclosures based on an analysis of in-depth interview data of 40 adult survivors. Subsequently, based on a sample of 67 adult survivors, Collin, Vizina, Sabloni, Palmer, and Milne identified 3 broad categories closely aligned with an ecological framework that impedes CSA disclosure: barriers from within, barriers in relation to others, and barriers in relation to the social world, which can be aligned to intrapersonal, interpersonal, and contextual factors. A summary of knowledge building using a social ecological framework follows. Knowledge gained in the intrapersonal domain excludes expanded conceptualization of disclosure by building on previous categories of accidental, purposeful, and prompted disclosure to also include behavioral and indirect attempts to tell intentionally withheld disclosure and triggered and recovered memories. Categories of indirect behavioral disclosure pattern have further verified in follow-up research by Hunter and through an extensive file review that used Alagia's disclosure framework to analyze their data for verification. Interpersonal factors have also emerged in regard to certain family characteristics as disclosure barriers. Families with rigidly fixed gender roles, patriarchal attitudes, power imbalances, other forms of child abuse and domestic violence, chaotic family structure, dysfunctional communication, and social isolation have been found to suppress disclosure. In addition, relationships with perpetrator is a factor whereby research indicates that disclosure is made more difficult when the perpetrator is a family member or close to the family. This is especially a barrier when the perpetrator lives with the victim. In terms of environmental factors, one study revealed that neighborhood community conditions can hinder disclosures when there is lack of school involvement in providing a supportive environment, such as in following up on troubling student behavior. Cultural factors influencing CSA disclosures have been studied to a much lesser degree. Despite this, a few important studies examining critical socio-cultural factors now exist for a better understanding CSA disclosure within a cultural context. Among these important contributions, Brazelton's 2015 research has delineated CSA disclosure processes as shaped by rational, racial, sociocultural, historical, and developmental factors. In a unique study using culturally focused research literature as data triangulated with clinical case materials, culturally based belief systems and many cultures have found to foster family climates that can silence children from disclosing abuse. Taboos about sexuality, patriarchal attitudes, and devaluation of women are among some of the cultural barriers that inhibit disclosure. Clearly, disclosure conceptualizations are being integrated into a socio-ecological model of individual and developmental factors, family dynamics, neighborhood and community context, as well as cultural and societal attitudes towards better understanding disclosure barriers and facilitators, although more data is needed on cultural and contextual factors. Age is consistently found to be an influential factor in CSA disclosure, making the life stage of the victim-survivor a critical consideration. Studies draw a distinction in age groups falling into either under or over 18 years of age. 18 years of age was the common age cutoff point that investigators chose in order to distinguish child-youth populations from adult samples. 16 of the studies drew on samples of children and youth, while the other 15 studies sampled adults over the age of 18, and a further 2 studies used mixed age groups. Among the child and youth samples, the age ranges span from preschool to late adolescence, with varying methodological approaches implemented across age cohorts. For younger cohorts, file reviews and secondary analysis of CSA reports were typically undertaken. Adolescents were most often given surveys. Sometimes children and youth were interviewed as part of administrating a survey or as a follow-up. In the majority of child and adolescent samples, sexual abuse concerns were already flagged to investigative authorities. However, the work of Unger, Barter, McConnell, Tuddy, and Fairholm is one exemption where by their survey elicited new disclosures. Adult studies typically had a mean age between 40 and 50 years. Interviews were the main data collection method, with a few exceptions using survey designs. Results show a clear trend toward increased likelihood of disclosure in older youth, and finding from adult samples showing a preponderance of disclosures in adulthood, with the large majority of participants of adults reporting never had a sexual abuse complaint filed with investigative authorities as a child or an adolescent. With children and youth under the age of 18, distinct patterns. First, accidental detection rather than purposeful disclosure is more likely to occur with younger children. For example, in one large-scale study of over 1,737 file reviews, over half of the CSA-related cases were identified through accidental and eyewitness detection, while less than one-third were purposeful disclosures initiated by the child victim. The second pattern which emerges is that rate of disclosure increased with age, especially into adulthood, which is supported by persistent findings of high rates of delayed disclosure reported later in the life by adult survivors. Third, younger children who disclose are more likely to do so in an interview situation or an environment that provides prompts or questions about sexual abuse. A number of studies have recently focused on CSA disclosures with male victims, since males have been an understudied population. Most investigations that sampled both sexes show females outweighing male participants, although women are at double the risk of being subjected to CSA. The ratio of women to men in most disclosure studies has not been representative. This finding may be indicative of male victims more likely delaying disclosing their CSA experiences, leaving male disclosure in child and youth samples underrepresented. Easton, Saltzman, and Willis have been developing gender-specific modeling of disclosure examining male disclosures. Their proposed model groups male disclosures into barrier categories as determined by individual factors, interpersonal issues, and factors that are socio-political in nature. These authors suggest that predominant gender norms around masculinity reinforce the tendency for male victims of CSA to blame themselves. For the abuse resulting in no disclosure, male participants in a subsequent study also relay that gender norms and stereotypes contributed to them concealing the abuse because they were abused by women. In the study that compared male and female disclosures, investigator found that men's fears of being viewed as homosexual, profound feelings of stigmatization or isolation because of their belief that boys are rarely victimized, and fear of becoming an abuser acted as disclosure barriers, whereas females felt more conflicted about who was responsible for the abuse and more strongly anticipated being blamed and not believed. Lack of life perspective. Given that the CSA disclosures draw on age groups ranging from samples of very young children to retrospective studies of adult survivors with significant developmental considerations, this area of study lacks an internal, cohesive life course perspective. Most data are derived from either cross-sectional or retrospective designs with few longitudinal studies. There are a series of sound yet disconnected studies focused on the specific age groups of children and adolescents along with adult retrospective studies. Thus, the available knowledge base does not allow for a cohesive picture of CSA disclosures, processes, and pathways over the life course to emerge. The life course perspective has been recommended as a critical lens for the study of child abuse. For example, a life course perspective has been utilized to understand the immediate and long-term effects of CSA on the developing child victim. Further, a life course perspective is important in terms of examining age of onset of CSA to explain the differential effects of sexual victimization and developmental impacts in terms of understanding their ability to disclose. Effects that need to be understood within a developmental context, especially for designing appropriate interventions for disclosures at critical transitions from early childhood through to adolescence and into adults. In addition, important turning points in life may facilitate disclosures. For example, entry into adulthood, given that delayed disclosure often occurs in adulthood, Alagia found that being in a committed relationship, the child acted as facilitator for some survivors to disclose, especially to their spouses. These significant life events as contributing to disclosure bear further examination. Research over the past 15 years continues to uncover barriers to CSA disclosures at a higher frequency than that of facilitators. As previously stated, that this might be the result of sampling methods whereby participants who volunteer for disclosure research may have had more negative disclosure experiences, especially since many report delays in disclosure. The following section outlines the major trends in both barriers and facilitators. Barriers. Age and gender were found to contribute to barriers as covered in Theme 3. Disclosures increase with age. Barriers listed. The younger the child victim, the less likely they will purposefully disclose. Gender. Males may be less likely to disclose in childhood adolescence as fear of being seen as homosexual and as a victim. Females experience more self-blame and anticipation of being blamed and are not believed. Relationship to perpetrator. If the perpetrator is a family member or in a family-like role, disclosure is less likely to happen. Sorry. I'm just sorry, this is hard for me just because I'm just thinking my sister, sorry. Because she held it in for a very long time. And it was a family member that did it. Okay. Shame, self-blame, and fear are psychological barriers. In addition, fear of negative consequences on the family and her self-safety inhibits disclosure. Families with a patriarchal structure, rigidly fixed gender roles, dysfunctional communication, other forms of abuse, i.e. domestic balance and isolation, inhibit disclosure. Environmental and cultural context. Lack of discussion about sexuality, passive acceptance that unwanted sexual experiences are inevitable, not wanting to bring shame to the family by admitting sexual abuse, lack of involvement from neighbors, school personnel, and stigma perpetuated by societal perceptions. Facilitators. Age. Disclosures increase with age, especially in adulthood. Gender. Slight trend towards females who are older, adolescent, to disclose before adulthood. Relationship to perpetrator. If the perpetrator is not living with the victim, disclosure rates increase. Dialogical context. Opportunities to disclose through discussion, therapeutic relationship, information sessions on sexuality, and sexual abuse prevention programs. Family relations. Supportive parent-child relationship. I think I need to take a break. Yeah.
Nathan, thank you so much for joining us. I know this isn't easy for anyone, and so, continued trigger warning about what a difficult subject this is. And so thank you everyone who is here with us, but please make sure you take care of yourselves because this is very heavy. I believe I am joined now by journalist and author of the Red Letter Substack, Tara Palmieri. She hosted Broken Seeking Justice and has stayed on the Epstein story for a long time when others were moving on. Tara, thank you for spending years listening to survivors, and thank you for being here with us today. I will turn it over to you.
Hi, thank you for having me. I will continue with the reading of the Epstein files, which I personally believe is a very important thing to make these documents real, to put them into the record. I also want to disclose that I am a journalist. I am not affiliated with the Save America PAC. I do not support super PACs and I'm not supported by super PACs. I am doing this independently because I think it is important, but I am not affiliated with a PAC or super PAC. This is not a political action for me. This is merely a documentation. So I'm going to start with, well, it's really the middle of the government of the Virgin Islands complaint against Jeffrey Epstein. And it looks like it was filed on, wow, this is really creepy, September 1st, 2020. That is my birthday, September 1st. We are in page 28 of 55. So these are court documents, so they're obviously very boring and very dry. And I will try to make them as interesting as possible. So, although sadly the graphic details of this story are horrific and kind of hard to turn away from. So, here we are, page 27 of 55. Each defendant engaged in acts that revealed its intent to join and participate in the criminal conspiracy by knowingly using coercion to compel underage girls and young women to provide labor or services by forced labor in violation of 14 BIC. Defendants knowingly benefited financially and or obtained other non-financial value from participation in the Epstein enterprise, which has engaged in human trafficking, forced labor, sexual servitude, and commercial sexual activity and young women in knowing or reckless disregard of the laws of the Virgin Islands. At all times, material herein, each defendant conspired with Epstein and other defendants to fulfill the primary criminal purposes of the Epstein enterprise: human trafficking, forced labor, and sexual servitude. At all times, material herein, defendants engaged in said pattern of criminal activity that was not isolated but was related to the affairs of the Epstein enterprise in violation of CICO. So it sounds like this is actually a complaint against everyone involved in the Jeffrey Epstein operation, the sex trafficking operation, because as we know, there were many people involved, the moving of people across state lines, just even, maintaining his properties. We know now from the files of the Department of the DEA, the Drug Administration, they were actually looking into whether they were trafficking drugs to the island. All right, count 5, human trafficking, sexual servitude. The government restates and realleges paragraphs 1 through 140 of this complaint as if fully set forth herein. At all times, material herein, each defendant directly and indirectly participated or associated with the Epstein criminal enterprise, an illicit enterprise. The Epstein enterprise engaged in 2 or more occasions of conduct that constitute criminal predicate acts as defined by CICO, including but not limited to knowingly maintaining or making available minors for the purpose of engaging the minors in commercial sexual activities or using coercion or deception to force young women to engage in commercial sexual activity in violation of 14 BIC. On the pretext of providing modeling opportunities, careers, and contracts, defendants facilitated the transporting or recruiting of young women and girls, or lured and recruited young women and underage girls to travel to the Virgin Islands where they engaged in sexual acts with Epstein and others. Note the word others. Important to note that because no others have been actually charged. In some instances, young women and underage girls were given scholarships, money, gifts, or other items of value in exchange for engaging in sexual acts with Epstein and others. I've been thinking about that lately. Why Epstein targeted the girls that he targeted. And so many of them they were ambitious, fair, but I think a big part of their ambition was a desire to escape where they were from and the very difficult upbringings that they already had. We know in the case of Virginia Giuffre, she was actually trafficked by her own father and was sexually abused by him and was trafficked before Epstein found her. So a lot of these women, and then he said, I can make you a traveling masseuse. In their minds, they were being freed from the servitude and the pain and the abuse that they were already suffering with at home. So I just think it's really worth it to point this out, that these women were ambitious to get out of the situation that they were in. Defendants, through a pattern of criminal activity, directly and indirectly participated in or associated with the Epstein enterprise, an illicit enterprise. Defendants, through a pattern of criminal activity, acquired and maintained directly or indirectly an interest in or control of the Epstein enterprise or real property. Defendants benefited directly and indirectly from the pattern of criminal activity conducted by the Epstein enterprise. At all times, material herein, defendants engaged in said pattern of criminal activity that was not isolated, but was related to the affairs of the Epstein enterprise in violation of CICO. At all times material herein, each defendant joined in a conspiracy to violate laws prohibiting human trafficking. Each defendant engaged in acts that revealed its intent to join the criminal conspiracy of knowingly maintaining or making available minors for the purpose of engaging the minors in commercial sexual activities, or using coercion or deception to force young women to engage in commercial sexual activity. On the pretext of providing modeling opportunities, careers, and contracts, defendants facilitated the transporting or recruiting of young girls and women, or lured and recruited young women and underage girls to travel to the Virgin Islands where they engaged in sexual acts with Epstein and others. In some instances, young women and underage girls were given scholarship money. It looks like that was a repeat of the last page. So, or I just read the same thing over twice. So I'm going to keep going. The government restates and realleges paragraphs 1 through 55 of this complaint. Okay. Apparently in lawsuits, they repeat things very frequently in documents like this. I'm going to try to tell you a little bit. I'm reading most of it, but a lot of it is repetitive. So I'm going to keep reading along. I mean, this document essentially suggests that there was an entire criminal conspiracy happening on an island in the Virgin Islands, and it required a large network of people and a number of co-conspirators. And it really talks about the way that these girls were recruited, scholarships, money, gifts, what that meant to many of these young girls. Maria Farmer, an artist, and her sister Annie, both came from families, single mother, did not have the means, and Epstein came along promising to make their dreams come true. It's actually just such a common story. He actually sought out children who needed patrons in the arts, in ballet, in Juilliard, Interlochen, people who had real talent. That's what made so many of these survivors truly incredible people, but didn't have the financial means. Okay. So many of them have said that their dreams were dashed from what happened to them, and their ability to be creative sucked from them because of this horrible abuse. Here's a 173. The Epstein enterprise engaged in 2 or more occasions of conduct that constitute criminal predicate acts as defined by CICO, including but not limited to knowingly or recklessly causing a child to suffer physical, mental, or emotional injury, or knowingly or recklessly causing a child to be placed in a situation where it is reasonably foreseeable that such child may suffer physical, mental, or emotional injury in violation Virginia Islands criminal laws prohibiting child abuse and neglect. I think that's really important to point out, that these children suffered physical, mental, and emotional injury. And often that emotional injury is the hardest one to to heal from. Defendants, through a pattern of criminal activity, acquired and maintained directly or indirectly an interest in or control of the Epstein enterprise or real property. Okay. At all times, material herein, each defendant joined in a conspiracy to violate laws prohibiting child abuse and neglect. Each defendant engaged in acts that revealed its intent to join and participate in criminal conspiracy as they knowingly or recklessly caused a child to suffer physical, mental, or emotional injury, or knowingly or recklessly caused a child to be placed in a situation where it is reasonably foreseeable that such child may suffer physical, mental, or emotional injury in violation Virgin Islands criminal laws prohibiting child abuse and neglect. As a result of defendants' actions, numerous young girls suffered physical, mental, and emotional injury. Defendants knowingly benefited financially and or obtained other financial value from participating in the Epstein enterprise, which has engaged in human trafficking, forced labor, sexual servitude, and commercial sexual activity of girls and young women in knowing or regardless or reckless disregard of the laws of the Virgin Islands. At all times herein, each defendant conspired with Epstein and other defendants to fulfill the primary criminal purposes of the Epstein enterprise: human trafficking, forced labor, and sexual servitude. At all times, material herein, defendants engaged in a pattern of criminal activity that was not isolated, but was related to the affairs of the Epstein enterprise. That is it for me. I think it is all a really strong reminder of how they lured these girls with promises to free them from their very difficult lives, and then the child abuse that they then committed against them, and all of the many different parts and players it took to make that happen, and then the fact that there are co-conspirators who are out there free right now. Thank you all, and I pass this on to the next person. Of course, thank you.
Whatever you want. Okay, it is almost time. So we are about 4.5 hours in to our cover to cover up 24-hour filibuster style live stream reading the Epstein files live from the Donald J. Trump and Jeffrey Epstein reading room here in Lower Manhattan. While we read, we are raising money for World Without Exploitation, which fights sex trafficking and the systems that enable it, including the ones in these very files. As a reminder, I'm Eliza Orlins, and I'm here with the Save America movement, which is a nonprofit. And we are here, as I said, raising money for World Without Exploitation. There should be a QR code on your screen, so please scan it to support this important organization. Joining me now is Academy Award-winning film producer and 2023 National Medal of Arts recipient, Bruce Cohen. Bruce, it's so good to have you with us. Thank you so much.
Thank you. I'm so honored to be here. So, via certified mail from Ghislaine Maxwell, MDC Brooklyn Metropolitan Detention Center, in the United States versus Ghislaine Maxwell, enclosed are witness materials and discovery pertinent to the following inmate, Ghislaine Maxwell. Please allow her access to the materials enclosed. Very truly yours, Damian Williams, United States Attorney, Assistant United States Attorneys. Via certified mail, Ghislaine Maxwell, MDC Brooklyn, Metropolitan Detention Center, United States versus Ghislaine Maxwell, October 26, 2021. Enclosed are witness materials and discovery pertinent to the following inmate, Ghislaine Maxwell. Please allow her access to the materials enclosed. Very truly yours, Damian Williams, United States Attorney, Assistant United States Attorney. October 26th, 2021. via certified mail, Ghislaine Maxwell, MDC Brooklyn, Metropolitan Detention Center, RE, United States versus Ghislaine Maxwell. The password for the disk containing witness materials and discovery pertinent to Ghislaine Maxwell. Very truly yours, Damian Williams, United States Attorney, Assistant United States Attorney. United States District Court, Southern District of New York, United States of America versus Ghislaine Maxwell, defendant. Allison J. Nathan, District Judge. As noted in its previous order, the court will hold an in-person pre-trial conference on November 1st, 2021 at 11 a.m., docket number 330. The conference will take place in courtroom 518 of the United States District Court for the Southern District of New York, Thurgood Marshall U.S. Courthouse at 40 Foley Square, New York, New York. In accordance with its prior order, the court will ensure access for alleged victims and any members of the defendant's family. Docket number 344. 2 pool reporters will be permitted in the courtroom proper. In order to comply with the district's COVID-19 protocols, the public will be able to access the proceeding in overflow courtrooms 110, 506, 619, 905, and 906 of the Thurgood Marshall U.S. Courthouse. These overflow rooms will have live video and audio feeds of the proceeding. The use of any electronic devices during the proceeding in the overflow rooms is strictly prohibited. The court anticipates seating capacity in the overflow rooms for at least 100 members of the public. If capacity is reached, no additional persons will be admitted. Per the SDNY response to COVID-19, anyone who appears at any SDNY courthouse must complete a questionnaire on the date of the proceeding prior to entering the courthouse. All visitors must also have their temperature taken when they arrive at the courthouse. Only persons who meet the entry requirements established by the questionnaire and whose temperatures are below 100.4 degrees will be allowed to enter the courthouse. All visitors must wear a mask that covers the person's nose and mouth. Bandanas, gaiters, and masks with valves are not permitted. If a person does not have an approved mask, a screener will provide one. Anyone who fails to comply with the COVID-19 protocols that have been adopted by the court will be required to leave the courthouse. There are no exceptions. For more information, please see www.nysd.uscourts.gov/COVID-19-coronavirus. So ordered by Allison J. Nathan, United States District Court, United States District Judge, on October 28, 2021, in New York, New York. From Kristen Everdale, Laura Mennings, Bobby C. Sternheim, and Jeff Pagliuca. Subject, U.S. versus Maxwell, 20 CR 330 AGN, Discovery and Exhibits. Date, Friday, 29 October, 2021. Attachments, Maxwell Discovery Letter, PDF, U.S. versus Maxwell Government Exhibit Index, Defense, PDF. Counsel, we have an additional discovery production ready to send to you. Attached, please find the accompanying cover letter. The production will be made via USA FedEx. The materials on USA FX will include additional exhibits. Attached, please find the accompanying index. We will send a CD with the materials to the MDC for Ms. Maxwell. If you would prefer that she receive the production on a drive, we can either request that the MDC send us one of the drives back to load with the production, or we can load a new drive if you would like to provide us with one. Thanks, Assistant United States Attorney, United States Attorney's Office, Southern District of New York. By electronic mail, from Kristen Everdale, Esquire, at Mark Cohen, Esquire, Cohen and Gresser, LLP. From Laura Menninger, Esquire, and Jeffrey Pagliuca, Esquire, Haddon, Morgan, and Foreman. And from Bobby Sternum, Esquire, Law Offices of Bobby C. Sternum. United States versus Ghislaine Maxwell. Dear Counsel, today we are producing the materials listed in the below index. These materials are stamped with control numbers SDNY_GM_027656768 through SDNY_GM_027677073. Please note that both this letter and the enclosed materials are governed by the July 31st, 2020 protective order in this case. This letter is itself designated as confidential because it includes information regarding records designated as confidential under the protective order. The Department of Justice directed this office to cease the dissemination of materials marked with the word confidential in order to avoid potential confusion with markings reserved for classified documents. Accordingly, in order to note the appropriate designation of this production under the operative protective order in this case, the materials being produced today are marked with the following label, quote, subject to protective order paragraphs 7, 8, 9, 10, 15, and 17, unquote. This marking directly refers to the specific paragraphs of the protective order that govern today's production. An index of the materials contained in this production is below. The government recognizes that its discovery obligations are ongoing and will promptly produce any additional discoverable materials of which it becomes aware. Please do not hesitate to reach out if you have any difficulty assessing these materials. Very truly yours, Damian Williams, United States Attorney. From Brad Edwards and Brittany Henderson. Subject Rule 412 motion on Thursday, 28 October 2021. Brad, Brittany. Attached, please find a redacted version of the defense's memorandum of law in support of her Federal Rule of Evidence 412 motion and related exhibits. As we mentioned earlier, this was filed under seal by the defense. Any response is due on November 1st, 2021. Likewise, any and all responses will also be filed under seal and will not be docketed. The court also ordered that any in-camera hearing is tentatively scheduled for November 5th, 2021. We're happy to discuss further tomorrow. I'm also attaching the court's order about the November 1st in-person pretrial conference. Thanks, Assistant United States Attorney, United States Attorney's Office, Southern District of New York. Subject, Epstein letter to the editor. Date, Tuesday, 26 November, 2019. For those who may have missed it, a notable letter to the editor in Sunday's New York Times, and the link to that letter is included. From Berman Jeffrey, USANYS. Sent Thursday, January 9th, 2020. To Berman Jeffrey, USANYS. Subject, Epstein Prose Memo. In preparing a memo in advance of the Human Trafficking Summit in Washington and next week, Redacted asked if I could send her the recent Epstein Prose Memo. Is it okay for me to send to her? From Berman Jeffrey, USANYS. Date, Wednesday, 8 January 2020. One of Epstein's victims, Redacted, said that Maxwell and Redacted coached her on how to pleasure him. It was Ghislaine and Redacted that showed me how to please Jeffrey, Redacted said. From Kathleen E. Cassidy. I forgot to attach the exhibits. They are attached here. Attached is our submission on behalf of our client, Redacted. Please let us know if you have any questions. Take care and stay healthy. From Redacted to Gloria Allred. Subject, call this week. Date, Tuesday, 31 January, March 2020. Please call my cell at Redacted. If we end up needing a conference line, I'll send that before 3 p.m. Eastern as well. Thanks, Redacted. From Gloria Allred to Redacted. Subject, call this week. That works. Please advise as to which number I should call. Gloria Allred. From Redacted, Tuesday, March 31st, 2020. To Gloria Allred. Subject, call this week. Gloria, we were wondering if you or your colleagues have been able to reach any of the clients we discussed last week. It would be very helpful to know their views and reactions shortly, and we're of course happy to speak with them directly as well, if that would be helpful. Thanks, Redacted. From Redacted, Thursday, March 26, 2020. 2, Gloria Allred. Subject, call this week. Gloria, thanks for speaking with us just now. The individuals we mentioned are redacted, redacted, and redacted. Thanks, redacted. From redacted, Wednesday, March 25th, 2020. To Gloria Allred. Subject, call this week. Gloria, would you have time for a call with the SDNY Epstein team tomorrow or Friday? We would like to provide you with a bit of an update and discuss some of your clients in particular. Hope you are staying safe and healthy. Best, redacted, Assistant United States Attorney, Southern District of New York. From redacted, to redacted. Subject, forward. Some will question U.S. District Judge Allison Nathan and Prosecutor's Office. Read if you want. From Gregory Hirsch. Some will question, how does America judge the degree of underage sex trafficking? If a wealthy man and or organization pays for airline tickets, hotel accommodations, and food for underage teens, to which results in the underage girls being paraded on stage in nothing more than what is deemed, quote, not much more than lingerie, unquote, eventually resulting in some of the underage girls possibly having sex with anyone 18 plus and or under 18, possibly straight sex and or lesbian sex, surely the wealthy individual and or organization is guilty of underage sex trafficking to some degree. While some will argue such cases are not to the extent of underage sex trafficking, such as what unfolded in the case of Jeffrey Epstein, both Lolita Island and U.S. gatherings, the argument of presentation cannot be debated. A degree of sex trafficking occurred during what is considered, quote, Miss Teen USA contests. There is grooming involved within beauty pageants, is there not? The payment by a wealthy individual and or organization offering various teenage girls the, quote, flamboyant freedom of opportunity for sex behind pageant doors, unquote, is surely, quote, a hidden secret, unquote, which has taken place, has it not? Had the underage girls not been offered the flamboyant freedom of opportunity through the guise of a beauty pageant, then cases of, perhaps most likely, lesbian sex between underage girls would not have been given the time nor the place for such sex vacations to occur. If such sex vacations occur, then surely it is a form of sex trafficking being set into place, into reality by the wealthy individual and or pageant organization. While chains, threats, freedom, etc. is perhaps not a form of physical sex trafficking, to which oftentimes associated with sex trafficking, if sex, especially underage sex of any manner at beauty pageant gatherings occurs, then this sex trafficking has occurred. Has anyone ever questioned past teen beauty contestants as to how many of them were sexually involved, either with those 18 and over and or under 18, with either those within or around the pageants, with male or female during pageant gatherings? If indeed any form of sexual involvement occurred, then in fact, sex trafficking occurred under the guise of, quote, flamboyant freedom of opportunity, unquote, presented by the beauty pageant owners. A grooming for the world of high-dollar prostitution is what many can potentially perceive beauty pageants and modeling shows to be. Note, obviously, wording of beauty pageants can also be replaced with modeling shows. In order to help ensure Ghislaine Maxwell's day in court, not only for her and her lawyers to defend herself through the legal system, to potentially expose corrupt sex traffickers, and perhaps at this point to expose the active participants within the deceased Jeffrey Epstein sex trafficking saga. Those active participants might very well be high-ranking politicians and government officials and socialites typically associated with Hollywood and the wealthy circles throughout America and the world. Ghislaine Maxwell's health and well-being should be extremely important to all women, young and old, in order to help ensure injustice is not a continuous practice as in the past, while justice is upheld even against those who have thus far been shielded due to political power and wealth. Plenty of stories have been revealed around media and former contestants. Donnie Trump has had employees attempting to groom underage girls for him during Miss Teen USA pageants, as have Donnie Trump and Billy Clinton connections with Epstein and Maxwell.
Bruce, thank you so much. We really appreciate you being here with us today. And I'm also very excited about our next guest. I am joined now by Amy Wallace, the advocate and author who ghost wrote Epstein survivor Virginia Giuffre's best-selling book, Nobody's Girl. Amy, I am so glad that you could join us. We're so grateful for you being here. Feel free to take a moment to introduce yourself, tell everyone why you're here, and then we'll let you take it away. Thank you. I'll take this.
Hi, my name is Amy Wallace, and I'm a journalist and a writer, and I'm the person who had the honor of collaborating with Virginia Roberts Giuffre on her memoir, Nobody's Girl. I wanted to come here to the Donald J. Trump and Jeffrey Epstein Memorial Reading Room because it's a chance to see the enormity of the evidence against Epstein and his co-conspirators. We're gathered in a 5,000 square foot room filled with 3,437 volumes that contain all 3.5 million pages of Epstein files that have been made public to date. And remember, that's only half of the documents that our government is required by law to release to the public. So why am I participating in this 24-hour filibuster, reading excerpts of the Epstein files? Because our Department of Justice has failed to follow up on so many leads that these files contain, and I believe that is shameful. Earlier today, we heard from several of the survivors, the brave survivors of Epstein's crimes, who stood at the same podium where I'm standing, and all of those women have told the FBI what Epstein did to them, and like Virginia Roberts Giuffre did, they have shared what and who they witnessed in Epstein's houses, on his jets, on his island. Some, like Virginia, have provided names of men they were trafficked to. And so far, none of those alleged perpetrators have been prosecuted in the United States. And what's more, there is no evidence that they've even been investigated. And that's why I'm here. Because I believe that if enough of us stand up, there is power in simply stating the truth. There is power in reviewing the evidence and in demanding that the evidence not be ignored. Now, I'm going to read a couple of random excerpts. These files are released in a way that is designed to be completely confusing. They do not have any context. One thing is not like another. So you just thumb through and you find random bits. But I tried to pick a few that would show you a little bit about Epstein. This is an email from Jeffrey Epstein, June 2009, to redacted, which is, you're going to hear that word a lot. Have the girls stop to say goodbye on the way to the airport. Response from redacted. What time do you want them? They need to go to the airport at 5:30 so they will have time after they eat in 20 minutes until 5:30. Jeffrey. They need to be at the airport or leave for the airport at 5:30. Leave from here or from there. Your message is unclear. Girls. Jeffrey Epstein, email to redacted, May 3rd, 2009. Nadia tells me that you prefer not to come. Response from redacted. It's not what I prefer or don't prefer. I thought you want me to do something here in New York, not there, something that I can do meanwhile modeling. I'd maybe be able to come there for a weekend, though I guess you need me working days, right? Is that anything I can do to get you here? Jeffrey, don't worry. I just thought I would give you the opportunity to earn some money. You can do it when convenient, May, June, etc. Get a little flavor there of how he talks to the girls. Okay, this is unclear what this is, but I thought it was interesting because it shows Jeffrey's original writing and then how a lawyer rewrites it. Jeffrey Epstein to redacted, sent May 16, 2009. My version, he says. Dear Debbie, Rhiannon, or whatever your name really is, I've always been a friend to you, and in that vein must now request that you do not attempt to contact me again. We have been advised that there are both federal and state arrest warrants for you. I've been advised by counsel that if contacted again, I must and I will contact your probation officer in Montana and, if necessary, arrange for your rearrest. I wish you no harm, but am duty-bound to carry out the law, blah, blah, blah. And then in the same email, he includes the lawyer version. Dear Debbie, do by attempt to contact me in any way, including email, phone, or in person. I have been advised that a U.S. federal warrant for your arrest has been issued. Your case is now with the U.S. Marshal's Office for action. I am legally bound to assist them in any way I can, and I will do so. Be advised that the specifics of any attempt to contact me will be sent immediately to my attorney, who will notify the U.S. Marshal's Office and proper authorities for their disposition. Regards. Threats. And then finally, I will just read another, same vein, same tone. A young woman, it seems like, we don't know. Hey, Jeff, I'm staying in New York for a little in a good rhythm with Torah, working out and eating healthy. Jeffrey Epstein required all the girls to eat healthy. I started making those smoothie drink recipes your friend sent me. Really good. I was thinking the beginning of June to come to Palm Beach. I will let you know for sure. Hope all is well. Thanks. Jeffrey responds, great. Same woman. Hey, Jeff, I was just on the phone with Sandy I organized last week to talk to her today. I'm thrilled beyond belief to be going on this trip. Please don't think I'm not. This means so much to me, and this is the chance of a lifetime. Seriously, thank you a million times. I also was speaking to Maddie last week via email, and we were both on the same page about the trip. Jeffrey responds, where are you and what are you doing? Explain why it has been so difficult for you to find time to concentrate on something that was only for your benefit. It makes little sense. I read all of those because they give you a flavor. They don't necessarily point a finger at a particular perpetrator, but it gives you a sense of what was really going on inside these houses. To anyone watching, I want to simply say this in conclusion. Never underestimate the power of your own outrage. Virginia Roberts Giuffre grew up with little money. She didn't graduate from high school, and yet she dared to step forward to try to right the wrongs that she'd witnessed and suffered, and to try to make the world a better place. And she succeeded, simply by telling her story. Though she is tragically no longer with us, I'm inspired by that, and I hope others are too. And I'm also inspired by this exhibit. So, thank you for having me.
Thank you so much, Amy. We all are here, thanks to Virginia's bravery, and what you just said, never underestimate the power of your own outrage, really resonates with me. I think we should all be fueled by outrage at this, because look at all these volumes. So we are entering, we've been going at this for I think 5 hours now. We're 5 hours in. So in case you're just joining us, I'm Eliza Orlins, and in conjunction with the Save America movement, which is a nonprofit, we are here doing Cover to Cover Up. We are live streaming for 24 straight hours, reading the Epstein files live from the Donald J. Trump and Jeffrey Epstein reading room in Manhattan, and raising money for World Without Exploitation. You should see the QR code on screen if you'd like to donate. We are now joined by George Conway, one of the founders of the Lincoln Project and congressional candidate for New York's 12th congressional district. George, very good to have you. Do you want to just grab the open one right there in front of you? Perfect. Here's George. Thank you.
Thank you, and I'm honored to be here today. It's a moving experience to actually hold these volumes and to think of all the suffering and the pain that all the victims that was perpetrated on them throughout these many, many years. And I'm here because I've seen Donald Trump in action. I've read about Jeffrey Epstein, and I think that the level of misogyny and corruption is really something I don't think I could have imagined several years ago. But here it is, in black and white, in thousands of volumes. And I haven't picked anything in particular to read, but I'll just open to a page. From Redacted, Saturday, August 10, 2019, 11:57. To Michael Miller, Martin G. Weinberg, Reed Weingarten, C.C. Redacted. Ray, U.S. versus Epstein. Mike, Marty, Reed. Following up on my conversations with Mike and Marty this morning, and my discussion with Mike moments ago, attached is a press release just sent to us, and I believe also issued publicly some minutes ago. It represents all the information we have from BOP, I assume that's the Bureau of Prisons, so far, but of course, if we are successful in our outstanding efforts to obtain additional information, we will pass it on immediately. Separately, we can tell you that reports that an FBI investigation into the death has been initiated are accurate, and I fully expect an investigation to be extremely rigorous. As always, please don't hesitate to reach out to us directly at any time if that would be useful. From Redacted to Redacted Ray Invoice 1024685 for Redacted 2017 September 9, 2014. Date Friday 19 September 2014 16/18/27. Ah, that is fine then. Have her go to Redacted then. On September 19, 2014 at 12:13 p.m. Redacted wrote, "Thank you, Redacted. She still has her clothes" at 11J. On Friday, September 19, 2014, Redacted wrote, "Hi, Redacted. I have changed Redacted ticket to go back to Moscow on Sunday. She can stay in apartment Redacted. Code Redacted. I will hire our new car service we are testing out to pick her up on Sunday from 301 at 4:30 p.m. and take her to JFK. Once I confirm, I will send to you." On September 19, 2014 at 10:31 a.m., Redacted wrote, "Redacted. JE asked to move Redacted flight to Moscow back to Sunday. She goes from St. Thomas on Saturday and spend the night here and goes to Moscow on Sunday. Thank you. Envoyé de mon iPhone." On September 18, 2014 at 1:15 p.m., Redacted wrote, and it's an empty message, sent from my iPhone. Begin forwarded message. From American Express Travel, itinerary at mytravelplane.eu. Date September 18, 2014, 12:30:04 p.m. EDT. Subject, invoice 1024685 for Redacted 20 September 14. And the rest, the rest is just messages for, I guess it was just an attachment of the plane ticket. From Leslie Groff, redacted, to Jeffrey Epstein, jeevacation@gmail.com. Subject, Ray, Woody Allen. Date, Monday, 22 September 2014, 19:59:43. Ginny says she does not think Woody will be editing on Wednesday either. She said she will have to get back to us on this as well. On September 22, 2014, at 3:19 p.m., Jeffrey E., jeevacation@gmail.com, wrote, if not, then I will do 3:30 Wednesday. On Monday, September 20, 2014, at 2:55 p.m., Leslie Groff, redacted, wrote, below from Ginny. Hi, Leslie, I don't think we will be editing Thursday. I think I will be able to give you an answer on Wednesday. Ginny. From Leslie Groff, redacted, to Jeffrey E., jeevacation@gmail.com. Subject, Ray. Date, Monday, 15 September 2014, 13:16:05. Jeffrey! Exclamation point, exclamation point. I am still flying so incredibly high on this kind gift from you. All weekend long, I kept thinking about how happy I am and how much I love my job and you. Thank you so very much. When I told my girlfriend, redacted, she screamed with excitement, too. Really just the nicest gesture from you. I have Russell on the call list, exclamation point, XO, sent from my iPhone. On September 15, 2014, at 8:10 a.m., Jeffrey E., jeevacation@gmail.com, wrote, Florida holiday, my style, please. Five-star hotel spa, five-star hotel spa, the whole works. I would like to talk to your headhunter again. From Leslie Groff, redacted, to Woody Allen, redacted, subject, Jeffrey Epstein. Date, Thursday, 11 September 2014, 17:56:45. Hello, Ginny. Hope you have been able to catch up since your holiday. Might you be able to let me know what time would be good for Jeffrey to come watch Woody edit tomorrow? Also, wanted to confirm Woody will come to dinner at Jeffrey's home this Saturday, September 13th at 7 p.m. Can you please get back to me? Thanks, Leslie. From redacted, Friday, January 6, 2012, 11:47 p.m. To redacted, CC Rich Barnett, Jojo Luciano Fontanilla, Rosalind Fontanilla. Redacted, J.E. wanted me to tell you that Tom Barrack might come by on Monday with his friend, Ahmad, to 71st to see the house. J.E. said he should, to talk to you about what time he is planning on coming. Rich, can you please show them around? From Luciano Fontanilla, sent Wednesday, June 19, 2013, 2:59 p.m. to Karina Shuliak. On June 19, 2013, 10:56 a.m., Karina Shuliak, redacted, mailed to redacted, wrote, "Hi Jojo, Mr. Epstein would like you to take me and redacted to the airport on Friday, June 21st. The time has still not decided. It will be either early morning or afternoon. Please confirm the receipt of this message. Thank you, Karina." From Facebook, notification. Sent Tuesday, June 21st, 2011, 5:46 a.m. to Karina Shuliak. Subject, Scott Coppola tagged a photo of you on Facebook. Facebook. Hi, Karina. Scott tagged a photo of you in the album Mermaid Parade, June 18, 2011. Thanks, the Facebook team. From redacted, sent Monday, April 21, 2014, 12:49 a.m. to Karina Shuliak, CC redacted. Subject, J.E. toiletry bag. Hi, Karina. Great, thanks, smiley face. On Sunday, April 20, 2014, Karina Shuliak, redacted, wrote, "Hi, girls. FYI, J.E.'s toiletry bag is now a part of his black bag. All the toiletries are currently in the black leather bag with 2 zippers." Thank you.
George, thank you so much. Really appreciate you joining us here today. And just to reset everyone, we are here inside the Donald J. Trump and Jeffrey Epstein reading room, and I am now so honored to be joined by actor, activist, producer, entrepreneur, the one and only Sophia Bush. Sophia, thank you so much for joining us today. Would love for you to introduce yourself to everyone and let them know why participating in this live event was so important to you.
Okay. Thanks, darling.
Thank you.
Hello, everyone. My name is Sophia Bush. I'm overwhelmed being in this room. There are 4,000 of these. They're 800 pages apiece. They are heavily redacted. Every single one is evidence of something that happened to a woman, to a girl, to a child. I am here because I am angry, because this should never go away, because no conflict or stock trade or war should supersede this, because I know what it feels like to have what happened to you erased, as most of the women in my life do. We have a problem, and I think the only way we're going to solve it is to get some sunlight on it. So let's continue. Okay. From Paul Morris, redacted, to Leslie Groff, redacted, Friday, 12th of September, 2014. Importance, normal. Classification, confidential. Hi, is JE in New York City next week? Thanks. From Leslie Groff, redacted, to Jeffrey Epstein. Subject, Paul Morris, Friday, September 12th, 2014. Paul Morris is asking if you are in NY next week. From Jeffrey E. to Leslie Groff, redacted. RE Paul Morris, Friday, the 12th of September, 2014. No, week after. Leslie Groff wrote, Paul Morris is asking if you are in NY next week, and the bottom is redacted. From Leslie Groff, redacted, to redacted, subject Jeffrey Epstein, Friday, 12th September, 2014. Hello, Lisa. Might you be available to come and see Jeffrey at 1 p.m. on Tuesday, September 23rd. Jeffrey lives at 9 East 71st Street, between 5th and Madison. Please let me know. Thank you. Leslie, assistant to Jeffrey Epstein. From Leslie Groff, redacted, to Paul Morris, redacted, REC, Friday, 12th September, 2014. Hi, Paul. Jeffrey will not be in town next week. He will be in New York the week after, however. On September 12th, 2014, Paul Morris, redacted, wrote, redacted. From Pat Zwarzik, redacted, to Leslie Groff, redacted. Subject, RE Jeffrey Epstein. Friday, 12th September, 2014. Leslie, I'm checking with Martin and will let you know. Pat is the assistant to Martin O'Connor, Esquire, at O'Connor Morris O'Connor. An office in Elizabeth, New Jersey. Attachments to the email advising about current IRS standards. Interesting. From Leslie Groff to Pat. Subject, Jeffrey Epstein. Hello, Pat. Jeffrey would be available to chat with Martin today, sometime between 12 and 1 p.m. or 4 and 5 p.m. Might Martin have some time within these windows? Or feel free to suggest a time. Thanks, Leslie. Assistant to Jeffrey Epstein. Leslie replies again to Martin O'Connor, Friday, 12th of September, 2014. Great. Jeffrey now has from 12:30 to 1:20. From Paul Morris, redacted, to Leslie Groff, redacted, REC. Friday, 12th September, 2014. Okay. Had someone I wanted to introduce him to. Have a good weekend. From Leslie Groff to Paul Morris, Friday, 12th September 2014. Ah, okay. Will they not be here week of 22nd? The pages continue to repeat the threads I've already read to you. Apologies for the delay. From Lisa New, redacted, to Leslie Groff, redacted. Ari Jeffrey Epstein, Friday, 12th September 2014. This is perfect. Lisa. It appears Lisa's replying to an email sent earlier that day from Leslie Groff writing, "Hello, Lisa. Might you be available to come see Jeffrey at 1 p.m. on Tuesday, September 23rd? You've already heard where Jeffrey lives." So Lisa is agreeing. From redacted to Leslie Groff, redacted. Ari, redacted, is here, exclamation point. Great, thanks, Leslie. When I hear back from the designer, I'll share his feedback as well. I did not hear back from him yet, but I'm sure he'll call me sometime today. Thanks for getting him in. Smiley face. Russell Cadillac, Gemstone Associates, partner, 380 Lexington Avenue, New York, New York, 10168. From Leslie, mail to redacted, sent Friday, 12th September 2014. To redacted, subject RE redacted is here, exclamation point. Okay, thanks. Jeffrey did not meet with redacted all but 5 minutes. He told her he wants her to come back in a week. We will see. Take care and have a great weekend. On September 12th at 11:15 a.m., redacted, wrote, "Okay on all fronts. Do whatever you think is best. FYI, I have to run downtown for my meeting between 12:30 to 2:30. I will be back up here before 3 p.m. Also, my cell number is redacted in case you need it during off times, weekends, etc. I will have my phone off between those times today. Thanks for everything. Russell Cadillac, Gemstone Associates, partner." Leslie Groff, mail to redacted, sent Friday, September 12, 2014, to Russell. Subject, redacted is here, exclamation point. Redacted is here, all fine. JE is not aware. I don't think that she was delayed. JE is still speaking with Gregory, which is highly, all in caps, unusual. I think it is a good sign. From Paul Morris, redacted, to Leslie Groff, redacted. This is a repeat of the pages about the 22nd and Paul having someone he wanted to introduce Jeffrey to, assuming it's a reprint of the email thread. Aha. From Leslie Groff, redacted, to Lisa New, redacted, RE Jeffrey Epstein. Leslie Groff wrote, "Hello, Lisa." Ah, this is the reply. So the reply to "Hello, Lisa, might you be available to come see Jeffrey at 1 p.m. on Tuesday, September 23rd? And his address, please let me know." Lisa replied, "That is perfect." Leslie replied, "Great. Could you pass along your cell number, please? My number is," redacted. More of the same threads. Seeing who's replying. Speaking with Gregory. Around an hour later, an email from Pat Zwarzik, redacted, to Leslie Groff, redacted. Friday, September 12th, 2014. Leslie, I spoke to Martin and the best time for him would be 4 p.m. We will call Jeffrey. Advise what number would be best. Thanks. Pat Zwarzik, assistant to Martin B. O'Connor, Esquire. O'Connor, Morrison, O'Connor. I love that every one of these emails ends with a, "and destroy all copies of the original message warning." I bet. Lisa New redacted. To Leslie Groff redacted. Cell is redacted. In response to Leslie Groff's email, which is redacted, sent on Friday, September 12, 2014, to Pat Zwarzik about how Jeffrey now has from 12:30 to 1:20, there is a follow-up email from Leslie Groff, redacted, to Martin O'Connor, redacted, that says, should be good, have him call the office number, redacted. On the next page, Leslie Groff, redacted, replies to Lisa New, redacted. After Lisa sends her cell, which is redacted, and says, great, thanks. From David Mitchell, redacted, to Andrew Alterson, redacted, and Leslie Groff, redacted. Subject, no subject. Friday, 12th of September, 2014. Dear Leslie, please get some time with Jeffrey for Andrew so he can update him on AdFin. Andrew, Jeffrey is the principal behind AdFin's Investor Southern Trust. Andrew is the new CEO of AdFin, and I mentioned to JE this morning I would like him to meet. Thank you so much, David. David Mitchell, Mitchell Holdings, 801 Madison Avenue, New York, New York, 10065. Office line, redacted. Mobile number, redacted. From redacted to Leslie Groff, redacted. Friday, 12th September, 2014. Dear Leslie, greatest thank you for all information and also your opinion about the jumper, 3 exclamation points. I've decided to make 2 of it, in red and gray colors, exclamation point, smiley face. Thank you so much, exclamation point. Your words were so needed, exclamation point. I am heartily sorry that I didn't thank you immediately. I feel so bad. I am so busy before our big trip, but this is not an excuse. I am very grateful to you, Leslie, exclamation point. My redacted phone number is redacted, but as soon as I come redacted, I will get a local number. I will send you immediately, exclamation point. First, we are going to Chicago to see our family friend, and then we are coming to NYC, 3 exclamation points. The most exciting part of our trip, 3 exclamation points. I really do hope to see you, exclamation point. I could walk by your office and come over for 5 minutes. 3 exclamation points, smiley face. Best wishes from redacted, signed redacted. Leslie Groff, redacted, wrote, hello, redacted, ... I wanted to give you the details of the apartment for your stay, exclamation point. The apartments are located at 301 East 66th Street, corner of 66th and 2nd Ave. You will be staying in apartment redacted, the code to redacted. The doorman will have a welcome letter for you with your apartment and code printed on it as well. The Wi-Fi code for the apartment is redacted. If you could pass along your cell number, that would be super. I hope you have a wonderful time in NY, and I do hope to see you, exclamation point. Take care, Leslie, assistant to Jeffrey Epstein. To the aforeread email, when David Mitchell is looking to introduce JE to Andrew, Leslie then responds, redacted, to David Mitchell, redacted, and Andrew Alterson, redacted. Great, I'll be in touch, Andrew. From redacted, redacted, to redacted. Friday, 12th of September. At 12:19 p.m., redacted, 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 wrote, OMG, ... At 12:20 p.m., redacted, wrote, I'm glad you spoke up. And a few minutes later, also redacted, but you're shocked, The response is simply, and after yesterday's email, exclamation point, question mark, exclamation point. From Rosa da Silva, redacted, to Leslie Groff, redacted, redacted, subject, Jess. Hi, Leslie, and happy Friday. At your convenience, can you please let us know if J.E. is free to see Jess this afternoon? Jess should free up around 5:30 p.m. Many thanks, Rosa. Rosa da Silva, Blue Mountain Capital Management, LLC, 280 Park Avenue, 12th floor, New York, 10017. I have to try to make sense of this, everyone. Sorry, this is so heavily redacted, I can't figure out what order these emails go in. Okay. On September 12th, 2014 at 12:54 p.m., Ballerina, redacted, wrote, Dear Redacted, greatest thank you for all information. And we're back to the jumper. I see. Top of the page is the response to such, which is from redacted to redacted and then another redacted. Thank you, redacted. I think your idea of one red and one gray is perfect. Smiley face. I love Chicago. Exclamation point. I hope you have a great time there as well. See you shortly. Exclamation point. Next page. In response to the email inquiry about J.E. being free to see Jess, Leslie Groff, redacted, wrote back to Jess Staley, redacted. Yes, happy Friday to you too! Exclamation point. I will get back to you. R-E-J-E and availability. The next page is from redacted to redacted to redacted to redacted to redacted. Subject new email redacted, redacted. And then we got nothing. Next page. Leslie Groff, redacted, to Jeffrey Epstein. Subject, Jess Staley. Jess Staley is asking if you would have time to see him this afternoon. He should free up around 5:30, ... 1:20 p.m., meet redacted and redacted at the corner of 63rd and Park. 1 to 5 p.m., go see Woody edit his movie at the Manhattan Film Center, located at 575 Park Avenue between 62nd and 63rd, redacted. All caps, JoJo to drive you. 4 p.m., all caps, phone date with Martin O'Connor. He will call the office line, in parentheses. 5 p.m., in all caps, phone date with George Church, redacted. 6 p.m., appointment with Boris Nikolic, redacted. From Jeffrey E. to redacted, R.E. Jess Staley. Yes, of course. Course, spelled C-O-U-R-E-S. It's a wonder the people controlling billions can't afford fucking spell check. Next page. From Leslie Groff, redacted, to Rosa da Silva, redacted. Jeffrey would love for Jess to come by. Would 6:30 be good? Question mark. A second email from Leslie Groff, redacted, to Jess Staley, redacted. Or 5:30. That is fine too. He has Boris Nikolic coming at 6. I think Jess knows him. Bet he does. Okay. From redacted to Larry Vysotsky, Larry, redacted, CC, redacted. Redacted, redacted, redacted. Next. Redacted, 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 redacted. Next line. Redacted, redacted, redacted again. Darren Indike, redacted. Bella Klein, redacted. Daphne Wallace, redacted. Anne Rodriguez, redacted. Subject, Sunday, Wheels Up around 3:30, 4 p.m. Jeffrey says he would like Wheels Up around 3:30, 4 p.m. on Sunday, September 14th to the island. From Rosa De Silva, redacted, to Leslie Groff, redacted. In response to the 5:30 is fine too, Boris Nikolic coming at 6, I think Jess knows him email. Rosa writes, Jess will be there at 5:30 p.m. Thanks, redacted, and have a great weekend. Signed, Rosa. From Leslie Groff, redacted, to Bob Carey, redacted. RE 914, lunch. Jeffrey Epstein and Senator Bob Carey. Jen, Peter Thiel will be at the lunch on Sunday, plus, quote, a few others, end quote. Jeffrey said he'll tell me later today, ... So once again, I will be back to you. That email was sent in response to an email from Jennifer Hill, redacted, which wrote, yes, thank you. Can you kindly let me know who will be in attendance? Best, Jen. That was a response to Leslie asking, Jennifer, could Senator Kerry come for lunch on Sunday, September 14th at 12:30? Jeffrey's home address is 9 East 71st Street between 5th and Madison. That email was written in response. I should really start from the bottom and go up, guys. To Jennifer Hill asking, Leslie, sorry to bother you. I'm checking on the potential dinner for this weekend. I'm trying to firm up Senator Kerry's weekend calendar. Thank you! Exclamation point. Jen. Leslie Groff writes, super. Appreciate your patience. Smiley face. To which Jen writes, of course, thank you. All of their emails are, of course, redacted. I feel like you get it by now. The earlier email chain started on Tuesday, September 9th. Jennifer Hill writing to Leslie, it seems. No, hold on. I see, bottom of the page. Leslie writing to Jennifer. Hello, Jennifer, still hammering out the details. Can we get back to you on this? She wrote that because Jennifer had emailed earlier saying, Leslie, good afternoon. I'm just following up for dinner on either Saturday or Sunday of this week. Thank you, Jen. Wild that so many people wanted to have dinner with this guy. Leslie and Jen go back and forth for a while. Let's see. Their email chain, it appears, actually began on September 2nd with Leslie Groff, redacted, writing, hello, Bob. Jeffrey is having Peter Thiel and possibly Bill Burns for lunch at his home in New York on Saturday, September 13th and Sunday, September 14th. Jeffrey is asking if you might be available to join, ... Please let me know, exclamation point. Thank you, Leslie, assistant to Jeffrey Epstein. September 2nd, Bob Carey responds, redacted, of course. Leslie, I think both work, but let me double check with Jen. Bob. Leslie Groff then responds, redacted, to Bob Carey and adds Jennifer Hill on CC. Great, thank you. The next day, September 3rd, 2014, 8:55 a.m., Jennifer Hill, redacted, writes, Leslie, we're just confirming a couple plans for that weekend. I'll respond today with an answer, exclamation point, thank you, Jen. Same day, 9:02 a.m., Leslie Groff, redacted, writes, super, thanks, sent from my iPhone. September 4th, 8:18 a.m., Jennifer Hill, redacted, writes, Leslie, sorry for the delay. Bob is available either date. At your convenience, kindly email to me the details once confirmed. Thank you, Jen. Leslie responds less than an hour later. Excellent! Exclamation point. I'll get back to you. Thank you for your help. September 9th, Jennifer Hill writes, here we go. Leslie, good afternoon. I'm just following up on the dinner for either Saturday or Sunday of this week. Thank you, Jen. You've heard what came after that. you think they could put these in order for us? Let's see, how far back does this go? We're back to, or 5:30, that's fine too. He has Boris Nikolic coming at 6. It's responded to by Leslie Groff to Jess Staley. Redacted, redacted, great! Exclamation point. From redacted to Jeffrey E. Friday, September 12th, 2014. I put the black box in the safe. From redacted to redacted. Bet you are. A simple reply, 3 letters, THX, for thanks. We're back to the top of the Peter Thiel thread on September 12th, 2014. Leslie Groff redacted, as you'll recall, wrote Jen, Peter Thiel will be at the lunch on Sunday, plus a few others. Jeffrey said he will tell me later today, ... So once again, I will be back to you, exclamation point. It's responded to by Jennifer Hill, redacted, who says, that is fine, thanks again, exclamation point. It's wild how they plotted the world's ending so joyfully and with so many typos. Okay, from Larry Vysotsky, redacted, to redacted, 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 redacted. Next line, redacted, 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 redacted. Next line, redacted, redacted, redacted. Rich Kahn, redacted. Garen Indike, redacted. Bella Klein, redacted. Daphne Wallace, redacted. Ann Rodriguez, redacted. R.E. Sunday wheels up around 3:34 p.m. Thank you, redacted. Teterboro Airport, I would assume. Meridian Aviation. A period and a comma. Guess they couldn't decide. The plane is in Islip, New York. I will fly it early Sunday morning to Teterboro for Jeffrey's departure. From Leslie Groff, redacted, to Jeffrey Epstein, subject, Kathy Rumler. Below, from Kathy Rumler, hi Leslie. Cass and Samantha cannot do dinner on Saturday, but Cass and I will join Jeffrey for lunch on Sunday. Unfortunately, Samantha cannot join on Sunday because of her responsibilities at the UN. Does that work? Question mark. Thanks! Exclamation point. So let's see. I think I made it about 35 pages. It's 800 pages a book. 4,000 of these books in here. This is not going away. Thanks for having me. You're amazing.
Sophia, thank you so much for reading for us. And I'm so grateful that so many people have been able to join for this 24-hour filibuster-style reading of the Epstein files. Here we are inside the Donald J. Trump and Jeffrey Epstein reading room in Lower Manhattan, where we are live streaming for 24 straight hours. We are approaching the 6-hour mark. I am just really grateful that everyone is participating in this important event. And I am so excited that we are now joined by an incredible actor and activist, Samantha Mathis. Samantha, thank you so much for being here.
Thank you so much for having me. I'm really honored to be here. I'm just going to read a short little statement that I wrote. The Epstein Files Transparency Act, passed by Congress and signed by the President of the United States, specifically states that no record can be delayed or redacted based on embarrassment, reputational harm, or political sensitivity, specifically noting that it cannot be applied to any government official, public figure, or foreign dignitary. The President of the United States and the Justice Department have failed to live up to that promise. This administration just seems to think that they can wear us down, that the will of the American people is not strong. But we're still here, and I'm just so honored to be here with everyone. It's my honor, and I'm here to honor the survivors. Should I be reading from and to? From and to? Yes. Okay, here we go. From Tazia Smith to Leslie Groff. Subject, DB, call, Monday, 9 EST. Date, Friday, 12 September 2024. The hour of 1844 and 45 seconds. Importance, normal. Classification, internal communication, correct. Tazia Smith, Director, Key Client Partners, U.S. Deutsche Bank Securities Incorporated. Deutsche Asset and Wealth Management, 345 Park Avenue, 26th floor. New York, New York, 10154. Telephone, redacted. Mobile, redacted. Fax, redacted. And email, redacted. From Leslie, redacted. Sent 9/12/24, 10:13 a.m. AST to Tazia Smith. Subject, DB call, Monday, 9 a.m. Eastern Standard Time. Hi, Tazia. I just want to confirm with you the following. The call will consist of you, Paul Morris, and Stilius Theodoisoi. The dial-in number is redacted. And the PIN is redacted. But what is redacted? It's a lot of redaction. Thanks, Leslie. On September 11th, 2024, at 7:32 p.m., Tazia Smith wrote, classification, external communication. Hi, Leslie. 9 to 10 a.m. Eastern Standard, Monday, works for London. We'll send through a calendar invite and a dial-in. Thanks, as always, for your help. Tazia Smith, Director, Key Client Partners, U.S. Deutsche Bank Securities Incorporated, Deutsche Asset and Wealth Management, 345 Park Avenue, 26th floor, New York, New York, 10154. Telephone redacted, mobile redacted, fax redacted, email redacted. This communication may contain confidential and/or privileged information. If you are not the intended recipient or have received this communication in error, please notify the sender immediately and destroy this communication. Any unauthorized copying, disclosure, or distribution of the material in this communication is strictly forbidden. Deutsche Bank does not render legal or tax advice, and the information contained in this communication should not be regarded as such. From redacted to Leslie Groff, again, redacted. Subject blank, redacted, is here. Date, Friday, 12 September 2014. Hi, Leslie. I just got back. I spoke to Gregory. He is very interested in and enjoyed meeting Jeffrey. Russell Katulak, Gemstone Associates, partner, 380 Lexington Avenue, New York, New York, 10168, Suite 1700. Redacted, 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 direct, fax, redacted. From Leslie, sent Friday, September 12th, 2024, 12:11 p.m. to Russell. Redacted is here. Great, thank you. On September 12th, 2024, at 12:04 p.m., redacted wrote, Great, thanks, Leslie. When I hear back from the designer, I will share his feedback as well. I did not hear back from him yet, but I'm sure he will call me sometime today. Thanks for getting him in. Smiley face. Russell Katulak, Gemstone Associates, partner, 380 Lexington Avenue, New York, New York, 10168, Suite 1700. Redacted, redacted, direct, redacted, redacted, fax. Original message from Leslie. Sent Friday, September 12th, 2014 at 11:22 a.m. to redacted. Subject redacted is here. Okay, thanks. Jeffrey did not meet with redacted. All but 5 minutes. He told her he wants her to come back in a week. We will see. Take care and have a great weekend. On September 12th, 2014 at 11:15 a.m., redacted wrote, okay, on all fronts, do whatever you think is best. FYI, I have to run downtown for a meeting between 12:30 and 2:30. I will be back here before 3 p.m. Also, my cell phone number is redacted. In case you need it during off times, weekends, etc., I will have my phone off between those times today. Thanks for everything. Russell Katulak, Gemstone Associates, partner, 380 Lexington Avenue, New York, New York, 10168, Suite 1700. Redacted direct, redacted fax. From Leslie, sent Friday, September 12th, 2014 at 11:05 a.m. to Russell. Subject, redacted is here. Redacted is here. All is fine. J.E. is not aware. I don't think that she was delayed. J.E. is still speaking with Gregory, which is highly unusual. I think it is a good sign. From Leslie Groff to Russell, subject, blank is here. Friday, September 12th, 2014 at 19:06, 34 seconds. Great to hear. Thanks. On September 12th, 2014 at 2:49 p.m., redacted wrote, hi, Leslie. I just got back. I spoke to Gregory. He is very interested and enjoyed meeting Jeffrey. Russell Katulak, Gemstone Associates, partner. Redacted direct, fax redacted. From Leslie, sent Friday, September 12th, 2014 at 12:11 p.m. to Russell, redacted is here. Great, thank you. On September 12th, 2014, at 12:04 p.m., redacted wrote, great, thanks, Leslie. When I hear back from the designer, I will share his feedback as well. I did not hear back from him yet, but I'm sure he will call me sometime today. Thanks for getting him in, smiley face. Russell Katulak, Gemstone Associates. From redacted, sent Friday, September 12th, 2014, 11:22 a.m. Subject, redacted is here. Okay, thanks. Jeffrey did not meet with redacted. All but 5 minutes. He told her he wants her to come back in a week. We will see. Take care and have a great weekend. Seems like a bit of a repetition. From redacted to redacted, Jeannie Brennan, redacted, Anne Rodriguez, and redacted, Cece Rich Khan, and redacted. Subject, very important envelope. Date, Friday, 12 September 2014. I have an envelope on my desk that is very important. It must go with you on the airplane this Sunday and given to redacted. in Jeffrey's office on St. Thomas. Please see me when you come back to the house to retrieve this envelope and then keep it with you. Make sure it goes with you on Sunday. I'm sure Anna can help you. Redacted. With logistics. Please confirm back to me. Thanks. Redacted. From Leslie to Leisure Fitness Superstar, CC Rich Khan, again, redacted. Also Bella Klein, and also redacted. Subject, receipt from Leisure Fitness Supercenter, or Superstar. Date Friday, 12 September 2014. Hi, Nat. I spoke with Jeffrey, and he most definitely wants to have Priva set up as well at the time of installation. Thanks, Leslie. On September 12, 2014 at 9:31 a.m., Leisure Fitness Superstar. Leslie attaches the transaction information for the swap. I will be sending an itemized invoice in a separate email. Receipt as follows: Leisure Fitness Paramus, type purchase, American Express, $5,934.77. Cardholder name, Jeffrey E. Epstein. Date and time, 12 September 14. Reference, author, transfer approved. Thank you, signature. You finished that book. But wait, there's more. I don't know what you've read, so yes, hand me a new one. Great. Anywhere? The beginning. Okay. To Ghislaine Maxwell. And redacted. From redacted. Subject, see you in New York. Sent Saturday, 7 February 2024. Exflode. Hi, Ghislaine. It was good to hear from you the other day. I thought I'd fill you in on my situation and see how we can work together. I am still dancing, Pilatesing, and teaching. I am very interested to keep training Jeffrey as we work well together, and I enjoy working with him. I understand he likes to work with a variety of beautiful, talented young women. And I think that training with lots of people can be a very good thing. I understand what I am looking for in other people to train, work with him, and it's quite a tall order, which is why I know that you need some help to find people. They don't come along every day. I need to use my time effectively to continue with my dance classes, learning, training, and also earning money to pay for it all. If I am looking for girls, I will need to go to a wide variety of classes, whereas at the moment I tend to stick to the ones I like. Not necessarily the ones to find suitable girls. So if you want me to be actively looking, then we will need to reach a financial agreement, as this will be my job. Or if you just want me to let you know if I come across someone suitable in my travels, then what will you pay me for this? as I am effectively doing myself out of a job. I would just like to have a good idea of where I stand, and if I will be getting more work from you, or if you can put me in touch with other people who want a trainer. Or if I can make looking for other people my main source of income. As I am here properly now, I have bills and rent to pay. I need to find something stable. I can be available to travel, but if I am on call, I need to know and be paid accordingly. I have a couple of girls in mind. So let me know what arrangement we will have, and I will do my best to help. I am appreciative of any work you can throw my way. I look forward to seeing you when you're back in New York City. Give my best to rainy England. Love, redacted. P.S. Do you want a lesson? This is from an attorney at law, H. Doane Williams, Jr. Over 45 years experience, Martindale, Hubble, AV, rated trials and appeals, state and federal courts, July 19, 2019. U.S. Attorney's Office, USA v. Jeffrey Epstein. Dear redacted. The bullet Epstein dodged that no one is talking about. He did so because of the combined actions of the former U.S. Attorney Alexander Acosta, former Palm Beach County State Attorney Barry Krischer, the Palm Beach County Sheriff's Office, and the Assistant State's Attorneys that handled Jeffrey Epstein's criminal prosecution in state court. At his plea and sentencing, the judge asked why Epstein was going to serve his sentence in the Palm Beach County stockade instead of in a Florida state prison, like most sex offenders. The response was, we just decided that this was the best way to accomplish what we needed to be done here, and agreed that the sentence satisfied everyone's requirements. His carefully constructed plea and sentence accomplished Epstein avoiding the Jimmy Rice Act relating to the indefinite civil commitment of sexual predators. If he had been eligible for Jimmy Rice commitment, there is a substantial likelihood that he would have been indefinitely committed and warehoused with other sexual predators. Epstein was charged with 2 felony offenses. 1, procuring a person under the age of 18 for prostitution, a second-degree felony, punishable by 15 years in prison, and 2, felony solicitation of prostitution, a third-degree felony, punishable by 5 years in prison. He was facing a maximum consecutive sentence of 20 years in prison. Florida, like the federal courts, has sentencing guidelines. Epstein's guidelines calculated the, quote, lowest permissible prison sentence of 21.5 months, or almost 2 years in state prison. In Florida, the court can go below the lowest permissible range via a motion for downward departure or plea bargain. Epstein avoided a 21.5 month prison system via plea bargain. Oh my, this is many pages. To understand how he avoided the Jimmy Rice Act, you need to look at this carefully constructed sentence. According to the plea sheet he signed, regarding his conviction for felony solicitation of prostitution, he was sentenced to 12 months in county jail. Regarding is a conviction for procuring a person under the age of 18 for prostitution, a second-degree felony, he was sentenced to 6 months county jail, consecutive to the above 12-month sentence. And that term of incarceration was to be followed 12 months community control. In other words, he was sentenced to 18 months incarceration in the county jail. What if he had been sentenced to 18 months in prison instead of the county jail? In 2008, the Jimmy Rice provided that to be eligible for indefinite civil commitment as a sexual predator, the person had to be, quote, serving a sentence in the custody of the Department of Corrections, a person who was adjudicated delinquent and is committed to the custody of the Department of Juvenile Justice, or a person who was involuntarily committed to the custody of the Department of Children and Family Services upon an adjudication of not guilty by reason of insanity. Defendants that might satisfy the definition of a sexual predator were excluded from consideration if they were serving their time in a county jail. I have defended sex offenders and men being prosecuted under the Jimmy Rice Act. In 2005-06, as an assistant public defender, I defended about 25 men being prosecuted under the Jimmy Rice Act. I advised young public defenders to have sex crime offenders take time in county jail for this very reason. In 2008, an experienced sex crimes prosecutor would have been aware of this county jail loophole. If they say they were not aware of this loophole, then they are incompetent or untruthful. In 2014, this loophole was closed. The above section was amended to include a person who is serving a sentence in a county or municipal jail for a sexually violent offense. Now, a defendant cannot avoid the Jimmy Rice Act by doing his time in the county jail, like Epstein. For purposes of the Jimmy Rice Act, a sexually violent offense includes any criminal act that is subsequently determined to be proven beyond a reasonable doubt to have been, quote, sexually motivated. A, quote, sexually motivated crime is one whose purpose, in part, was for sexual gratification. Certainly, prostitution-related offenses, and particularly with the facts of his case, were committed in part for sexual gratification. The misnomer is that the violence does not have to be an element of the crime. If Epstein had been in prison instead of in county jail, the Department of Children and Family multiple disciplinary team would have evaluated Epstein and submitted its written assessment and recommendation to the state attorney, Barry Krishner. Epstein would have been back in the state attorney's lap for filing a petition to seek his indefinite civil commitment. Once a petition is filed, the offender is held in custody at a Florida Civil Commitment Center. There is no bond bail. Having tried these cases representing the defendant, the case is a battle of experts. The 6-person jury must unanimously find by clear and convincing evidence whether the person has the requisite prior conviction, has a mental abnormality affecting a person's emotional or volitional capacity, which predisposes the person to a sex offense, and is likely to engage in further sex crime to such a degree as to pose a menace to the health and safety of others unless he is indefinitely confined for treatment. This potential rabbit hole was avoided simply by where Epstein was incarcerated. In determining whether Epstein would satisfy the criteria for the state attorney to file a petition for involuntary commitment, the psychiatrist evaluators use a diagnostic tool known as Static 99. It is used throughout the United States and Canada. See the attached Static 99 form. Plus, the evaluators can go behind the mere charges that he pled to. Having a familiarity with Static 99 evaluation forms while representing men who had petitions filed against them based on the Static 99, Epstein arguably qualified for the filing of a petition. I am not an expert, but I rough calculated his score using the sheet applicable at his time of the plea as 4, which translates to a moderate to high risk of reoffending. If Epstein was sentenced to state prison by State Attorney Krishner, there's a likelihood he would have been back in front of the same state attorney for potential indefinite civil commitment. Instead of recently returning from France, Epstein might still be at the facility in Arcadia, Florida, with over 600 other sexual offenders. Florida has more people committed than any other state. There are other anomalies in the handling of this case. He was indicted for the first charge in the federal system. Felony prosecution is initiated by indictment, or the prosecutor and the defense agree to the file of an information charging a specific crime. In Florida, the only crime that requires an indictment is first-degree murder. In Florida, the state attorney is referred to as a one-man grand jury, because the state attorney can, with the stroke of a pen, initiate a criminal prosecution for any crime other than first-degree murder. Over 98% of crimes in Florida are charged by information filed by an assistant state attorney. According to the Miami Herald article, Detective Carey also told the Miami Herald that in May of 2006, he drew up probable cause affidavits that charged Epstein and 3 associates with a slew of sex crimes. But instead of pushing forward with the case, Kreischer referred the case to the grand jury, which returned an indictment on a single count of soliciting prostitution. In Florida state court, the prosecutor frames the charge it wants to the grand jury to consider and brings an indictment and the applicable law and instructions. I would be curious how many indictments in Palm Beach County in 2005-2006 were returned for crimes other than first-degree murder cases. How many sex crimes prosecutions were initiated by an indictment? These questions a federal prosecutor unfamiliar with our state system might not ask. It's all very curious, isn't it? I'm really honored to be here. And we've got our next reader. Thank you for watching. It's really important that you're watching.
Thank you, Samantha. That was Amazing. So if you're just joining, thank you for being here. We have crossed the 6-hour mark. I'm Eliza Orlins, and I am here for 24 hours with the Save America movement. We are doing this for 24 hours of live reading from the Donald J. Trump and Jeffrey Epstein reading room here in Lower Manhattan. I just want to contextualize this for a second before I bring up our next reader. So, we're sitting here reading these volumes, and even though we're going to read for 24 hours without stopping, we are barely going to get through a single entire volume. We're skipping around a bit. You'll see we're bringing up different volumes. But if we were to read every single volume in this place, nearly 4,000 volumes, each with 800 pages, even if we read for 24 hours a day, it would take us about 4.5 years of live streaming to get through all of these pages. And mind you, there is still documents outstanding. And so I just wanted to put that in context because the gravity of this is such a huge magnitude. And what we're going to be able to do in this 24 hours is just barely a drop in the bucket. But we hope that you will share this stream. We hope that you will tell people about this because we need eyes on this story. We are not going to let this story die. So we are so fortunate for our next reader to have actor and activist Asia Kate Dillon with us tonight. Asia, thank you so much for being here and for reading. Here, let me take away some of these for you.
Thank you so much for having me. I'm participating in this reading because I myself am a survivor of childhood sexual abuse, and because nearly 1,400 survivors spoke the truth, and the national media, the Department of Justice, and this administration have failed them. Cover to Cover Up exists to make sure that failure does not go unnoticed. It is an honor to be here to honor the survivors. I'll begin by reading from a document titled Narrative Number 36. It's dated January 23rd, 2006. Reported by Redacted, entered by Redacted. On January 19th, 2006, Detective Redacted and I met with Redacted at Redacted in Palm Beach Gardens. Redacted was identified as a licensed massage therapist who had previously been seen on Epstein's property when physical surveillance was done. Redacted was told of an ongoing investigation, and I felt she may have information pertaining to the case. During a sworn taped statement, Redacted stated she met Epstein 3 years ago when Ghislaine Maxwell approached her while she was attending Redacted to work around Epstein's house. Maxwell had told her that they needed some girls to work at the house to answer phones and run errands. Redacted accepted the job and began working at Epstein's house on El Brillo in Palm Beach. Redacted stated it was a part-time job during the time she went to Redacted. She continued going to Epstein's house and would be notified when Epstein would travel to Palm Beach. Redacted advised she would be notified by Maxwell, Epstein, or Redacted, his assistant, when he would travel to Palm Beach. Redacted stated she began providing massages to Epstein before she became a massage therapist. She continued giving massages not only to Epstein, but to Redacted, Redacted, and Redacted, his assistant. Redacted was asked about what occurred during the massages. Redacted stated, as she was 23 years old when she met Epstein, anything that happened was between two consenting adults. I explained to her she was not in any trouble. However, as part of this investigation, I needed to ask certain questions. Redacted stated that there were times that Epstein would ask her to perform during the massage. He would instruct her to Redacted. Redacted stated she felt grossed out about the behavior, but as she was getting paid, she just continued. Redacted also advised she would on occasion perform the massages naked. Epstein would on occasion utilize the redacted when she performed the massages. Redacted explained that Epstein never exposed himself to her, as he maintained himself covered under the towel he would be wearing. When Epstein would masturbate, he would be covered. I asked if Redacted ever received any gifts or any gratuities from Epstein. Redacted advised, aside from being paid well, she advised Epstein took care of her tuition from Redacted College. She received a rental car for a week when her scooter broke down. Additionally, she received other gifts from Epstein. Epstein also recommended her to another client who resides at Redacted in Palm Beach. The client she was referred to was Redacted, unknown last name, and his wife, who she provided a massage to. The statement was concluded and placed into evidence upon our return to the Palm Beach Police Department. While at the police station, I researched Florida tag Redacted, which was also previously seen on the property when there was physical surveillance being done at the property. The vehicle is registered to Redacted of Lake Worth, Florida. Researching Mr. Redacted and the vehicle revealed that his daughter, Redacted, had been redacted. The vehicle is a Redacted. I researched Redacted, date of birth, Redacted resides at Redacted in Lake Worth. Redacted has a MySpace page called www.myspace.com/redacted. In her web page, it shows various photos of Redacted photographed at a beach. An interview is forthcoming. A review of the video discs, which was extracted at the Palm Beach County Sheriff's Office Computer Crime Unit, revealed that only one hidden camera was functional at the time. Several images of Epstein working at his office were seen. Additional footage of Redacted, Redacted, and Redacted was seen. There was other footage of females seen. The identity of the females is unknown at this time, until such time as I meet with certain females to show the video footage to confirm if, in fact, it is them on the video. At this time, it appears that Redacted, and Redacted are seen sitting with Epstein beside his desk in the evening hours. Due to poor lighting, a direct confirmation cannot be made at this time. Interview continues. The next document is titled Narrative Number 37. It is a Palm Beach Police report, an incident report from January 30th, 2006. Reported by Redacted, entered by Redacted. On January 25th, 2006, Detective Redacted and I responded to Redacted in Lake Worth and met with Redacted. Redacted stated last year, when she was 17 years of age, she met Jeffrey Epstein through her former roommate. Redacted was allegedly dating Epstein at the time. Redacted and Redacted had once cohabitated together when they modeled. Redacted explained Redacted called her on her telephone and advised her that she was in Palm Beach and requested to see her. Redacted made arrangements to meet with her at Epstein's house. Redacted arrived and met Epstein, and Redacted went to the Palm Beach Mall together and went shopping. Redacted advised that Redacted and she had received money from Epstein to go to the mall. They visited Victoria's Secret and purchased undergarments from the store, utilizing monies given by Epstein. Redacted advised she purchased one item, and Redacted purchased various items. The money used to purchase the items was the money given by Epstein. Redacted and Redacted continued shopping and having a day together. Redacted stated, Redacted explained how she and Epstein have been dating each other and he has been paying all of her bills. Redacted claimed, Redacted advised they met in New York and had been dating ever since. They later returned to Epstein's home and encountered Epstein. He had a brief conversation with Redacted about her modeling career. He knew of her modeling career from Redacted. He requested to see her modeling portfolio and explained he could help her with her modeling jobs. Redacted had her book with her to show, and Redacted and showed the book to Epstein. He commented negatively about her photographs and portfolio. Redacted felt uncomfortable with the comments made, as she had been working with other professional modeling companies who had offered her work from her photographs. Epstein requested to see what was purchased at the mall. Redacted took out the undergarments, which were purchased. She immediately showed Epstein different sets purchased. Epstein then requested to view what Redacted purchased. Redacted was reluctant to show the outfit. However, since it was Epstein's money that purchased the item, she pulled it out of the bag. Epstein asked her to try it on. Redacted looked at Burns, who told her, quote, "Yeah, try it on," unquote. Feeling compelled to try the undergarment outfit on, she went to another room and put on the bra and panty set. She walked out to the living room where they were sitting and modeled the suit. She then went back into the other room and changed back into her clothes. Redacted returned into the room and told Redacted she would be going home. Redacted scheduled another day for Redacted to return for massages with her. Redacted stated that within the same week she returned to meet with Redacted and have a massage. Redacted had told her that she would be unable to stay with her as she would be going on a bike ride with Epstein. Redacted explained she could only stay at the house and take advantage of the massage. Redacted stated she met with an unknown massage therapist and had the table already set up in a guest room. Redacted removed her clothing, leaving her panties on, and wrapped herself with a towel for the massage. Redacted remembered that the door to the guest room was closed but not locked. As the therapist was working her back, the door was opened by Epstein and entered into the room. Redacted was trying to conceal herself as Epstein was talking to her about his chiropractic session. Epstein told Eaton, "Turn over onto her back." Redacted eventually turned over, exposing her breasts to Epstein as he applied pressure on her shoulder and her waist. Redacted stated Epstein, quote, "popped," unquote, her back. Redacted removed herself from the table, got dressed, and left the house. Eaton further stated Redacted had attempted to call her on several occasions to invite her back to Epstein's house, to which Redacted replied, quote, "I'm busy." Redacted advised she had not had contact with either Redacted, or Jeffrey Epstein. It should be noted that her mother, Redacted, was present during the interview. The interview was concluded, and we thanked them for their time. Narrative number 38, dated January 31st, 2006. Reported by Redacted, entered by Redacted. On January 27th, 2006, I made telephone contact with Redacted at Redacted. Redacted is a licensed massage therapist who had frequented the home of Jeffrey Epstein. Ms. Redacted had been unable to meet with me in Palm Beach County, and because she lives and works in Port St. Lucie, a telephone interview was conducted. I explained to Ms. Redacted that there was an ongoing investigation involving Jeffrey Epstein. Redacted stated she knows Epstein and has been employed by him for approximately 3 years. Epstein has paid Redacted to perform Swedish massages, deep tissue, on him and other guests. Redacted explained that approximately 3 years ago she met Ghislaine Maxwell and Jeffrey Epstein through a mutual friend. Epstein and Maxwell were looking for a massage therapist. Redacted stated, since that time, she is notified when Epstein is coming to Palm Beach. Redacted stated she comes to his house and provides the massage or massages. Redacted explained she has also massaged his guests and assistants. Redacted continued that she is paid $100 an hour for the massage. I asked Redacted if anything occurred during the massage that would have made her feel uncomfortable. Redacted stated she only provided massages, and that was it. She was never approached for anything else. I asked if Epstein ever asked to rub his chest. She stated she would not rub his chest and that was not part of her massage. Redacted explained that she was not Epstein's type. The girls she would see at Epstein's house were very thin, beautiful, and without tattoos. Redacted explained she had several tattoos that are visible. Maxwell and Epstein have commented negatively about her tattoos previously when she has provided massages. Redacted stated she only provided massages for Epstein and his associates and nothing happened during those massages. Redacted stated, as she does Swedish-style massages, the patient is usually sore after the massages. I thanked her for her assistance, and the interview was concluded at this time. I received a facsimile from Redacted service on telephone number Redacted, which is assigned to Redacted, pilot for Mr. Epstein, who resides in Lake Worth. Redacted telephone number was dialed on several occasions by Redacted. A background on Redacted indicated he has a valid FAA pilot license first class for the Southern FAA region. Redacted has another historical FAA license for airline transport pilot. Investigation continues. This is from narrative number 39, February 14th, 2006, reported by, entered by. I'll finish up this last narrative. On Friday, February 3rd, 2006, I had made arrangements to meet with Redacted at the Palm Beach police station. At approximately 1 p.m., Redacted and her friend, Redacted, arrived at the police station. During an interview with Redacted, she stated she met Epstein when she turned 18 years old and was brought to Epstein's house to provide a massage. She advised this occurred on May of 2005. She advised Redacted had informed her if she wanted to provide a massage for $200. Redacted agreed and was brought to Epstein's house to provide a massage. Redacted stated she had been to the house on many occasions during the massage sessions. Redacted also stated she would remove her clothing to provide the massage on Epstein. Redacted advised Epstein would pay her $300 to rub his back, legs, and chest. During the massages, Epstein would masturbate himself as she rubbed his chest. I asked her if Epstein ever redacted during the massages. Redacted replied, quote, yes. I asked her if Epstein ever redacted. Redacted stated he redacted. I asked her if he ever redacted. Redacted stated that during a massage, redacted. She stated this occurred only one time. Redacted stated the massage would be over when Epstein would climax onto a towel. I asked Redacted if she had any formal massage training, to which she replied she did not. Redacted was then asked if she ever brought anyone to the house to, quote, work. Redacted stated she brought 2 people to the house. She advised she received money for bringing people to the house to, quote, work. Redacted stated she brought a girl named Redacted and her friend Redacted. Redacted was still waiting for Redacted in the lobby of the police station. I thanked Redacted for her time and her cooperation and escorted her to the lobby. Thank you again for having me. It was an honor to be here.
Thank you, Asia Kate. We really appreciate you taking the time to read. And up next, we are joined by some wonderful folks. Number one is Rye Howard Stone, who is the founder of EpsteinData.com, which is, if you don't already know, an online website that makes the entirety of the files released by the DOJ, everything that is in here with us today, available to the public. So Rye, thank you so much. And Rye is also joined by Lucius Tuck, who is an investigator with EpsteinWiki.com. a grad student in international crime and justice who has been integral in helping a decentralized network of independent investigators research and cover the Epstein files. Thank you both for your work, and thank you for taking the time to join us during our 24-hour stream. Thanks. I think this is a new book for you guys.
Hi, everyone. My name is Rye Howard Stone. I built Epstein-data.com, which is a forensic archive of the DOJ's approximately 3 million page Epstein file release. This is my friend Lucius.
I'm Lucius Tuck. I'm here on behalf of EpsteinWiki.com.
And we spent the last 3 months in these documents. Before we read anything, we want to name some of the women who came forward.
Maria Farmer, who walked into the FBI in 1996 and reported what Jeffrey Epstein and Ghislaine Maxwell had done to her. She was the first. The FBI took her statement, then nothing happened for the next 23 years.
Annie Farmer, Maria's younger sister, who was 16 when Epstein flew her to his ranch in New Mexico.
Virginia Roberts Giuffre, who was 16 when Ghislaine Maxwell approached her at Mar-a-Lago and recruited her into Epstein's trafficking network. She passed away in April of last year.
Courtney Wild, who was 14 when she was first abused. She has fought for nearly 2 decades to enforce the Crime Victims' Rights Act against the U.S. attorneys who signed Epstein's non-prosecution agreement without telling her or any other victims.
Mariska Chartuni, Michelle Licata, Haley Robson, Shantae Davies, Tiala Davies, Lisa Phillips,
Jenna Lisa Jones, Rosa, Danny Bensky, 3 of the 5 survivors who returned to West Palm Beach 6 days ago to give sworn testimony at a House Oversight shadow hearing, 3 miles from the mansion where they were trafficked. Maria Farmer and Courtney Wild were the other 2.
And the thousands of women whose names are still in the bound volumes lining this room, and which the United States Department of Justice has so far refused to release.
So we're going to read in 3 parts. The first is from the morning of July 15th, 2019, United States District Court, Southern District of New York, Judge Richard Berman presiding. Jeffrey Epstein has just been arrested on federal sex trafficking charges. It's the first time he's ever faced a federal prosecution. The hearing is to determine whether he'll be granted bail. He will die in his cell at Metropolitan Correctional Center less than a month later, but today in the courtroom, 2 women stand up.
Miss Farmer. Hello, Your Honor.
The court reads, "Could you help us out and spell your first and last name?"
Yes. Annie Farmer. ANNIEFARMER. I was 16 years old when I had the misfortune of meeting Jeffrey Epstein here in New York. He later flew me to New Mexico to spend time with him there. I wanted to voice my support for the government's request that his bail not be set, and also just my reaction to the fact that the defense was claiming that it would be perhaps easier for victims or more likely for victims to come forward given the publicity and some of the other issues surrounding this case. Well, I would say that it would be quite the opposite. That his wealth and privilege and the notoriety of the case would actually make it, I think, often more difficult. Also that they now were arguing that the discipline of this time, but yet we know that they have found photos of young women in his home, and that if he's continuing to engage with pornography of young women, I would say that would be quite the opposite of disciplining. Also, those victims in the photographs are continuing to be victimized.
Are you in a position to answer this question? Are you saying that Mr. Epstein engaged in sexually inappropriate conduct with you?
He was inappropriate with me. He was inappropriate with me. I would prefer not to go into the details of that at this time, yes.
Thank you very much.
You're welcome.
When Annie Farmer finishes, the attorney, Brad Edwards, stands up and introduces a second client. He spells her name for the court. Courtneywild.
Miss Wild. Hi, Your Honor. My name is Courtney Wild. I was sexually abused by Jeffrey Epstein starting at the age of 14, and I would just like to bond, to keep him in detention just for the safety of another, ask the court not to grant him bond, to keep him in detention just for the safety of any other girls out there that are going through what I'm going through. It is a public case, and he's a scary person to have walking the streets.
Where did that occur, the sexual inappropriateness?
In Palm Beach, Florida.
Great. Thank you so much.
Thank you.
Courtney Wild was first abused by Jeffrey Epstein when she was 14 years old. By the morning of the bail hearing, she had been fighting the U.S. government for 11 years to get the Crime Victim Rights Act enforced against Alex Acosta's office. The federal court had ruled in her favor 4 months earlier, February 21st, 2019. Acosta announced his resignation as Secretary of Labor 3 days before this hearing. 3 months earlier, on April 16th of that same year, another woman had filed her own lawsuit in this courthouse. Her name was Virginia Roberts Giuffre. I'll read this here. Plaintiff became a victim of sex trafficking and repeated sexual abuse after being recruited by Ghislaine Maxwell and Jeffrey Epstein when plaintiff was under the age of 18. Between 2000 and 2002, Epstein sexually abused Roberts at numerous locations, including his mansions in West Palm Beach, Florida, New Mexico, the Virgin Islands, and this district. Epstein also flew Roberts on his plane nationally and internationally numerous times when she was under the age of 18. Only portions of the flight logs of Epstein's private planes are yet known, and Epstein also flew Roberts frequently on commercial airlines to meet him and others. However, the chart below, which shows Roberts' flights on Epstein's private plane from the limited logs that are available, illustrates the international scope of Epstein's sex trafficking. Between 1997 and 2007, with the assistance of numerous co-conspirators, Epstein abused more than 30 minor underage girls, a fact confirmed by state and federal law enforcement. After years of abuse, Epstein sent Roberts to Thailand in September 2002. One of Roberts' assignments from Epstein was to bring a young girl back to Epstein in the United States. Fearing for his life, and not wanting to subject another young girl to the abuse she was forced to endure, Roberts fled from Thailand to Australia to escape from Epstein.
Virginia filed that complaint in April. Annie Farmer and Courtney Wild stood up in court in July. Epstein died in August. And 9 years before any of it, in late 2010, in his own home, in his own voice, on a recording he made himself, this is what Jeffrey Epstein was saying instead.
So this is a conversation transcribed between Nobel Prize winner Robert Axwell and Jeffrey Epstein himself. It's EFTA 004322827.
Jeffrey. No, Kreischer, the actual guy at the state who filed the indictment, and said, "Can you tell me? I have to think about this, because there will be tremendous political heat if I do this. Can you tell me your summary of what Epstein did?" Oh shit, right? Here's what came back. He said, "I've been doing this for 26 years. I was a state prosecuting attorney. Epstein's behavior was inappropriate, but not criminal." I said, "What? What?" he said. "Yeah, he just got fucked." This is what he said to the governor. The governor called me. This is what he called me for. He said, "This is the guy, Jeffrey, who signed off."
He's the one who put you in solitary.
Yeah. He said, "This is inappropriate, but not criminal."
That sentence, inappropriate but not criminal, was spoken by Palm Beach County State Attorney Barry Kreischer to the governor of Florida.
By his own account, quoted on Epstein's recording, Kreischer had been a state prosecuting attorney for 26 years. He had reviewed the file Maria Farner's FBI report had become. He had reviewed the file from Palm Beach police, who had spent 13 months building a case against Epstein. He had reviewed the testimony of Courtney Wild and dozens of other women, most of whom were minors at the time of the abuse.
And privately, on a phone call to a sitting governor, he said, Jeffrey Epstein's behavior was inappropriate but not criminal.
That sentence is what kept Maria Farmer's report buried for 23 years. It is what kept Annie Farmer waiting 23 years to stand up in a federal courtroom about what was done to her at 16. It is what kept Courtney Wild fighting for almost 18 years to get the Crime Victims' Rights Act enforced. It is why Virginia Giuffre had to leave Thailand by herself in 2002 to escape from a man the United States government had already been told about.
6 days ago, 5 of these women returned to West Palm Beach. They sat down at City Hall 3 miles from the mansion where they were trafficked, and they gave sworn testimony at House Oversight Shadow Hearing. The morning shows didn't cover it, the networks moved on, so tonight in this room, we read. Thank you.
Thank you both so much for joining us tonight, and thank you for your work in helping folks access these files. So we are almost at the 7-hour mark. We've been reading the Epstein files for almost 7 hours, so that means we have 17 hours to go. We are here in the Donald J. Trump, Jeffrey Epstein reading room, and live in Lower Manhattan for a full 24 hours. And while we read, we are asking you to do one thing, which is if you see the QR code on screen, to please scan it and give what you can to World Without Exploitation, which is an organization taking on sex trafficking and the powerful networks that protect it. Networks that look a lot like what is in these pages. Now, joining me is former U.S. Attorney for the Northern District of Alabama and author of Civil Discourse Substack, the amazing Joyce Vance. Joyce, good to have you with us. Thank you.
I'm reading to you from is a transcript of a courtroom hearing. The hearing takes place in a case called United States of America versus Jeffrey Epstein. And the hearing takes place in New York City on August 27, 2019 at 10:30 a.m. in the morning. The lawyers are listed on the front of the transcript. Jeffrey Berman is the United States Attorney for the Southern District of New York. Interestingly enough, the name of the Assistant United States Attorney who actually appears at the hearing is redacted. And of course, that's interesting for the reasons that many of you have already noted, including the failure to protect survivors and victims' identifying information. And yet here, the prosecutor, who we can be fairly certain is Maureen Comey, who handled the case, for inexplicable reasons, her name is redacted. Jeffrey Epstein is represented by his lawyers, Martin Weinberg, Reed Weingarten, and Michael Miller. And so the court opens with some pleasantries at the beginning, and then we learn why we're here. Let me read to you from what the court says. This is a transcript of the judge's words. He says, "Good morning to all of you. This hearing that we're having today considers the government's motion to dismiss the indictment in this case. I must add that it also serves as the opportunity for me to thank all of you, the attorneys and the victims who are here today, among others, for your very hard work and dedication in this case. We also have here today the U.S. Attorney for the Southern District of New York, Jeffrey Berman, who has also been very helpful and indispensable in this matter. The news on August 10, 2019, that Jeffrey Epstein had been found dead in his cell at the Metropolitan Correctional Center at the MCC was certainly shocking. Most of you, and myself for that matter, were anticipating that the next steps in this case would be defense motion practice, including a motion to dismiss, followed by a trial on the merits before a jury if the motions were not successful, and through which the accusers and the accused would come face to face, allowing everyone to get their day in court. Mr. Epstein's death obviously means that a trial in which he is a defendant cannot take place. It's a rather stunning turn of events, the judge says. He continues, the government's motion to dismiss the indictment because of Jeffrey Epstein's death on August 10, 2019 is relatively straightforward. In my view, a public hearing is nevertheless the preferred vehicle for its resolution. Incidentally, while I'm on this subject, I got some help today from the New York Law Journal from two professors who write that a hearing is, the judge says, let me tell you exactly what they said and refers to the article. They say in part that this is an odd moment for transparency in a criminal case. I think that's an odd sentence to hear about, transparency in a criminal case. They go on to say that normally if a prosecutor seeks to dismiss an indictment for such an obviously worthy reason, the court would simply grant the request. As to that statement, I respectfully say that it is incorrect as a matter of law. They go on to say the judge would not schedule a hearing, and he definitely would not allow victims to speak. If he did hold a hearing, whatever informational interests the victims may have would be served by affording them a chance to attend the hearing, not by giving them a speaking role. I read it. It was incredulous. I'm still incredulous. I don't understand it at all. There's a suggestion in the article that the reason they are making these suggestions has to do with the minimization of drama in this case. In the Jeffrey Epstein case, there has not been much a minimization of drama. And what little drama might happen today, I don't think it would be very significant. On a somewhat more serious note, don't quote me on this, but it's my understanding that some of the authors of that article is himself counsel in one of the Epstein-related cases. I was surprised to learn that very recently. I'm certain it is true. I was also surprised that that aspect was not disclosed in the Law Journal. But in any event, I think you know where I'm heading. I respectfully disagree with the Law Journal piece. I was saying that the government's motion is relatively straightforward, and in my view, a public hearing is clearly, nevertheless, the preferred vehicle for its resolution. I'm still convinced of this. A few may differ on this, but public hearings are exactly what judges do. Hearings promote transparency, and they provide the court with insights and information which the court may otherwise not be aware of. The victims have been included in the proceeding today, both because of their relevant experiences and because they should always be involved before rather than after the fact. The victims, let me skip down further. The indictment, he explains, charged Jeffrey Epstein with sex trafficking and with conspiracy to commit sex trafficking. The U.S. Attorney on August 19, 2019, requested that the court approve the government's proposed order of nolle prosequi. I think that's a rough justice. That means nolle prosequi, discontinued by the prosecutor of all or of a part of the case that he or she has commenced. The government in its motion concludes that Epstein's death abates these proceedings. In accordance with Federal Rule of Criminal Procedure 57B, I determined to hold a public hearing, and I notified the victims that they would be given the opportunity to be heard before any final action on the motion. That is the purpose of today's proceeding. I would do that every time. Also recognize that Mr. Epstein, died before any judgment of conviction against him has been obtained, and that the government's proposed order appears in form and substance to be appropriate. Federal Rule of Criminal Procedure 48A codifies the nolle prosequi process. It is entitled dismissal, and it states in relevant part that the government may, with leave of the court, dismiss an indictment, information, or complaint, and that leave of the court proviso, you should know, was added as an amendment to the original draft of Rule 48, which had originally provided for automatic dismissal upon the motion of the government. This proviso, in my judgment, is clearly directed toward an independent judicial assessment of the public interest in dismissing the indictment. Thus, even whereas in this case the standard of court review is deferential, the court must still make its own independent determination. A conclusory statement from the government that dismissal is appropriate does not satisfy the court's obligations. It is also, in my view, required that the court consider the views of the victims in the case at the hearing and before deciding whether to grant the motion. This is being done here both as a matter of law and as a measure of respect that we have for the victim's difficult decision to come forward in this matter. In a case called United States versus Heaton, the government filed a Rule 48 motion for leave to dismiss a charge against a defendant who allegedly committed a sexual offense against a young victim. Although I should point out very importantly that that defendant was still alive, which distinguishes it from our case. Nevertheless, I think it is relevant because in evaluating the Rule 48 motion, then District Judge Paul G. Cassell, who's now a law professor at the University of Utah and is regarded to be a noted expert in victims' rights, concluded that under the Crime Victims' Rights Act, victims have broad rights that extend to a court's decision whether to grant a government motion to dismiss under Rule 48. I completely share that viewpoint in these circumstances, even though the facts of our case, as I said, are somewhat different from those in Heath. I believe it is the court's responsibility and manifestly within its purview to ensure that the victims in this case are treated fairly and with dignity. The fundamental substantive principle which applies in considering the government's motion is termed the rule of abatement. This principle originated in the English common law. It was adopted by most U.S. federal courts, but more recently, it has faced some appropriate criticism. The rule of abatement is best explained in the Second Circuit case of U.S. versus Wright. In that Wright case, two defendants had pled guilty to embezzlement and tax evasion. Both defendants appealed, but one of the defendants died while his appeal was pending in the Second Circuit. The Court of Appeals ruled that under the rule of abatement, the judgment of conviction against the deceased defendant was required to be vacated and the indictment was to be dismissed. The Wright court held that when a convicted defendant dies while his direct appeal as of right is pending, his death abates not only the appeal, but also proceedings had during the course of the prosecution. The Second Circuit, incidentally, has also held that when a criminal conviction abates the death of a defendant, any restitution ordered as a result of that conviction must also abate. And it is also ruled the same with respect to asset forfeiture. This latter application of the rule of abatement regarding forfeiture has not been universally accepted among federal courts, but it certainly is the law in this circuit. Some of you may be interested to know that some United States courts, state courts, have criticized the rule of abatement, particularly in the face of growing recognition of victims' rights in the criminal justice system, including the Crime Victims' Rights Act. It has been written and contended in the Brooklyn Law Review, I can give you the site later, that when courts abate criminal convictions, they reimpose a burden on victims that legislatures intended to alleviate through these victims' rights statutes. The state Supreme Court has even concluded that the expansion and codification of victims' rights provides the changed conditions needed for overruling the rule of abatement. It has also been stated that Alaska's statute and its constitution now require the criminal justice system to accommodate the rights of crime victims. Further, that the abatement of criminal convictions has important implications for these rights. But coming back to our case, which is what you are concerned about, and I am as well, it is appropriate to conclude that if the rule of abatement applies to a convicted defendant, as in the Wright case, it should also apply a fortiori in the Epstein case, which was still in the pre-trial phase when Epstein died, when there had been no conviction. So that's just some background I wanted to share with you. At this point in time, I would like to turn to the government prosecutors to hear from them in support of their Rule 48 application to dismiss the Epstein indictment. The judge concludes his comments there and he invites the prosecutor to the podium. Her name is, of course, redacted. As I told you when we began, it says Ms., and I would say that this redacted block in the document looks pretty much like Comey. So again, I think it's safe to include that this is Maureen Comey, the lead prosecutor in the case. She says, Thank you, Your Honor. Would you like me to address the court from the podium? The judge says, if you wouldn't mind. And she says, thank you, Your Honor. I believe Your Honor has accurately summarized the state of the law as set forth in our papers in light of the clear Second Circuit law that upon the death of a defendant before a final entry of judgment of conviction, all proceedings must be abated. In light of that clear law, the government is legally obligated to seek dismissal of the pending indictment against Jeffrey Epstein, and we respectfully submit likewise that the entry of the proposed order is similarly required by law. A few notes to make about that, though, Your Honor, she continues. She says, to be very clear, dismissal of this indictment as to Jeffrey Epstein in no way prohibits or inhibits the government's ongoing investigation into other potential co-conspirators, nor does it prevent the bringing of a new case in the future or the prosecution of new defendants. It also does nothing to prevent the government from continuing to explore the possibility of seeking civil forfeiture of any assets that were used to facilitate the crimes charged in this indictment. Indeed, as has been stated publicly, investigations into those matters have been ongoing, remain ongoing, and will continue following dismissal of the indictment here. I would also like to note that, as the government has previously mentioned, this dismissal in no way lessens the government's resolve to stand up for the victims in this case, both those who have come forward and those who have yet to do so. We agree with Your Honor's sentiment that those victims should be respected, and we appreciate Your Honor's recognition of that. She continues, one housekeeping matter that I did want to reference for Your Honor. The protective order in this case requires destruction or return of any and all discovery material upon conclusion of the case. We have been in communication with defense counsel who have confirmed that they have returned all physical copies that they have of discovery that the government has produced to date, and they are in the process of deleting any copies that they may have made. So the parties are in compliance with the protective order. Finally, I just wanted to say a word about the victims in this case, and particularly those who are here in court today. I'll note that in light of the court's order indicating that the victims and their counsel would be permitted to be heard in court here today, the government has endeavored to provide notice to all known victims of today's proceeding. We did so either directly, where a victim was not represented by counsel, or through counsel, where a victim is represented by an attorney. The government does not know exactly how many victims or their attorneys are here today, and we do not know how many of them or their counsel would like to speak. To the extent any individuals do wish to speak, we do not know the substance of what they would like to say. We have left that entirely up to the individual decisions of the victims and their attorneys. I will note, though, that throughout this case, the government has endeavored and done our utmost to fulfill our obligations under the Crime Victims' Rights Act. We have done so by trying to keep as many victims as we are aware of up to date about the ongoing case and about any developments in the case. We will continue to provide services and offer services to any of the victims in this case, even after the indictment is dismissed. Both the U.S. Attorney's Office and the FBI have been in touch with all known victims, or have attempted to be in touch with all known victims, either, again, directly where victims are not represented by counsel, or through counsel where they have attorneys. We have expressed to them that services are available for those who wish to take advantage of them. Unless this court has any questions for me, the government will rest on its papers. The judge says, I just have one question. The protective order, is that self-executing or do I need to do something? The prosecutor says, it is self-executing, Your Honor. The court says, thank you very much, Ms. Redacted. She responds, thank you, for honor. And the court says, I'll turn to counsel for the defense at this time. Mr. Weingarten, I'm happy to hear from you. Mr. Weingarten says, Your Honor, I think it is an understatement of the year to say that the world looks and feels differently today than it did the last time I was before you. For us, the elephant in the room is what happened to our client. I would like to tell you how we see the world and where we are on that subject. We start with the Attorney General's statements, public statements, that there were very serious improprieties in the jail. We obviously read the press. We see that the warden has been taken out. We see that the guards on duty at the time have been put on leave. We understand the guards are refusing to cooperate with the investigation. We have heard allegations that people at the time who had responsibility for protecting our client falsified information. We understand that there were orders out there that Jeffrey Epstein was never to be left alone and that the orders were ignored by many of the employees in the prison. In a word, yikes. In addition, obviously, we followed the medical examiner's report, or we haven't followed the report. We haven't seen it, but heard the conclusions. Initially, not enough evidence to come to a conclusion, wanted to see more. We assumed she was talking about the videotapes, but then came the conclusion that it was a suicide. We report to the court that the court stops Mr. Weingarten and says, suicide by hanging. Weingarten says yes, and the court says that was her conclusion. Weingarten responds, yes. Oh, I'm sorry, I missed. I thought you were wrapping me. That's good. I mean, there's a little bit more here, and this is important stuff, particularly in hindsight. I had not reviewed this transcript for some time, and I'm surprised by how relevant it is to news today. So Mr. Weingarten has just a few more comments. He continues, and we report to the court that we had a doctor there at the time, and we also have been in receipt of a tremendous amount of medical and scientific evidence volunteered to us, opining that the injuries suffered as reported were far more consistent with assault than with suicide. And we are happy to supply the court with all the information we have. Now, in addition, as the court noted, we were underway with our pretrial motions. And as the court obviously understands, the NPA and the role of the NPA was going to be critically important. And I would simply like to report that we were pretty far along. We interviewed all of the relevant lawyers on the defense side who participated in the NPA, and we were satisfied that we had a very strong argument that every one of those lawyers believed with an objective basis that the deal was global. That is, at the time, the court interrupts him and says, I'm sorry, that? Mr. Weingarten says, the deal of the NPA, that's the non-prosecution agreement out of Florida, was global. That is, more specifically, at the time the Florida prosecutors and agents knew of conduct in New York and that no competent defense counsel negotiating in good faith with the prosecutors would have ever agreed to a deal back then that allowed New York prosecutors to indict for precisely the same conduct in the future, which of course is what happened. In addition, we have come up with very powerful evidence, we believe, that Florida prosecutors who participated in the deal steered the victims and the alleged victims to New York on more than one occasion because they did not want to suffer the slights of attacks against them. So we have advanced the ball on this very subject, and we are prepared to completely report to the court as to where we are and what we've done. The transcript continues, but that's the end of my portion to read to you.
Joyce, thank you so much for joining us. I am so grateful for all of the brilliant... No, you're amazing, Joyce. Thank you. Appreciate you. And just to let everyone know, we are now a little over 7 hours into our 24-hour live stream here at the Donald J. Trump Jeffrey Epstein Reading Room in Lower Manhattan. We have just about 17 more hours to go, but we are doing this because it is so important to keep eyes on this story. And I am joined now by Lev Parnas, political activist and author of the Lev Remembers Substack. Thank you so much for being here, for joining us. Please let everyone know, why you're here, why this is so meaningful to you, and then, proceed with the reading. Thank you.
Thank you so much for having me. Thank you. Hey, everyone. Good evening, everyone. I want to thank Steve Schmidt, Save America, Aliza Orleans, and all of the volunteers that helped put this extremely important reading together. I want to start off by saying how honored I am to have been asked to stand here today to speak and to read as part of this 24-hour reading of the Epstein files. This is not something that I take lightly. These files are not just documents. They're not just pages. They're not just names, dates, flights, meetings, and court records. Because behind every page is a survivor. Behind every file is someone whose life was changed forever. And before I say anything else, I want to thank every single person who, for the past year, long before, has fought for the Epstein survivors, spoken up for them, kept their stories alive, and refused to let this country move on. I will never forget traveling to Washington, D.C., sitting in that room, that hearing, watching Pam Bondi. There she was, sitting in a position of power, representing the Department of Justice, representing an institution that is supposed to protect victims and fight for justice. But instead of speaking for the survivors, instead of honoring their pain, instead of facing them with the dignity they deserved, she would not even turn around and look at them in the face. I sat there and I watched the pain on their faces. I watched them walk out of their room carrying the weight of that moment. As I followed and walked out with that pain in my heart alongside with them. Because as a father, as a son, as someone who has 3 daughters, I cannot even begin to imagine the pain these young women have carried. Not just the pain of what happened to them then, but the pain of having to fight again and again just to be believed, just to be heard, just to be treated like their lives matter. That moment stayed with me forever, and it reminded me why we could never stop speaking out. Because, folks, this is not about politics. This is about being human. About human beings. This is about survivors who have never been forced to carry pain that was never theirs to carry. And then just a few weeks ago, I was fortunate enough to be in Washington, D.C., standing with survivors, advocates, and Virginia's family at the Butterfly Vigil for Virginia Go Free. I stood there and listened to Sky, her brother, speak about his sister. I listened to others speak about Virginia's courage, her pain, and the price she paid for telling the truth. And as I stood there, I kept thinking about how much she endured, not only what was done to her, but what she had to go through to expose this truth. Because Virginia suffered because of Epstein and the people around him. But she also suffered because of the powerful people trying to silence her, discredit her, and make the world look away. But I want to say something, Virginia. If you're looking down today, we're not looking away. Today we're saying your name and every name of every survivor. Today we're honoring your courage. And I believe Virginia is looking down and proud to see this fight that did not just die with her. Proud that the survivors are still standing, proud that people are still demanding the truth. And last, when I was in West Palm Beach last week for the hearings, I sat there and listened to the survivors tell their stories. I watched as Maria Farmer. I listened to Rosa, a young woman from Uzbekistan, describing the horror she endured and the way the system failed her. I listened to the survivors explain how the pain does not stop when the abuse ends. The pain continues when the government mishandles your name. The pain continues when your story is treated like paperwork. The pain continues when the Department of Justice makes decisions without thinking about the human beings behind those files. So why am I here? That is why I'm here. That is why we are here. We're here for Virginia. We're here for Maria. We're here for Annie, for Rosa. We're here for all the survivors whose names we know, and for every survivor whose name we do not know. For every survivor who has spoken, every survivor who is still not ready or able to speak. And we are here for every Katie Johnson out there, for every young girl whose name was hidden, for every child who was too scared to speak, for every survivor who tried to come forward and was met with threats, pressure, fear, disbelief, or silence. You see, folks, Katie Johnson was the name used in a case brought by a woman who alleged she was only 13 years old when she was abused by Donald Trump and Jeffrey Epstein. That case was later withdrawn and many people stopped talking about it. But we cannot and will not forget what that name represents. It represents a 13-year-old girl, the child, someone who should have been protected, someone who should have been believed enough to be heard, someone who allegations deserve serious attention, not mockery, not dismissal, not political spin, especially not silence. Because for every survivor whose story makes headlines, there are many, many more whose stories never do. For every name we know, there are names we may never know. For every file that has been released, just think about how many more files they are hiding and protecting. And for every child who was hurt, there must be accountability. That is why this fight matters. That is why we cannot let them close the book. That is why we cannot let powerful men decide which survivors matter and which survivors get erased. Because that is what they're counting on. They were counting on people moving on. They were counting on the news cycle changing. They were counting on survivors being exhausted. They were counting on the shame, the fear, the silence, and time. But almost a year later, we are still here. Because I'll never forget what happened last year during 4th of July weekend. While Americans were celebrating freedom, while families were gathering, while this country was supposed to be honoring justice and liberty, Donald Trump, Pam Bondi, and the Department of Justice with Kash Patel tried to quietly close the door on the Epstein files. They all of a sudden put out a memo and told the American people there was no client list, no more answers, nothing more to see, no need to release anything else. And I remember thinking to myself, how is that possible? How is it possible? Jeffrey Epstein, private islands, mansions, planes, powerful friends, politicians, billionaires, royalty, bankers, businessmen, lawyers, people all around the world connected to him, and somehow we are supposed to believe that the story ends with him. How is it possible that the survivors have spent years telling us of what happened? Court records, victims have testimony, journalists reporting, investigators having evidence, and suddenly the government wants us to believe that there is nothing more. The truth is, the cover-up is sometimes a lot worse than the actual crime. And here, it's so bad, it's worldwide. Because this is not about one man operating in shadows alone. This was a network, folks, a system, a protection racket for the rich and powerful. A system where money, influence, access, fear, and people, while survivors, were left to carry the pain. And I say this as someone who unfortunately was once inside of Donald Trump's world. For years, Donald Trump and the people around him promised their base they would release the Epstein files. They said they would expose the truth. They said they would name the names. They used it. They raised money on it. They campaigned on it. And then when the moment came, when they had the power to release the files, they turned around and said no. I remember speaking with people still on the inside, very close to Donald Trump. I remember asking, what the hell is going on with him? And I'll never remember the gentleman telling me, Lev, you must have forgotten that Donald Trump is not just protecting other people. He's protecting himself. And we saw that with when Marjorie Taylor Greene came out and what she said, what he told her. Remember, Marjorie, there are good people that we need protecting. Think about that, folks. And when you look at what happened since that, it all comes together. The puzzle starts to fit together. Because we have watched Donald Trump ignore the survivors. We have watched him dismiss this as saying it's a hoax. We have watched him refuse to meet this moment with the seriousness it deserves. Instead he sends Pam Bondi out to cover it up. And now we see Todd Blanche and others trying to do the same thing. Manage it, bury it, delay it, control it, protect the people who should be answering the question. So I want to say something directly to you, Todd Blanche, because I know you watch everything I do, because I know you very well. Release the files. Do the right thing. Stop covering up for the criminal that you're protecting, Donald Trump. Stop covering for the rich and powerful. At one time, that wasn't you, Todd. Stop using the Department of Justice to protect the same people who have been protected for far too long. Remember, one day you will have to look your own kids in the face, in their eyes. Enough of this, Todd. We cannot take that anymore. The survivors cannot take it anymore. The American people cannot take it anymore. Stop with the politics. This is not about left or right. It's not about Democrats, Republicans. It's about right or wrong. Children were abused, Todd. Children, young girls were trafficked, survivors were silenced, powerful men are still being protected. And the institutions that were supposed to seek justice help bury the truth. So you ask me why I'm here? That's why I'm here. I'm here because I cannot look at my children and say I stayed silent when the survivors were asking for justice. I cannot teach my sons about courage if I do not stand up to it myself. I cannot tell my daughters that they are safe in a country where powerful men could abuse, hide, and walk away without accountability. And I truly cannot look anymore at any of these survivors and say we did everything we could if we stopped now. So I want to say something before I start reading to the survivors. I want to say it clearly. We're here, we believe you, we stand with you, we honor you, we are so sorry. We are so sorry you had to fight this hard. We are sorry you had to relive the trauma again and again just to be heard. We are sorry powerful people traded you, your pain like an inconvenience, and still do. And we are sorry institutions that were supposed to protect you protected themselves instead. But today you're not alone. Today we stand here. We stand with you. Today we read because the truth matters. We are reading them because silence is exactly what the powerful and what Donald Trump counted on. And today we're going to prove them, all of them, wrong. Today proves that the survivors are not alone. Today proves that the truth still has power and no one should be protected. No one should be above the law. No one. Because the Epstein files, folks, they're not just the documents. They are a test. They are a test to whether this country still has the courage to confront powerful people. They are a test to whether our institutions serve the public or are starting to serve the wealthy and connected. They are the test of whether survivors matter only when it's convenient to us or whether they matter always, because they matter always. To everyone here and to everyone watching, do not let this end with this hearing today, please. Keep talking about it, keep sharing it, keep demanding answers, keep standing with the survivors, because this fight is not over until the truth is released. This fight's not over until the powerful are held accountable. This fight is not over until every survivor knows that this country did not abandon them. So today I stand here with humility, with anger, with love, and with purpose. The survivors deserve justice. The public deserves the truth. The files must be released. The cover-up must end. We will not be silent. We will not look away. We will not move on. And now I'm going to read to you some important passages out of Volume 27 out of 3,437. So what I'm going to read to you is the United States District Court, Southern District of Florida. It's a case that was filed by Jane Doe, number 1, and Jane 2 versus the United States. Jane Doe number 3 and Jane Doe number 4, corrected motion pursuant to Rule 21 for the joinder in action. Come now, Jane Doe and Jane Doe 3 and Jane Doe 4, also referred to as the new victims. By and through the undersigned counsel to file this motion pursuant to Federal Rule of Civil Procedure 21 to join this action on the condition that they not litigate any issues already litigated by Jane Doe 1 and Jane Doe 2, also referred to as current victims. The new victims have suffered the same violations of their rights under the Crime Victims' Rights Act as the current victims. Accordingly, they desire to join in this action to vindicate their rights as well. Because the new victims will not litigate any issues previously litigated by the current victims, and because they are represented by same legal counsel as the current victims, the government will not be prejudiced if the court grants the motion. The court may at any time add new parties to the action under Federal R. Civil P21. Accordingly, the court should grant the motion. As the court is aware, more than 6 years ago, Jane Doe number 1 filed a present action against the government, alleging a violation of her rights under the CVRA 18 USC-37771 DEI 1. She alleged that Jeffrey Epstein had sexually abused her and that the United States had entered into a secret non-prosecution agreement regarding those crimes in violation of her rights. At the first court hearing on the case, the court allowed Jane Doe number 2 to join the action. But both Jane Doe number 1 and Jane Doe number 2 specifically argued that the government had failed to protect their CVRA rights, to confer, to reasonably notice, and to be treated with fairness. In response, the government argued that the CVRA rights did not apply to Jane Doe number 1 and Jane Doe number 2 because no federal charges had ever been filed against Jeffrey Epstein. The court has firmly rejected the United States position. In a detailed ruling, the court concluded that the CVRA extended rights to Jane Doe 1 and Jane Doe 2, even though federal charges were never filed, DE 189. The court explained that because the NPA barred prosecution of crimes committed against them by Epstein, they had standing to assert violations of the CVRA rights. The court deferred ruling on whether the two victims would be entitled to relief pending development of further evidentiary record. Two other victims who are in many respects similar situation to the current victims now wish to join this action. The new victims joining at this stage will not cause any delay, and their joinder in this case is most expeditious manner in which to pursue their rights, because the background regarding their abuse is relevant to the court's assessment of whether to allow them to join. Their circumstances are recounted here briefly. Jane Doe number 3's circumstances. As with Jane Doe 1 and Jane Doe 2, Jane Doe 3 was repeatedly sexually abused by Epstein. The government then concealed from Jane Doe 3 the existence of its NPA from Jane Doe number 3. In violation of her rights under the CVRA, if allowed to join the action, Jane Doe number 3 would prove the following. Then in 1999, Jane Doe 3 was approached by Ghislaine Maxwell, one of the main women who Epstein used to procure underage girls for sexual activities and a primary co-conspirator in a sexual abuse and sex trafficking scheme. In fact, it became known to the government that Maxwell herself regularly participated in Epstein's sexual exploitation of minors, including Jane Doe number 3. Maxwell persuaded Jane Doe number 3, who was then 15 years old, to come to Epstein's mansion in a fashion very similar to the manner in which Epstein and his other conspirators coerced dozens of other children, including Jane Doe 1 and Jane Doe 2. When Jane Doe 3 began giving Epstein a massage, Epstein and Maxwell turned it into a sexual encounter, as they had done with many other victims. Epstein then became enamored with Jane Doe number 3, and with the assistance of Maxwell converted her into what commonly referred to as a sex slave. Epstein kept Jane Doe 3 as a sex slave from about 1999 to 2002, when she managed to escape to a foreign country and hide out from Epstein and his co-conspirators for years. From 1999 through 2002, Epstein frequently sexually abused Jane Doe number 3 not only in West Palm Beach, but also in New York, New Mexico, the U.S. Virgin Islands, in international airspace on Epstein private planes, and elsewhere. Epstein also sexually trafficked the then minor Jane Doe, making her available for sex to politically connected and financially powerful people. Epstein's purposes in lending Jane Doe, along with other young girls, to such powerful people were to integrate himself with them for business, personal, political, financial gain, as well as to obtain potential blackmail information. One such powerful individual was Epstein forced then minor Jane Doe 3 to have sexual relationship with former Harvard law professor Alan Dershowitz, folks. A close friend of Epstein's and well-known criminal defense attorney, who's a close friend now of Donald Trump's. Epstein required Jane Doe number 3 to have sexual relationships with Dershowitz on numerous occasions while she was a minor, not only in Florida but also on private planes in New York, New Mexico, and U.S. Virgin Islands. In addition to being a participant in the abuse of Jane Doe number 3 and other minors, Dershowitz was an eyewitness to the sexual abuse of many other minors by Epstein and several of Epstein's co-conspirators. Dershowitz would later play a significant role in negotiating the NPA on Epstein's behalf. Indeed, Dershowitz helped negotiate an agreement that provided immunity from federal prosecution in the Southern District of Florida, not only to Epstein, but also to any potential co-conspirators of Epstein, NPA at 5. Thus, Dershowitz helped negotiate an agreement with a provision that provided protection for himself against criminal prosecution in Florida for sexually abusing Jane Doe 3. Because this broad immunity would have been controversial if disclosed, Dershowitz, along with other members of Epstein's defense team and the government, tried to keep the immunity provision secret from all of Epstein's victims, the general public, and even such secrecy violated the Crime Victims' Rights Act. Meanwhile, Ghislaine Maxwell was another person in Epstein's inner circle and a co-conspirator in Epstein's sexual abuse. She was someone who consequently also appreciated the immunity granted by the NPA for the crimes she committed in Florida. In addition to participating in the sexual abuse of Jane Doe number 3 and others, Maxwell also took numerous sexual explicit pictures of underage girls involved in sexual activities, including Jane Doe number 3. She shared these photographs, which constituted child pornography under the applicable federal laws, with Epstein. The government is apparently aware of this, and in certain instances possesses some of these photographs. Perhaps even more important to her role in Epstein's sexual abuse ring, Maxwell had direct connections to other powerful individuals with whom she could connect Epstein. For instance, one such powerful individual Epstein forced Jane Doe 3 to have sexual relationship with was a member of the British royal family, Prince Andrew, aka Duke of York. Jane Doe number 3 was forced to have sexual relationship with this prince when she was a minor in 3 separate geographical locations: in London at Ghislaine Maxwell's apartment, in New York on the Epstein's private island in the U.S. Virgin Islands, in an orgy with numerous other underage girls. Epstein instructed Jane Doe 3 that she was to give the prince whatever he demanded and required Jane Doe 3 to report back to him on details of the sexual abuse. Maxwell facilitated Prince Andrew's acts of sexual abuse by acting as a madam for Epstein, thereby assisting in internationally trafficking Jane Doe number 3 and numerous other girls for sexual purposes. Another person in Epstein's inner circle of friends who becomes apparently with almost no investigative effort is Jean-Luc Brunel. Epstein sexually trafficked Jane Doe number 3 to Jean-Luc Brunel many times. Brunel was another of Epstein's closest friends and a regular traveling companion who had many contacts with young girls throughout the world. Brunel has been a model scout for various modeling agencies for many years and apparently was able to get U.S. passports for young girls to work as models. He would bring young girls ranging ages as young as 12 to the United States for the sexual purpose and farm them out to his friends, especially Epstein. Brunel would offer the girls modeling jobs. Many of the girls came from poor countries or impoverished backgrounds, and he lured them into the promise of making good money. Epstein forced Jane Doe number 3 to observe him, Brunel, and Maxwell engage in illegal sexual acts with dozens of underage girls. Epstein also forced Jane Doe number 3 to have sex with Brunel on numerous occasions at places including Epstein's mansion in West Palm Beach, Little St. James Island in the U.S. Virgin Islands, many including orgies that were compromised of other underage girls. New York City, New Mexico, Paris, the south of France, and California. Epstein also trafficked Jane Doe number 3 for sexual purposes to many other powerful men, including numerous prominent American politicians, powerful business executives, foreign presidents, as well known prime ministers and other world leaders. Epstein required Jane Doe number 3 to describe the events that she had with these men so that he could potentially blackmail them. The government was well aware of Jane Doe number 3 when it was negotiating the NPA, as it is listed her as a victim in the attachment to the NPA. Moreover, even a rudimentary investigation of Jane Doe number 3's relationship to Epstein would have revealed the fact that she had been trafficked throughout the United States and internationally for sexual purposes. Nonetheless, the government secretly negotiated a non-prosecution agreement with the Epstein, preluding any federal prosecution in the Southern District of Florida of Epstein and his co-conspirators. As with Jane Doe number 1 and Jane Doe number 2, the government concealed a non-prosecution agreement from Jane Doe number 3, all in the violations of her rights under the CVRA, to avoid Jane Doe number 3 from raising powerful objectives to the NPA that would have shed tremendous public light on the Epstein and other powerful individuals, and that would likely have been prevented it from being concluded in the secret manner in which it was done. Jane Doe's number 4 circumstances. If permitted to join this action, Jane Doe number 4 would allege that and could prove at trial that she has CVRA claims similar to those advanced by Jane Doe 1, Jane Doe 2, based on the following. As with other Jane Doe, Jane Doe 4 was repeatedly sexually abused by Epstein and around the summer of 2002. Jane Doe phone number 4, an economically poor and vulnerable 16-year-old child, was sold by another one of Epstein's underage minor sex abuse victims that she could be making $300 cash by giving an old man a massage on Palm Beach. An acquaintance of Jane Doe number 4, also a minor sexual abuse victim of Epstein, telephoned Epstein and scheduled Jane Doe number 4 to go to Epstein's house to give him a massage. During that call, Epstein himself got on the phone, a means of interstate communication, with Jane Doe number 4, asking her personally to come to his mansion in Palm Beach. When Jane 4 then went to Epstein's mansion and was escorted upstairs to Epstein's large bathroom by one of Epstein's assistants, shortly thereafter, Jeffrey Epstein emerged and lay face down on the table and told Jane Doe number 4 to start massaging him. Epstein asked Jane Doe number 3 her age, and she told him that she had recently turned 16. Epstein subsequently committed illegal sexual acts against Jane Doe number 4 on many occasions. Epstein used a means of interstate communication, example, a cell phone, to arrange for those sexual encounters. Epstein also frequently traveled in interstate commerce on his personal jet for purposes of illegally sexually abusing Jane Doe number 4. The acts Epstein committed against Jane Doe number 4 constituted numerous federal sex offenses, some of which do not carry a statute of limitations and thus are not time barred. See 18 U.S.C. Section 3283-. And these offenses were the kind of offenses that the Federal Bureau of Investigation in the United States Attorney's Office for the Southern District of Florida were pursuing in 2007. So far as Jane Doe number 4 is aware, the U.S. Attorney's Office made no serious effort to locate her. Instead, after identifying approximately 40 separate underage sexually abused victims and apparently preparing a 53-page federal indictment with the full awareness of the existence of many victims like Jane Doe number 4, unidentified and not interviewed, it entered into a non-prosecution agreement, folks, barring prosecution of Epstein federal crimes against these victims. This is contrary to the government's normal approach in prosecuting federal sex offenses. It has also violated Jane Doe's number 4 rights under the CVRA, including the fact that she had a reasonable right to confer with the U.S. Attorney's Office before they entered into an agreement with the sex offender, barring prosecution of him for the crimes he committed against her. 8 U.S. 18 U.S.C-377A5. Motion for joinder. Jane Doe number 3 and Jane Doe number 4 now both move to join this action filed by Jane Doe 1 and Jane Doe 2 pursuant to Rule 21 of Federal Rule of Civil Procedure. Rule 21 provides to a motion on its own, the court may at any time or just term add a party, granting the court broad discretion to permit a change in the parties at any stage of litigation. Ford versus Airline Pilots EDNY 2003, eternal quotation omitted. The new victim should be allowed to join the current victims in this accusation under the rule. The new victims will establish a trial that the government violated their CVR rights in the same way as it violated the rights of other victims. The new victims participate in this case is important because it appears that the government intends to raise as factual defense that somehow it did keep Jane Doe number 1 and Jane Doe number 2 properly informed of what was happening in their criminal prosecution. Of course, if 4 victims all testifying consistently that they were not properly informed by the government, as we believe they will, that provides a stronger case for a CVRA violation. In addition, Jane Doe number 3 and Jane Doe number 4 participation is relevant to the defense. The court has allowed the government to raise. The court has previously ruled that the victim's request for rescission of the NPA implicates a fact-sensitive, equitable defense which must be considered in the historic factual context of the entire interface between Epstein, the relevant prosecutorial authorities, and the federal offense victims, including an assessment of the allegation of a deliberate conspiracy between Epstein and the federal prosecutors to keep the victims in the dark of the pendency of the negotiations between Epstein and the federal authorities, until well after the fact, the presentation of the non-prosecution agreement to them as a fait accompli de -189 at 12N.6. Jane Doe number 3 and Jane Doe number 4 participation in this case will help to show what the entire interface was between the government and the victims, and thus respond to the government's estoppel arguments as well as other defenses that it appears to be preparing to raise. See example 52-page response from the government to the victim's summary judgment motion, raising numerous factual based and other arguments against the victim's position. Jane Doe 3 and Jane Doe 4 participation is also directly relevant to the discovery disputes currently pending in this case. The government has raised various relevancy objections to the documents that Jane Doe 1 and Jane Doe 2 are attempting to obtain, the current victims have obtained. The current victims have responded by explaining how these documents are relevant, including explaining how these documents might bear on the way in which Epstein used his powerful political and social connections to secure a favorable plea deal, as well as provide proof of the government's motives to deliberately fail to investigate certain aspects of the victim's claims in an effort to maintain the secrecy of the facts and resolve the case without the victim's knowledge. Jane Doe number 3 and Jane Doe number 4's participation will help prove the relevancy of these requests as well as the need for those requests. One clear example is request for production number 8, which seeks documents regarding Epstein's lobbying efforts to persuade the government to give him a more favorable plea deal, arrangement, and/or non-prosecution agreement, including efforts on his behalf by Prince Andrew and former Harvard Law professor Alan Dershowitz. Jane Doe number 1 and Jane Doe number 2 have alleged that these materials have needed to prove that their allegations that after Epstein signed the non-prosecution agreement, his performance was delayed while he used his significant social and political connections to lobby the Justice Department to obtain a more favorable plea deal. Jane Doe number 3 has directly person knowledge of Epstein's connection with some of these powerful people and thus how Epstein might have used them to secure favorable treatment. Adding 2 new victims to this case will not delay any of the proceedings. They will simply join in the motions that the current victims were going to file in any event. For example, the new victims will simply join in a single summary judgment motion that the current victims anticipated filing after discovery has been completed, nor will adding the new victims prejudice the United States. As the court is aware, this court is still in its initial discovery stage. The court is currently considering whether to reject the government's assertion of privilege over documentation regarding the case. Victims' reassertion of the objections to the government privileges claims. The new victims do not seek any additional discovery beyond that previously sought by the current victims. Accordingly, the United States will not be prejudiced or burdened by adding them to the case. The CVRA does not contain any statutes or limitations for filing any actions to enforce rights under the statute. Accordingly, were the court to deny this motion, the result might be that the new victims would then be forced to file a separate suit raising their claims, which then possibly proceed on a separate litigation track. Rather than require duplicate litigations, the court should simply grant their motion to join. Jane Doe 1 and Jane Doe 2 support the joinder motion. Counsel for the victims have discussed this motion with the government at length in an effort to avoid any need to file a substantive pleading on the issue. Counsel for the victim asked the government during the summer for its position on the joinder. The government, however, took the matter under advisement for months. Ultimately, after several inquiries from the Victims' Counsel, the government indicated without explanation that it opposes this motion. Counsel for the victims has requested a meeting with the government on this issue, which will hopefully occur in January. In the meantime, however, counsel for the victim believe that this is no longer appropriate to delay filing this motion as accordingly filed it at this time. Because the government is apparently opposing this motion, Jane Doe 3 and Jane Doe 4 have described the circumstances surrounding their claim so that the court has appropriate information to the rule on the motion. Conclusion, Jane Doe 3 and Jane Doe 4 should be allowed to join this action pursuant to Rule 21 of Federal Rules of Civil Procedure. Their joinder should be conditioned to the requirements that they not litigate any issue previously litigated by Jane Doe 1 or Jane Doe 2. A purpose, ordered, and effect is attached to this pleading. And then we have certificate of service. And then we have some examples here. I'll read you some emails. Blacked out, subject working doc, February 27, 2021. It says, hey, blacked out. Did you add the redactions on page 117? It may have been there from an old version this morning. Either way, since it now quotes from the public Second Circuit docket, I think we don't need to redact that bit. Will, I caught a nit in the first sentence of the VCI. It says example 10, 14, 9, instead of example 14 at 14-9. Otherwise, I'm penciled down. Maureen, if you still think it's useful to create a public redacted version of the July depot, I can do that quickly while you finalize. Thanks, redacted. Next email, from redacted Friday, February 26, 2021, 9:17 p.m. to redacted subject working doc. Here you go, almost done with inputting your edits as well. Next email from redacted, sent Friday, February 26 at 9:14 p.m. 2021 to redacted subject working doc. Hey, redacted, would you send me the working doc when you have a second? I'm just taking a quick look at the redactions. No textual changes are coming. Redacted, Assistant United States Attorney, Southern District of New York. Redacted. Next email, redacted, from to redacted, CC redacted, subject, SDNY investigation, re Epstein. Date, July 16, 2019, 1809-24-609. Thanks, redacted. That works for us. We'll see you at 5 p.m. Next email, redacted from, sent Tuesday, July 16, 2019 at 2:07 p.m. to Christian Everdahl and Mark S. Cohen. CC redacted. Subject, SDNY investigation into Epstein. Chris, sorry to have missed your call, and I hope you and Mark are still able to get this. We can meet at 5 p.m. today if that's convenient for you both. And I'm happy to ask the CSOs to allow you to retain your phones. Please let us know if that works and we will put it on our calendar. Thanks, redacted. Next email from Christian Everdahl, redacted, sent Tuesday, July 16, 2019, 1338 to redacted, Mark S. Cohen. Next, redacted, CC redacted. Subject, SDNY investigation, Epstein. Hi, redacted. I just tried your desk. Do we have time this afternoon when you can meet? Let us know as soon as you can come because Mark will be in court soon and will not have his phone. Also, would you mind asking the CSOs to allow us to bring our phones into the building? Let me know if that's a problem. Thanks, Chris. Next email from redacted, sent Monday, July 25th, wrapping up. Following up on my very brief conversation, Chris, earlier this afternoon, and the voicemail you left earlier, thanks for getting in touch regarding your representation of Miss Maxwell. I understand you'll be in our neighborhood tomorrow afternoon. We can make ourselves available to meet, but that have been enough time for you to speak with your client. Let us know what you think would be the best to proceed, and we will figure out the next step. Thanks, redacted Assistant U.S. Attorney, Southern District of New York. Thank you all for listening, and please continue to keep the Epstein survivors in your heart. Thank you.
Lev, thank you so much. Thank you. That was truly amazing. So we are officially about to hit 8 hours of live streaming. Let's go, team. Truly, I couldn't have done it without all of the unbelievable guest readers who've been here joining us here inside the Donald J. Trump Jeffrey Epstein reading room in Lower Manhattan, where we are live streaming for 24 straight hours, reading the Epstein files because we are not letting this story go. We are very lucky right now, in fact, to be joined by a United States Senator, that is Senator Jeff Merkley from Oregon. Senator, thank you for being one of the lead Senate sponsors of the Epstein Files Transparency Act, and thank you for being here with us today. We really appreciate you.
Hi, I'm Senator Jeff Merkley from Oregon. It's great to be with you. Thank you for what you and the Save America movement are doing to continue to keep attention on the Epstein files. I've been focused in the Senate on delivering justice for survivors, transparency for the public, and accountability for abusers. My Epstein Files Transparency Act passed late last year and mandated that the Trump administration publicly release the Epstein files. And at my request, the Government Accounting Office, GAO, has opened an investigation into the DOJ's practices of redacting information from the public release of the files. And regarding the delayed release of the files, I've continued to keep pressure on DOJ's internal watchdog about the Justice Department breaking the law. And tomorrow I'll be questioning Acting Attorney General Todd Blanche about the Epstein files transparency. So I'm glad to be with you because transparency and accountability are critical to delivering justice to Epstein's victims. Without further delay, here is a portion of the Epstein files. Starting with paragraph 243. Defendants benefited directly and indirectly from the pattern of criminal activity conducted by the Epstein enterprise. At all times material herein, defendants engaged in a pattern of criminal activity that was not isolated but was related to the affairs of the Epstein enterprise in violation of CICO 14 VIC number 600. The government restated and realleges paragraph 1 through 244 of this complaint as if fully set forth herein. At all times material herein, each defendant joined a conspiracy to laws against prostitution. Each defendant engaged in acts that revealed its intent to join and participate in the criminal conspiracy by engaging in or facilitating the persuasion, inducement, enticement, or coercion of women and children to travel to the Virgin Islands to engage in prostitution and or sexual activity, and or attempted to do the same, keeping, maintaining, and or permitting Epstein's property at Little St. James to be used for the purpose of prostitution, lewdness, or assignation with knowledge or reasonable cause to know the same, receiving, offering, or agreeing to receive individuals at his property at Little St. James for the purposes of prostitution, lewdness, or assignation, and or permitted women and children to remain there for such purposes, and directing, taking, transporting, and or offering or agreeing to take or transport women and children to Little St. James with the knowledge or reasonable cause to know that the purpose of such directing, taking, or transporting was prostitution, lewdness, or assignation in violation of 14 VIC 1622 and 1624. Defendants knew, or should reasonably have known, that individuals that were the subjects of the actions described in this count were minors. As a result of the defendants' actions, numerous young women and minors suffered serious physical, mental, and emotional injury. Defendants knowingly benefited financially and or obtained other non-financial value from participation in the Epstein enterprise, which has engaged in human trafficking, forced labor, sexual servitude, and commercial sexual activity of girls and young women in knowing or reckless disregard of the laws of the Virgin Islands. At all times material herein, each defendant conspired with Epstein and other defendants to fulfill the primary criminal purposes of the Epstein enterprise: human trafficking, forced labor, and sexual servitude. At all times and material herein, defendants engaged in a pattern of criminal activity that was not isolated, but was related to the affairs of the Epstein enterprise in violation of CICO 14 VIC number 600. The government restates and realleges paragraphs 1 through 240 of this complaint as if fully set forth herein. Epstein was required to, and did, register under the Virgin Islands Sexual Offender Registration Community Protection Act, codified at 14 VIC 1721. SORCPA requires that offenders required to register provide information relating to intended travel in foreign commerce. On at least 2 occasions, Epstein traveled to Vienna and Monaco without disclosing that travel to the Virgin Islands Sex Offender Registry. Epstein's failure to disclose this travel before, during, or even after his travel was knowing. Epstein's violation of SORPCA was part of a pattern of criminal activity that was not isolated, but was related to the affairs of the Epstein enterprise. Count 20, fraudulent conveyance. violation of the Criminally Influenced and Corrupt Organizations Act. The government restates and realleges paragraphs 1 through 258 of this complaint as if fully set forth herein. At all times, material herein, each defendant directly and indirectly participated in or associated with the Epstein enterprise, an illicit enterprise. Each defendant engaged in 2 or more occasions of conduct that constitute criminal predicate acts as defined by CICO, including, but not limited to, transferring assets to and between various entities controlled by Epstein and the Epstein enterprise to avoid, defeat, hinder, or delay claims against them. Upon information and belief, in an effort to defeat the claims of creditors and avoid the oversight of the court probating his estate, Epstein, days before his death, transferred significant assets, including assets held by other defendants, into the 1953 trust. At the time of these transfers, Epstein had numerous actions pending against him related to his trafficking and sexual assault seeking financial judgments. Through these transfers, Epstein and the Epstein enterprise fraudulently removed property and effects beyond the jurisdiction of the probate court. Epstein and the Epstein enterprise were parties to the fraudulent conveyance of the property, real or personal, and or the interest or rights arising out of property, contracts, or conveyances of Epstein and Epstein enterprise. Epstein and the Epstein enterprise acted with the intent to defeat, hinder, or delay creditors and claimants, including the government of the Virgin Islands, in collecting on their judgments, debts, and demands. Defendants, through a pattern of criminal activity, acquired and maintained, directly or indirectly, an interest in or control of the Epstein enterprise or real property. Defendants benefited, directly and indirectly, from the pattern of criminal activity conducted by the Epstein enterprise. At all times, material herein, defendants engaged in a pattern of criminal activity that was not isolated, but was related to the affairs of the Epstein enterprise in violation of CICO 14 VIC 600. Count 21. Fraudulent conveyance, conspiracy to violate the Criminally Influenced and Corrupt Organizations Act. The government restates and realleges paragraphs 1 to 269 of this complaint as if fully set forth herein. At all times, material herein, each defendant joined in a conspiracy to commit fraudulent conveyances. Each defendant engaged in acts that revealed its intent to join and participate in the criminal conspiracy, including, but not limited to, transferring assets to and between various entities controlled by Epstein and the Epstein enterprise to avoid, defeat, hinder, or delay claims against them. Upon information and belief, in an effort to defeat the claims of creditors and avoid the oversight of the court probating his estate, Epstein, days before his death, transferred significant assets, including assets held by other defendants, into the 1953 trust. At the time of this transfer, Epstein had numerous actions pending against him related to his trafficking and sexual assaults seeking financial judgments. Through this transfer, Epstein and the Epstein enterprise fraudulently removed property and effects beyond the jurisdiction of the probate court. Epstein and the Epstein enterprise were parties to the fraudulent conveyance of the property, real or personal, and or the interests or rights arising out of property, contracts, or conveyances of Epstein and the Epstein enterprise. Epstein and the Epstein enterprise acted with the intent to defeat, hinder, or delay the government of the Virgin Islands and other creditors and claimants to collect on their judgments, debts, and demands. Defendants knowingly benefited financially and or obtained other non-financial value from participation in the Epstein enterprise, which has engaged in human trafficking, forced labor, sexual servitude, and commercial sexual activity of girls and young women in knowing or reckless disregard of the laws of the Virgin Islands. At all times, material herein, each defendant conspired with Epstein and other defendants to fulfill the primary criminal purposes of the Epstein enterprise: human trafficking, forced labor, and sexual servitude. At all times, material herein, defendants engaged in a pattern of criminal activity that was not isolated, but was related to the affairs of the Epstein enterprise in violation of CICO. Count 22, civil conspiracy. The government restates and realleges paragraphs 1 through 280 of this complaint as if fully set forth herein. Defendants acted in concert and joined with others to perform the wrongful acts identified in counts 1 through 13, among others concealing the sexual abuse of minor females by unlawful means. Each co-conspirator knew, or in the exercise of reasonable care should have known, about the conduct of the others and about the common unlawful scheme. These unlawful acts could not have been carried to the length and extent accomplished without the common understanding shared by Epstein and the Epstein enterprise defendants. Each of the defendants had a duty to report, stop, or terminate the wrongful conduct. But instead, each defendant concealed, assisted, and furthered the wrongful acts by use of civil conspiracy. As a direct and proximate result of defendants' conspiracy, the Virgin Island has been injured. Each co-conspirator is jointly and severally liable for the acts alleged herein. Thank you, and I hand this back to the team.
Thank you so much, Senator Merkley, for joining us, and also thank you for fighting for transparency and justice for the Epstein survivors. We are now officially in our 8th hour of our stream, Cover to Cover Up, a public reading of the Epstein files from the Donald J. Trump and Jeffrey Epstein reading room in Lower Manhattan. I'm Eliza Orlins, and I'm here with the Save America movement. While we read, we are raising money for the World Without Exploitation, and you can scan the QR code on your screen to give to support this organization that is doing such important work. I am now joined by Zev Shalev, Emmy-nominated investigative journalist and author of the Zev Shalev Substack. Zev, thank you so much for being here.
Thanks, Eliza, and thank you, the Save America movement. You guys have done a fantastic job. I can't believe you've been going for 8 hours. At 21 minutes already. It's incredible work. It's important work. So thank you very much for including me in it. And to everyone who's been reading before and everyone who'll be reading afterwards, it's really important that these Epstein files get the attention they deserve, and that's what everyone here is doing today. Is making sure that the Epstein files is front and center in our. While we've been reading, Yetovan Noel, the correction officer who was on duty the night Jeffrey Epstein died, sat with the House Oversight Committee today for an extended interview that was not videotaped and transcribed. However, we'll get the full transcription soon. And what they looked at is the conditions under which Jeffrey Epstein was found dead. And then it also learned during the testimony today, although we knew this before, in November 2018 and July 2019, JP Morgan flagged 12 cash deposits to her account. One of them was $5,000 that landed 10 days before Epstein died. So, there are a lot of questions, of course, about whether Epstein suicide, whether he died. There's just lots of people who don't know the answer, and we may never know the answer, but we are beginning to get some of the details that are so important. I got involved in the story between his arrest and his death. I've been investigating Trump and Epstein for 10 years, but started on Epstein after he was arrested, but before he died. So this reading that we're doing tonight is really crucial because it's in that period of time, in those 5 weeks, that, he went from someone who was free and a billionaire to someone who became arrested and then died in a short amount of time. This is why this section of these files really matter. It's the moment that Epstein's own lawyers stood up in front of a federal judge and demanded that Judge Richard Berman actually launch an investigation into whether Jeffrey Epstein killed himself or whether he was murdered. So what we're reading is really critical in terms of understanding how the court system works, because after all, he was a subject of the court. They sent him into jail, therefore he was their responsibility. To this day, we do not know exactly the circumstances that he died. So let's get into the reading. His lawyers tried to tell the judge, by the way, that that there was good reason for him to start an investigation. That investigation did happen, but it's not complete. People do not know for sure whether Jeffrey Epstein committed suicide or died. So here we go, the reading. The client says this. Client's in and around the time of his death, and obviously the attorney-client privilege of death. Wait, is this right? Reading right spot here? Yes. By his death, and we are not going to forfeit the privilege, but we will report to the court with as much specificity as the court may want that at or around the time of his death, we did not see a despairing, despondent, suicidal person. Details to follow if the court wishes. The 800-pound gorilla, says the attorney, us, of course, are the video surveillance tapes. Obviously, we assume there is a tape that leads directly to the door where Jeffrey Epstein was housed. If that tape reports for 12 hours before his death, no one went in and no one went out of that room, then the suggestion that there was something other than suicide seems preposterous. Obviously, we'd see the tape, is what they're saying. But there is no such evidence that has surfaced to date, just the opposite. We have heard and we actually read in the press that the tapes were either corrupted or not functioning. Talk about a yikes. If in fact the system was broken for 6 months before Jeffrey Epstein was housed, that would be stunning incompetence. If it was allowed to continue to be inoperative when Jeffrey Epstein was housed, it would be incompetence times 10. But what if the tapes only broke down, were inoperative, or were corrupted on the day he was killed or the day he died? Well, then it would be a completely different situation. This is really important because what they're saying here, if this tape is just a temporary thing that happened while he died, obviously we're looking at something much more sophisticated than just a suicide. So this is back to the reading now. So where does this lead? I think where it leads is there are incredibly important questions that remain open. The public interest in this matter is obvious from this courtroom. There are conspiracy theories galore. We're all in for finding the truth. We believe this court has an indispensable role to play. Whether or not this indictment is dismissed, I think the court has the inherent authority to find out what happened on its watch. Obviously, when the court detained Jeffrey Epstein, the court did not anticipate that the weeks later he would be dead in his cell. I think given the inherent authority of the court should make an inquiry. This could come in many forms. Obviously, the court made inquiry as to what happens in the first incident when there was an allegation of attempted suicide. The court made inquiry. The court obviously was interested. I recall your language. You talked about that being one of the several open questions indicating interest in the court for the others as well. Obviously, the ultimate question is what happened to the client. The court obviously could hold hearings. The court could assign a lawyer of the court. I think this is an area where there is public interest. We have complete confidence in the prosecutors in the Southern District and the FBI to do a competent investigation. But these allegations against the serious components of the United States Department of Justice. Sometimes the appearance of justice is just as important as justice itself. I think the court supervising or at least keeping an interest in this proceeding is incredibly important for the public to have confidence in the ultimate findings, and certainly for us to have confidence in the ultimate findings. One more issue. The conditions of the jail, in a word, were dreadful, not just for Jeffrey Epstein, but for many of the prisoners over there. This is a prison within the shadow of this courthouse. The situation is rife with vermin. The abuse and the condition in the prison, in a word, are a disgrace, and everybody knows it. A person with authority told us, someone with knowledge, that the prisoners in Guantanamo, and he spoke with personal knowledge, are treated better than the prisoners right across the way. The feds certainly know how to run a disciplined, clean prison. I've been in 20 of them. They know how to do it just fine. And the question is, why in the world does it not happen down the road? I think it is a perfectly legitimate subject for the inquiry. In a word, we want the court to help us find out what happened. The court has a role to play. It is the institution most people have confidence in those very troubled times. So whether or not you dismiss this indictment, to us, is beside the point. We want you to stay on the case. We want you to conduct an investigation, and we want to know what happened here. Thank you, Your Honor. This is the response. Actually, I think this is the other attorney. I think it's other. First, as to the conditions, we think Your Honor trusted the government, the Bureau of Prisons, to keep our clients safe and keep him in civilized conditions. The government will again ask the defendants that they be detained at the MCC. Some subset of them will end up in the SHU unit, the SHU unit, which is isolation unit. It is horrific. I've called it medieval. There's vermin on the floor. There is wet from the plumbing, no sunlight. There's a limited exercise opportunity. It is simply conditions that no pretrial detainee, and I would go farther as a criminal defense lawyer, no United States defendant should be subjected to. Certain judges have taken views of the conditions. We would urge, Your Honor, the government we talk about transparency to see what kind of conditions exist within 50 or 100 yards of one of the great United States district courts. Second, we have a profound problem with the conclusions of the medical examiner. There are 3 reasons, Your Honor. This is so important. This stuff is so important. One is the timing of Mr. Epstein's demise. It was on August 10th that he died. On August 12th, a bail appeal motion was being filed in the Second Circuit. On August 12th or 13th, that's when they would listen to that pending appeal. The United States attorneys were going to respond to our request for the preservation and production documents that would have facilitated and furthered our effort to demonstrate communications between the Southern District of Florida and the Northern District of Georgia, which was standing in the shoes of the District of Florida main justice and the Southern District. In other words, we were beginning the process of discharging our responsibilities. There had been no new evidence that Mr. Epstein had committed an offense against a minor after 2005. The subject matter of the New York prosecution was squarely within the heartland of the Florida NPA. We had a significant motion to dismiss. This was not a futile, defeatist attitude. Third, we had all the discovery motions that Your Honor had scheduled to the timing for a pre-trial detainee to commit suicide on August 10th, when his bail pending appeal motion is being filed on August 12th, strikes us as implausible. We had an independent doctor who was present at the autopsy, which occurred on August the 11th. On August the 11th, the city medical examiner's findings were that the death was inconclusive, or the reason for the death was inconclusive. We are told by a very experienced forensic pathologist that the broken bone of Mr. Epstein's neck, in his larynx, are more consistent with external pressure, with strangulation, with homicide, if you will, than with suicide. It doesn't exclude suicide, but the pure medical forensic evidence creates profound issues about what happened to him. Also, the time of death. A medical examiner's opinion is that it occurred at least 45 minutes and probably hours before 6 a.m. on August the 10th, when he was found, according to reports, yet he was moved, something that is not ordinary in these circumstances. Sorry, excuse me here. Apologies. According to the reports, yet this was moved, something that is not ordinary in these circumstances. Instead of having the cell in the condition it was found, if he had been dead for 45 minutes or 2 hours or 4 hours, there were efforts to move him and therefore make it more difficult to reconstruct whether or not he died of suicide or from other causes. That is a critical question. The fact that he was moved, possibly several times, makes it really difficult for people to know in what condition or where he's lying at the time of his death. And we'll never know the answer to that question. I spoke to Stacey Richmond, who is a responsible member of this court who represents the family of Mr. Epstein. She spoke to the medical examiner on Friday after Mr. Epstein's death and asked why the conclusion was made late in the afternoon on Friday that week. She specifically asked about what extrinsic non-medical evidence caused the medical examiner to go from uncertain to suicide. And she was told that the medical examiner had seen 9 minutes of one video, which was on a stairwell between the floors at the MCC. She was told that the principal video that would have showed the hall was corrupted. It was in DC with the FBI to see if they can reconstruct it. And I asked the same questions that my co-counsel did. Was the dysfunction of the critical pivotal video in the most secure prison east of Florence, out in Colorado, known to the MCC before August 10th? Or was this corruption occurring on August 10th, which would again cause it to be skeptical of the certitude of the medical examiner's conclusion that this was suicide rather than some other cause? So with my co-counsel, we ask, Your Honor, it is not a question of trust or not trust. They asked you to detain people, and you trust the Bureau of Prisons. And it is within your inherent authority, Your Honor, to find out what happened to our client. We are angry about the conditions he was held in, and we're also angry, quite frankly, Your Honor, that the only source of information that we get as to what happened to him is through the media, rather than the United States Attorney's Office. We've made informal requests. We've made TOHI requests. We've been told there is pending investigation. But we trust, Your Honor. I didn't get that. I think you said 5 minutes. Okay. But we trust, Your Honor, and the judiciary. And with all due respect, we believe there is an inherent and central role, a pivotal role, for Your Honor to find out what happened to a defendant in a case before the court. Whether or not the court grants the null pros today, or whether it holds it pending an investigation into Mr. Epstein's death. We're not here without significant doubts regarding the conclusion of suicide. We are not here to say what happened. We don't know what happened, but we deeply want to know what happened to our client. Thank you, sir. Well, maybe stop there because I think it's a good spot to stop and just maybe reiterate how important this particular reading is. Because we're finding out here how even the clients of Jeffrey Epstein, of the lawyers of Jeffrey Epstein at least, had no idea whether he had committed suicide or was murdered. That question has not been answered to anybody's full satisfaction. And a lot of the evidence, which we heard from Tova Noel today about the checks, and a lot of the evidence we've heard today that I'm reading here about the video surveillance and all of that other information that we're finding out, we just may never know if he committed suicide or was murdered. And of course, that is an important question to find out the whole of the Epstein saga and the solution to the whole of the Epstein saga. So I'll leave it there. I want to thank the Save America movement. Thank you so much for sharing this space and for allowing us to all have a reading and for keeping this important issue of the Epstein files front and center in front of the American public.
Zev, thank you so much for joining us. We really appreciate you and couldn't agree more with everything you said, because we absolutely need to keep eyes on this story and we're not letting it go. So joining us now is Ken Harbaugh, host of the Ken Harbaugh Show and steering committee member for the Save America movement. Thanks for being here, Ken.
Thanks, Eliza. I wish I could say it's an honor to be here, but honestly, what I feel is anger at a system that failed these women so completely. Whatever honor there is in this tragedy belongs to those women who fought for decades, long after the system made clear it wasn't going to fight for them. I'm Ken Harbaugh, former Navy pilot and host of the Ken Harbaugh Show on the Midas Touch Network, and a steering committee member for the Save America movement. And what you're about to hear me read is a federal court transcript from August of 2019, a victim impact hearing held in the Southern District of New York following Jeffrey Epstein's death in custody. Epstein never faced his accusers in open court. He never had to sit across from these women and listen to what he did to them. This hearing was the closest thing to accountability that the justice system could offer, and it came only after decades of secret deals, silenced victims, and a criminal justice system that treated powerful men as a separate category of defendant. The voices in this document are survivors. Some used their names, some spoke as Jane Doe. All of them showed up anyway, knowing the man they came to confront was already dead, knowing the full justice they deserved had been stolen from them again. We're reading this because these words deserve to be heard out loud. Some of my clients are going to address the court that are here today, others are not. Some are going to use their names and have in the past, and others wish to remain anonymous. And I have instructed each of them to inform the court reporter that they will be proceeding as Jane Doe so that the court reporter can take them down, the court. For those who wish to remain anonymous, Mr. Edwards, exactly, Your Honor, the court. And that is satisfactory as far as I'm concerned, Mr. Edwards. Before we do that, I would like to address a couple of the things that have occurred this morning. First of all, whether relevant or not, I personally and on behalf of my clients do appreciate the presentation that Mr. Weingarten made and Mr. Marty Weinberg made. I have tremendous respect for Mr. Weinberg. I've worked with him through this and related cases for years, and I understand the reason why they made the presentation that they made. There are two things of interest to our clients in that respect. One is because of the tragic ending that none of my clients wanted, nor did I, nor did anyone else. If there is some civil rights violation and there is some civil remedy for Mr. Epstein that goes to the estate, certainly the victims are interested in that as they might help to repair the damage done. Second, Mr. Epstein's untimely death, the timing is curious to us, but more so, it makes it absolutely impossible for the victims to ever get the day in court that they wanted in court and to get full justice. That now can never happen. I know that Mr. Epstein's attorneys say he wanted it, and they know we did too. And there are a lot of people here today that are very sad by the way that this ended for both Mr. Epstein and the fact that full justice was robbed from them once again. The second issue I want to address was the law review or the law journal article that Your Honor referenced, which is troubling because the opinion seems to say that transparency is not appropriate in the criminal system and is not appropriate at this point in time. That's tough to swallow, especially in this case, given the long history of this case. Personally, it is tough to swallow, and on behalf of my clients, I can say that is very concerning. Transparency is the only way that the justice system works. We know this because there was a similar investigation of Mr. Epstein many years ago from 2005 to 2008. My personal involvement in this case was because a young female came into my office named Redacted, and she came to me not asking to file a lawsuit against Jeffrey Epstein, but simply asking for the government to talk to her. She was cooperating in an FBI investigation and wanted the government to speak with her, and I thought that was going to be an easy task. It was only a few months later that we learned that this investigation that was represented to my client in written form, that it would be a long investigation and to be patient, basically to hang tight. It was resolved by the way of a secret deal that never allowed any of the more than 30 victims who had been identified of Mr. Epstein's abuse in Florida to ever participate in a single hearing. There was a hearing. They were never notified. I then went on to represent many of them in civil cases and also in extensive pro bono work, and I can tell Your Honor that while Jeffrey Epstein's abuse of them hurt them and harmed them for many years, the feelings they had was aggravated exponentially by the facts that they had no rights in the criminal justice system, by the fact that they were treated as if they didn't matter. They were not allowed their rights under the Crime Victims' Rights Act to meaningfully confer with prosecutors, to be treated with fairness, to be treated with dignity. That is what this is supposed to be about, and to have notice of hearings. So I do want to thank Your Honor, and especially the prosecutors who have worked this investigation and this case, which is very different in experience for all my clients and the other Epstein victims in this case, because they were allowed to be part of the process. While some of them elected not to be here today, that opportunity should always be allowed for them. In 2008, we filed that case under the Crime Victims' Rights Act because our clients' rights were violated, and as Your Honor knows, a federal judge has ruled in our client's favor that their rights were violated. So this hearing today means a lot to them. The fact that they may never get their chance to speak in court, they may never get complete closure. And all of us have to wonder, if their rights had been afforded them the first time, would any of us be here now? Or wouldn't it more likely be the case that everyone, including Jeffrey Epstein, would have turned out better for it? Today, I've not only represented, but met and become very close with many of these victims, many of these survivors. They are very strong people. They are people who have persevered through a lot of adversity. It's been a roller coaster of emotions that has led us to where we are today. And while they have all been cast over the years because of the secrecy of the first investigation in the shadow as victims, you can't put them all in one bucket and say one size fits all. They are each individual people who are harmed differently and distinctly through not only the abuse, but the system. On behalf of all of them, I would like to thank Your Honor for the fairness with which they've been treated, and the United States Attorney's Office for the way in which you have handled this investigation, and especially how you have treated the victims in this case. Like I said, I have many who want to speak, some that can't. This is a very difficult day for them, but we appreciate the opportunity and the invitation. The first client that I have that is going to address Your Honor is the one who walked into my office in 2008 asking just to be heard, name redacted. The court. Hold on one second. Did you all want to be seated? You don't need to be standing. Whatever is more comfortable until you're ready to give some comments. It's up to you. Redacted. If you could spell your name for the court reporters, please. The name is redacted. My name is redacted, and I'm a victim of Jeffrey Epstein. Jeffrey Epstein sexually abused me for years, robbing me of my innocence and mental health. Jeffrey Epstein has done nothing but manipulate our justice system, where he has never been held accountable for his actions, even to this day. Jeffrey Epstein robbed myself and all the other victims of our day in court to confront him one by one, and for that, he is a coward. I want to thank the U.S. attorneys for seeking justice that has been long overdue, and most importantly, given us, the victims, our day in court to speak our piece and find some sort of closure. I feel very angry and sad that justice has never been served in this case. Thank you. The court. Thanks very much, Mr. Edwards. I believe my next client who is going to speak is probably going to speak as Jane Doe. Jane Doe number one. Yes, Jane Doe. The court. We'll say Jane Doe number one just for the record. Jane Doe number one. Okay. Thank you for allowing us to speak today. I've shifted what I want to say in hearing what's already been said, and just about the question of Jeffrey's death. I don't know what the relevance is to this hearing, but I do know that it is profoundly relevant to my life as a victim. I don't like that word, but I still feel like I am learning the ways that he's impacted me as a complex situation. But he was also a major part of my life. As destructive as that relationship was, and as much of a villain as we have created him to be, based on facts, we've created him to be a villain. He's a complex villain, and actually all of that is irrelevant. Anybody deserves an investigation is the right thing to do. Like, we do need to know how he died. I felt like a whole new trauma all over again. And I don't know why, because I'm trying to defend myself against him at this point in my life, but it still does not feel good. It didn't feel good to wake up that morning and find out that he had allegedly committed suicide. Okay. But I also want to say to the press, I'm reading, I read my story in the paper. I read so many other girl stories that are so similar to my own, and everything that's been focused on is not the most important part of it. The problem with focusing on the facts of the situation that were out of the ordinary, and because he was such a grand person and it was just a unique situation. I know that's the more interesting side of the story, but I don't want to be used as entertainment. And the fundamental problem of the whole situation is the element of exploitation and coercion, and these are things that so many girls can relate to. And even though this Jeffrey Epstein brought it to a grand scale on some level, a lot of girls could relate to the trauma that we are talking about. And even though this whole situation sucks, I would like to think that it may be possibly a catalyst for change, because obviously, as we're seeing with the Me Too movement, change needs to happen. And what I'm seeing in the papers is not a common story, but it's so much more common than you realize. That's all. Thank you. The court. Thank you very much. Mr. Edwards. I believe that the next client is going to also be a Jane Doe, so I think for the purposes of the record, it will be Jane Doe 2. The court. Yes. Jane Doe number 2. Good morning, Your Honor. The court. Good morning. How are you? Jane Doe number 2. Doing okay. I hadn't prepared any words to speak today, but there is something that was on my mind this morning when I got here. It's been on my mind and reading through the press and through the people that I've spoken to about it, friends, family. It's something that's bothered me because I think it has a lot of blame in it as well. A little bit of what my friend who was up here was speaking about. I think that a lot of people asked why we spent so much time, why we stayed. It's an experience that's really hard to explain to people who haven't gone through it. I think there's a writer, Thomas Nagel, who wrote an essay called What Is It Like to Be a Bat? And I think that he touches on it pretty strongly. And if you haven't experienced something, it's very hard to fully understand why someone makes the decisions they do and what the circumstances were. I don't want to speak for all of the victims. I think each of us has a different story and different circumstances for why we stayed in it. But for me, I think he was really strategic in how he approached each of us. Things happened slowly over time. We didn't, it was almost like putting it like that analogy of a frog being in a pan of water and slowly turning the flame up. You didn't realize it was happening. And it just, I don't think anyone can fully understand the experience, but the blame feels very strong. There's a lot of support as well, but I just want people to try to understand that we aren't bad people. We weren't it wasn't a situation where we were trying to extort money from someone. A lot of us were in very vulnerable situations and in extreme poverty, circumstances where we didn't have anyone on our side to speak on our behalf. And that's really scary. You start to blame yourself because at first, you don't tell anyone what's happening, and it becomes your deep, dark secret that you tried to keep from everyone. And I didn't even know I was a victim until I spoke with my lawyers. I had no idea. I had so much self-hatred and doubt and just guilt for everything. I still do. I still don't feel like I deserve to say I'm a victim. And I think that's a big problem with our society right now, that people are still blaming victims. And I think that does need to change. I hope that today people understand that each of us has a story, has a past, has a family, and just give us a chance to, that's basically all I just wanted to say. The court, thank you so much. Jane Doe number 2, thank you so much. The court. Okay. Mr. Edwards. Okay, I think that the next person who is going to speak is also going to be speaking as Jane Doe. So for the purposes of the record, Jane Doe number 3. Jane Doe number 3, thank you for allowing us to speak today. I came to New York City 15 years ago to pursue modeling from a small town. I signed on with an agency and was excited to pursue my passion and my dream. Several months later, I met a female who told me about Mr. Epstein. She portrayed him as an amazing man who genuinely cared for people and that he was going to be able to help me in a modeling career. I was excited to meet him. After hearing her talk about him, he sounded like an amazing person. An introduction was made at his New York home, and it is there that I was sexually assaulted. I left his home after he threw me, basically put money on the table, and I was ashamed. I was embarrassed. This was not the way I was brought up, and I couldn't believe that this had happened to me. I left, and my world kind of spiraled after that. I stopped going on modeling castings. I gained weight. I became depressed. I stopped going out with my friends, and only 5 months after I had been in New York City to pursue my dream, I left. I left the modeling industry, and I left New York City, and I totally switched my career paths. I buried this deep within me, and all of the new occurrences that have come up in the media, it's what brought it back up for me. And I feel sickened and saddened that it took so many years and God knows how many victims for this to finally come out. But I'm thankful it did. And I'm just angry that he's not alive anymore to have to pay the price for his actions. So I thank you for your time. The court, you're very welcome. Mr. Edwards. Your Honor, Jane Doe number 4, I believe, is going to speak now. Jane Doe number 4. Good morning, Your Honor. The court. Good morning. Jane Doe number 4. I just have something very short to say. I met Jeffrey Epstein at a very vulnerable place in my life. And whatever the outcome is with everything, I just wanted to express that we, the victims, we will always carry irreparable damage and pain throughout our lives after this. It's something that's never going to go away. You know, whoever we marry in our life, whatever future we have in our life, it's always going to be something that's always there for us. And I'm very nervous right now. And Jeffrey Epstein, he took away the chance I had at having the future I had envisioned for myself as a young girl. And I think many of us here today will never fully heal from that pain and the heartache that will continue carrying with us. So I just wanted to say that. It's something that's irreparable. I can't even really use a better word to describe that. So thank you for hearing us today. The court, you're very welcome. Mr. Edwards, Your Honor, Jane Doe number 5 would like to speak. Jane Doe number 5. This is a letter that I wrote, so it's going to be, Dear Jeffrey, I think you are a mentally disturbed human being. You used your power to make me believe at a young age that I could have my dreams of being a model. You paid for your freedom. You violated my rights. You should have to pay for them just as anyone else. You got a plea deal that no one else would have been able to get. You used your money to get out of paying the price for your actions. Also, as a victim, I never got to see what the agreement was or why the special treatment got approved. I think you should have been in jail for several years in population and lived like everyone else that is mentally disturbed like you. You paid for yourself to get special treatment while you were in jail. Don't even think you spent a day in jail as a normal human being. You had investigators come to my house and also went to my friend's house to question them. I will never be able to I will never be able to get over the overwhelming emotions and embarrassment I experienced from that trauma. I needed therapy several times a week and had high stress and anxiety levels. You paid your way to make the public think that the girls had nothing in life going on for them. You wanted to try and blame that we were lower class, and that was the problem with the girls. I was from a middle class family and did well in school. I lived the American girl dream or the American girl life. I went on family vacations around the world, grew up in a good city, and my parents are still married to this day. Basically, everything you said that we didn't have in our life, I did. It all came down to I was told I was making $200 in an hour. Being young, that was a lot of money, and I didn't know any better. Sadly, you were the one with an illness that you should have to go and see a doctor and also have a mentor group for the sickness you have. I will continue with writing my book about that secret life with all the newspaper articles of the case, my high school agenda book off official dates. I'm basing that proof that I deposited cash after leaving Jeffries. I still have all of the information, articles that I collected over the years. You mentally and physically traumatized me. I went to therapy, and it was the best thing I did for myself. If anyone only learns one thing from this case, I hope it is that money should not let you buy your way free. A crime is a crime, and a victim is a victim. Thank you. The court, thank you. Thank you very much. Mr. Edwards, Your Honor, my next client is redacted. I met Jeffrey Epstein through my first massage teacher, a man who took me in as his apprentice to teach me a practice I wanted to learn while in desperate search to find a cure for a debilitating neurological disorder that I have, which manifests into violent vomiting attacks largely triggered by stress. It's called cyclic vomiting syndrome. I was recruited by Ghislaine Maxwell. Upon my first meeting of her, I wouldn't know that I had been recruited until many years later when I would read it in a headline. Ghislaine and Jeffrey took me in. They sent me to school. They gave me a job. They flew me around the world, introduced me to a world I had only dreamt of, and made me feel as though I had become a part of their family, another thing I was desperately searching for. But on my third or fourth time meeting them, they brought me to Jeffrey's Island for the first time. And on the first night there, redacted, came tapping on my door late at night to inform me Jeffrey was ready for another massage. My instincts told me this didn't feel right, but I got up and followed her to a villa I hadn't yet seen, Jeffrey and Ghislaine's villa. I began my massage, trying not to let him smell my fear and obvious discomfort, but before I knew what was happening, he grabbed onto my wrist and tugged me towards the next half page is redacted. I spent 2 weeks vomiting, almost to death, in a Los Angeles hospital after that first encounter. Jeffrey's abuse would continue for the next 3 years, and I allowed it. That's the end of the transcript. And those were the voices of survivors, women who showed up to a federal courthouse to confront a man who was already dead because they had been denied that moment for decades. Some gave their names, some of them didn't, but all of them told the truth. Jeffrey Epstein died in custody before he could be held accountable in open court. But the men who enabled him, who protected him, and benefited from what he did, many of them are still very much alive. And the institutions that looked the other way, that offered him sweetheart deals and treated his victims as inconveniences, those institutions are still functioning. That's why this transcript matters. That's why this reading matters. Not as historical artifact, but as an indictment, an active indictment. If you want to know why so many Americans have lost faith in the idea that the law applies equally to everyone, this is your answer. It's right here in the words of these women who had to fight for decades just to be heard in an empty courtroom after the man who hurt them had already escaped the only justice that was available. We owe it to them to keep asking the questions that powerful people would prefer we didn't. Thank you so much. I'm Ken Harbaugh.
Love for you to introduce yourself before you read and kind of let folks know what we're hoping to accomplish with this event. Thanks.
Thank you, Eliza, and thank you so much for being our MC and helping us put this on in such a short period of time. At the Save America movement, we were watching the testimony of the survivors in Palm Beach last week, and we were struck by how little coverage their testimony that was so extraordinary. We were struck by how little it was covered by the mainstream media, and from that observation came this idea to do this 24-hour Epstein Files filibuster, to force eyes to this story and take a step to keep this critical story in top of mind for America. So I'm very honored to be here. I've been so moved by everything that I've experienced today. It's hard to put into words, but these survivors deserve justice. They deserve accountability, and I know that we won't stop until they get it. So I'll start reading. From Redact to Jeffrey Epstein. I understand that you want to do better for me, but you should understand what is better firstly. It's like feeding someone who likes oranges very much, but have a severe allergy on them. I appreciate your help very much. You taught me and showed me a lot, but you can't change me. Excuse me for being not happy as you used to see those baby dolls. Excuse me for not answering your emails on time because Redact very busy. And for looking like a shit when I came to you, etc. Yes, young, but not that stupid Jeffrey. And I know what do usually mean and usually doesn't. There's some, I think, translation here. I know what you expect from me, Jeffrey, but I will not say that, not for me. Sometimes it's better to say, darling, beautiful bitch who comes to your house, and you like me, everybody likes me, and I love myself, and you also. I am in trouble. Troubles, darling. Transfer me money, sweetheart. You can't say no. You're a gentleman. Yes? Successful. Yes? Yes? I see it every day and how it works, and I had a lot of opportunities to say that by myself to a lot of people, believe me. Of course, they also tell, you baby girl are going to go with me at my place. I will fuck you twice. You will suck my cock, and I will have your ass 3 times. End quote. Gosh, how good it works. All right, Jeffrey. You have a lot of them. Go ahead. I know that I was that one who never did something for you when she didn't want to, and never expecting something back. Believe me, if I had an opportunity, I would never take money from you when going home. Sorry, not used to this world. Not your daughter for you to deal with my problems. And this is all my fault. I chose it myself. Me was not working. Me was taking money from friends and enemies just because no choice was seen at that moment. But it will be seen, I believe. Can't see the reason to delay my ticket. It should be better to bring it back. Can't see the reason to meet me the second day. Not a toy, Jeffrey. Thank you. From Jeffrey Epstein. Bring all the info, your arrest and court date, your visa info. From Redact. Hello, Jeffrey. Firstly, about jail. You are the person with whom I should be honest. That's for shoplifting. I was at Macy's with Redact, and both of us took some clothes from the men's department and went to the women's fitting rooms to put them in the bag. One Fred said that this place is the most easy to take something a long time ago. I never used to do that, but when I recognized that I need to go home and even have nothing from my dad, brother, and boyfriend, I made this stupid thing first and last time in my life. So they put us in jail, but Redact was out in the night and I moved to the prison. It was awful. I was sitting with 24 sick Afro-Americans till the evening of next day. I can't believe how it was for you. Then I had my court, and my lawyer said that I can go to it when I will come back to it. Freedom is the most expensive that we have. Sorry for that news. I didn't expect that from myself either. As about going home, I don't know. I don't know, Jeffrey. Going crazy. I'm really ready to lose my head. I want to tell you everything and know how you think about that, because nowadays you're the only person who can tell me what is better. Thinking of me, and this will be the most clever answer. I have my ticket on the 11th. I called my mom. She picked up the phone at this time, but is not talking to me. I just said the date when I come for her to know. I was happy to hear something different from do whatever you want, as usual. If you come back to live in your Redact, however you want, and we just don't care. That's because my parents are too angry on me. I made so many mistakes. And the main thing that hurts is that my dad is not even talking with mom because of me. And it's very difficult to know that my dear mother is all alone and mad about everything. That's why I want to go back home. I didn't see them from June, and I want to say sorry to them and make my parents live together. Concerning my study, it is a really good university. Despite that it is an English education system, and all my lessons are in English and in similar program. It is kind of franchise university. Westminster International University in Redacted. I like it very much, and I really want to study there. Maybe I will transfer to U.S. University in the future, but I don't want to lose the year because Redact here. I should go home and finish the year for it. Despite the fact that I have nothing to pay for it, but I hope to be good with parents. Jeffrey, but I have a lot of money that I owe to people. I know this is stupid. Redact. A lazy fuck, as you usually say, but I really can't leave this country until I deal with them. And moreover, I owe to Redact, and that is the most awful thing ever, because she paid for me from January for everything. I hope to have my job at the end of January as a model. Very good, but they didn't like my hair. Now she is on her way to home, and every time says to me, I can't go home because I need my money, and I understand her. I just the day before yesterday counted everything I need to do and to resolve and understand that this is a huge amount of money, but there is no other choice. I can't go home without it. I really can't. I need to give credit at Chase, which from September, I need to give Redact her money. And my two friends also, I need to pay for my study, buy suitcases, pay for overweight, buy something home, minimum, pay for my study, put on braces, live for the first time in a dormitory because I will have my work from March at Aegis Engineering Company. They took me and I can feed myself, so this is impossible. I should wait and stay here to have some work and solve the problems. I can't go home like that in addition to my parents really mad at me. But I thought about not going home, but I can't stay here. My visa expires on the 16th. Redact is finally going home. Redact alone. Nowhere to live, nothing to do. You understand that it is impossible. And moreover, I should call my parents and tell them I was studying in the university for 4 years and now even will not end my year. Having nothing, I will stay in U.S. without visa and do nothing, nowhere, and with nobody. I don't know, Jeffrey, what is better. I Redact really tired. I don't even know how I could get in such a situation. Oh, I know, but then I think about how stupid I am to do that. Today is 8th. My flight is on 11th. I am sorry for writing such a big mess, but I wanted to tell this to somebody. You're the only who can tell me the right things. I see you are my friend and wish all the best for me. Tuesday, March 13th, 2012. From Redact to Jeffrey Epstein. Come at 12, 9 East 71st Street. From Redact, wrote, morning. So I survived the Met in one piece with, awful stories other than it was emotional, and I went home to bed, big gold star. How are you, honey, and when are you free? Are you free? X. From Jeffrey Epstein to Redact. I didn't call anyone. I will find out. From Redact, wrote, sorry I didn't come see you today. I didn't feel great and didn't leave my hotel. As you called my mother, you know where I am. Calling my mother is out of bounds. I would not call yours. I will be free after tomorrow and hope we can see each other. From Jeffrey Epstein to Redact. Please try to remember you must not take direction from others. Okay. The grand jury charges. The charges set forth herein stem from the role of Ghislaine Maxwell, the defendant, in the sexual exploitation and abuse of multiple minor girls by Jeffrey Epstein. In particular, from at least in or about 1994, up to and including at least in or about 1997, Maxwell assisted, facilitated, and contributed to Jeffrey Epstein's abuse of minor girls by, among other things, helping Epstein to recruit, groom, and ultimately abuse victims known to Maxwell and Epstein to be under the age of 18. The victims were as young as 14 years old when they were groomed and abused by Maxwell and Epstein, both of whom knew that certain victims were in fact under the age of 18. As a part and in furtherance of their scheme to abuse minor victims, Maxwell, the defendant, and Jeffrey Epstein enticed and caused minor victims to travel to Epstein's residences in different states, which Maxwell knew and intended would result in their grooming for and subjection to sexual abuse. Moreover, in an effort to conceal her crimes, Maxwell repeatedly lied when questioned about her conduct, including in relation to some of the minor victims described herein when providing testimony under oath in 2016. During the time periods charged in this indictment, Maxwell, the defendant, had a personal and professional relationship with Jeffrey Epstein and was among his closest associates. In particular, between in or about 1994 and in or about 1997, Maxwell was in an intimate relationship with Epstein and also was paid by Epstein to manage his various properties. Over the course of their relationship, Maxwell and Epstein were photographed together on multiple occasions. Beginning in at least 1994, Ghislaine Maxwell, the defendant, enticed and groomed multiple minor girls to engage in sex acts with Jeffrey Epstein through a variety of means and methods, including but not limited to the following. A. Maxwell first attempted to befriend some of Epstein's minor victims prior to their abuse, including by asking the victims about their lives, their schools, and their families. Maxwell and Epstein would spend time building friendships with minor victims by, for example, taking minor victims to the movies or shopping. Some of these outings would involve Maxwell and Epstein spending time together with a minor victim, while some would involve Maxwell or Epstein spending time alone with a minor victim. Having developed a rapport with a victim, Maxwell would try to normalize sexual abuse for a minor victim by, among other things, discussing sexual topics, undressing in front of the victim, being present when a minor victim was undressed, and or being present for sex acts involving the minor victim and Epstein. Maxwell's presence during minor victims' interactions with Epstein, including interactions where the minor victim was undressed or that involved sex acts with Epstein, helped put the victims at ease because an adult woman was present. For example, in some instances, Maxwell would massage Epstein in front of a minor victim. In other instances, Maxwell encouraged minor victims to provide massages to Epstein, including sexualized massages during which a minor victim would be fully or partially nude. Many of those massages resulted in Epstein sexually abusing the minor victims. In addition, Epstein offered to help some minor victims by paying for travel and or educational opportunities, and Maxwell encouraged certain victims to accept Epstein's assistance. As a result, victims were made to feel indebted and believed that Maxwell and Epstein were trying to help them. Through this process, Maxwell and Epstein enticed victims to engage in sexual activity with Epstein. In some instances, Maxwell was present for and participated in the sexual abuse of minor victims. Such incidents occurred in the context of massages, which developed into sexual encounters. Maxwell, the defendant, facilitated Jeffrey Epstein's access to minor victims, knowing that he had a sexual preference for underage girls and that he intended to engage in sexual activity with those victims. Epstein's resulting abuse of minor victims included, among other things, touching a victim's breast, touching a victim's genitals, placing a sex toy such as a vibrator on a victim's genitals, directing a victim to touch Epstein while he masturbated, and directing a victim to touch Epstein's genitals. Between approximately in or about 1994 and in or about 1997, Maxwell, the defendant, facilitated Jeffrey Epstein's access to minor victims by, among other things, inducing and enticing and aiding and abetting the inducement and enticement of multiple minor victims. Victims were groomed and are abused at multiple locations, including the following: a multi-story private residence on the Upper East Side of Manhattan, New York, owned by Epstein, the New York residence; an estate in Palm Beach, Florida, owned by Epstein; a ranch in Santa Fe, Mexico, owned by Epstein; Maxwell's personal residence in London. Among the victims induced or enticed by Maxwell, the defendant, were minor victims identified herein as minor victim 1, minor victim 2, and minor victim 3. In particular, and during time periods relevant to this indictment, Maxwell engaged in the following acts, among others, with respect to minor victims. Maxwell met minor victim 1 when minor victim 1 was approximately 14 years old. Maxwell subsequently interacted with minor victim 1 on multiple occasions at Epstein's residences, knowing that minor victim 1 was under the age of 18 at the time. During these interactions, which took place between approximately 1994 and 1997, Maxwell groomed minor victim 1 to engage in sexual acts with Epstein through multiple means. First, Maxwell and Epstein attempted to befriend minor victim 1, taking her to the movies and on shopping trips. Maxwell also asked minor victim 1 about school, her classes, her family, and other aspects of her life. Maxwell then sought to normalize inappropriate and abusive content by, among other things, undressing in front of minor victim 1 and being present when minor victim 1 undressed in front of Epstein. Within the first year after Maxwell and Epstein met minor victim 1, Epstein began sexually abusing minor victim 1. Maxwell was present and involved in some of this abuse. In particular, Maxwell involved minor victim 1 in group sexualized massages of Epstein. During those group sexualized massages, Maxwell and or minor victim 1 would engage in sex acts with Epstein. Epstein and Maxwell both encouraged minor victim 1 to travel to Epstein's residences in both New York and Florida. As a result, minor victim 1 was sexually abused by Epstein in both New York and Florida. Minor victim 1 was enticed to travel across state lines for the purpose of sexual encounters with Epstein, and Maxwell was aware that Epstein engaged in sexual activity with minor victim 1 after minor victim 1 traveled to Epstein's properties, including in the context of a sexualized massage. Maxwell interacted with minor victim 2 on at least one occasion in or about 1996 at Epstein's residence in New Mexico when minor victim 2 was under the age of 18. Minor victim 2 had flown into New Mexico from out of state at Epstein's invitation for the purpose of being groomed for and or subjected to acts of sexual abuse. Maxwell knew that minor victim 2 was under the age of 18 at the time. While in New Mexico, Maxwell and Epstein took minor victim 2 to a movie, and Maxwell took minor victim 2 shopping. Maxwell also discussed minor victim 2's school, classes, and family with minor victim 2. In New Mexico, Maxwell began her efforts to groom minor victim 2 for abuse by Epstein by, among other things, providing an unsolicited massage to minor victim 2, during which minor victim 2 was topless. Maxwell also encouraged minor victim 2 to massage Epstein. Maxwell groomed and befriended minor victim 3 in London, England, between approximately 1994 and 1995, including during a period of time in which Maxwell knew that minor victim 3 was under the age of 18. Among other things, Maxwell discussed minor victim 3's life and family with minor victim 3. Maxwell introduced minor victim 3 to Epstein and arranged for multiple interactions between minor victim 3 and Epstein. During those interactions, Maxwell encouraged minor victim 3 to massage Epstein, knowing that Epstein would engage in sex acts with minor victim 3 during those massages. minor victim 3 provided Epstein with the requested massages, and during those massages, Epstein sexually abused minor victim 3. Maxwell was aware that Epstein engaged in sexual activity with minor victim 3 on multiple occasions, including at times when minor victim 3 was under the age of 18, including in the context of a sexualized massage. Maxwell's efforts to conceal her conduct. In or around 2016, in the context of a deposition as part of civil litigation, Maxwell, the defendant, repeatedly provided false and perjurious statements under oath regarding, among other subjects, her role in facilitating the abuse of minor victims by Jeffrey Epstein, including some of the specific events and acts of abuse detailed above. From at least in or about 1994 up to and including in or about 1997 in the Southern District of New York and elsewhere, Maxwell, the defendant, Jeffrey Epstein, and others known and unknown, willfully and knowingly did combine, conspire, and agree together and with each other to commit an offense against the United States, to wit, enticement in violation of Title 18 United States Code, Section 2422. It was part and object of the conspiracy that Maxwell, the defendant, Jeffrey Epstein, and others, known and unknown, would and did knowingly persuade, induce, entice, and coerce one and more individuals to travel interstate and foreign commerce to engage in sexual activity for which a person can be charged with a criminal offense in violation of Title 18 United States Code, Section 2422. Overt acts. In furtherance of the conspiracy and to effect the illegal object thereof, the following overt acts, among others, were committed in the Southern District of New York and elsewhere. A. Between in or about 1994 and in or about 1997, when minor victim 1 was under the age of 18, Maxwell participated in multiple group sexual encounters with Epstein and minor victim 1 in New York and Florida. B. In or about 1996, when minor victim 1 was under the age of 18, minor victim 1 was enticed to travel from Florida to New York for purposes of sexually abusing her at the New York residence, in violation of New York Penal Law, Section 130.55. In or about 1996, when minor victim 2 was under the age of 18, Maxwell provided minor victim 2 with an unsolicited massage in New Mexico, during which minor victim 2 was topless. D. Between in or about 1994 and in or about 1995, when minor victim 3 was under the age of 18, Maxwell encouraged minor victim 3 to provide massages to Epstein in London, England, knowing that Epstein intended to sexually abuse minor victim 3 during those massages. Count 2, enticement of a minor to travel to engage in illegal sex acts. The grand jury further charges the allegations contained in paragraphs 1 through 8 of this indictment are repeated and realleged as if fully set forth within. From at least in or about 1994 up to and including in or about 1997 in the Southern District of New York and elsewhere, Maxwell, the defendant, knowingly did persuade, induce, entice, and coerce an individual to travel in interstate and foreign commerce to engage in sexual activity, which a person can be charged with a criminal offense and attempted to do the same and aided and abetted the same, to wit, Maxwell persuaded, induced, enticed, and coerced minor victim 1 to travel from Florida to New York on multiple occasions with the intention that minor victim 1 would engage in one or more sex acts with Jeffrey Epstein in violation of New York Penal Law, Section 130.55. Count 3, conspiracy to transport minors with intent to engage in criminal sexual activity. from at least in or about 1994 up to and including in or about 1997 in the Southern District of New York and elsewhere, Maxwell, the defendant, Jeffrey Epstein, and others known and unknown, willfully and knowingly did combine, conspire, and agree together and with each other to commit an offense against the United States. Transportation of minors in violation of Title 18, United States, Section 2423. It was a part and object of the conspiracy that Maxwell, the defendant, Jeffrey Epstein, and others, known and unknown, would and did knowingly transport an individual who had not attained the age of 18 in interstate and foreign commerce, with intent that the individual engage in sexual activity for which a person can be charged with a criminal offense in violation of Title 18, United States Code, Section 2423A. Overt acts. Between in or about 1994 and in or about 1997, when minor victim 1 was under the age of 18, Maxwell participated in multiple group sexual encounters with Epstein and minor victim 1 in New York and Florida. In or about 1996, when minor victim 1 was under the age of 18, minor victim 1 was enticed to travel from Florida to New York for purposes of sexually abusing her at the New York residence in violation of New York Penal Law, Section 130.55. In or about 1996, when minor victim 2 was under the age of 18, Maxwell provided minor victim 2 with an unsolicited massage in New Mexico, during which minor victim 2 was topless. Between in or about 1994 and in or about 1995, when minor victim 3 was under the age of 18, Maxwell encouraged minor victim 3 to provide massages to Epstein in London, England, knowing that Epstein intended to sexually abuse minor victim 3 during those massages. Count 6, perjury. The grand jury further charges 22. The allegations contained in paragraphs 1 through 8 of this indictment are repeated and realleged as if fully set forth within. On or about July 22nd, 2016, in the Southern District of New York, Maxwell, the defendant, having taken an oath to testify truthfully in a deposition in connection with the case then pending before the United States District Court for the Southern District of New York under docket number 15 Civ 7344, knowingly made false material declarations. Maxwell gave the following underlined false testimony. Were you aware of the presence of sex toys or devices used in sexual activities in Mr. Epstein's Palm Beach house? Answer: no, not that I recall. Question: do you know whether Mr. Epstein possessed sex toys or devices used in sexual activities? Answer: no. Question: other than yourself and the blonde and brunette that you have identified as having been involved in three-way sexual activities, with whom did Mr. Epstein have sexual activities? Answer: I wasn't aware that he was having sexual activities with anyone when I was with him other than myself. Question: I want to make sure that I'm clear. Is it your testimony that in the 1990s and 2000s, you were not aware that Mr. Epstein was having sexual activities with anyone other than yourself and the blonde and brunette on those few occasions when they were involved with you? Answer: that is my testimony. That is correct. Question: is it your testimony that you've never given anybody a massage? Answer: I have not given anyone a massage. Question: you never gave Mr. Epstein a massage? Is that your testimony? Answer: that is my testimony. Question: you never gave minor victim 2 a massage? Is that your testimony? Answer: I never gave minor victim 2 a massage. Great. Thank you.
Mary, thank you so much. So, we are almost 9.5 hours into our 24-hour live stream. Let's go. And we are doing Cover to Cover Up, a public reading of the Epstein files from the Donald J. Trump and Jeffrey Epstein reading room in Lower Manhattan. This event is a collaborative effort from the Save America movement and the Institute for Primary Facts. So I am going to read. I am reading from Southern District of New York, Grand Jury Testimony, United States of America versus Ghislaine Maxwell, June 29th, 2020, 10:04 a.m. Colloquy proceeds, witness enters room, time noted 10:16 a.m. Redacted, called as a witness, having been duly sworn by the foreperson of the grand jury, was examined and testified as follows. By Miss Blank. Redacted. Good morning. Answer. Good morning. Question. Can you please state your full name for the record? Answer. Redacted. Redacted. Question. So I recognize that you are wearing a mask and behind plexiglass. There's a microphone in front of you. If you could just make an effort to speak into the mic and keep your voice up, that would be great. Answer. No problem. Question. Where do you currently work? Answer. The Federal Bureau of Investigation. Question. What is your title? Answer. Special Agent. Question. How long have you worked as a special agent? Answer. About 3 years. 3 years now. Question. Where are you currently assigned? Answer. I work on the Violent Crimes Children's Squad. Question. What are your duties and responsibilities as a special agent on that squad? Answer. We investigate crimes that have to do with child sexual abuse material, sextortion, exploitation, and enticement of minors, sex trafficking. Grand juror. Maybe if she could take the mask off, is anybody having difficulty understanding her? Miss Blank, thanks for letting me know. Would it be okay with you if the witness took her mask off? Grand juror, we're okay with plexiglass, right? Grand juror, yeah. Miss Blank, thanks very much. Thank you. Question. All right, so I'm just going to go back and ask a few of those questions again to make sure that everyone could hear, except you all heard me, so I'm not going to repeat them. Can everyone hear the witness? And Special Agent Blank, if you could try and keep your voice up, I appreciate it. It's a little difficult under the circumstances. Question. Have you participated in an investigation of Ghislaine Maxwell? Answer. Yes, I have. Question. Have you spoken to other people, including other law enforcement officers, about this investigation? Answer. Yes. Question. Have you reviewed reports and documents prepared by others regarding this case? Answer. Yes. Question. Is your testimony today based in part on those conversations with other law enforcement officers and documents that you have reviewed? Answer. Yes. Miss Blank. Ladies and gentlemen, let me give you a brief instruction. Some of the testimony that you will hear today will include what's called hearsay. As you know, that means that the witness will not be testifying solely from her own observations, but that she'll also be reporting to you from what others have told her and what she's read in reports and documents prepared by other people. Hearsay evidence is admissible in these grand jury proceedings, and you're free to rely on it in determining whether there's probable cause to indict the proposed defendant. If, however, you would like to hear the testimony of any other witness, you have the right to request it, and we will make reasonable efforts to bring that witness before you. By Miss Blank. Special Agent Blank, we placed on the desk in front of you a PowerPoint that is Grand Jury Exhibit 2, which we're entering into the record. Do you recognize this? Answer, yes. Question, what is it? Answer, it is a PowerPoint presentation to assist in testifying today. Question, did you participate in preparing this exhibit in connection with your testimony today? Answer, yes, I did. Question, if you could please turn to the first slide, who are the individuals depicted in these photographs? Answer, the picture on the left is Ghislaine Maxwell, and the picture on the right is Jeffrey Epstein with Ghislaine Maxwell. Question, based on your participation in this investigation and your review of public source materials, have Maxwell and Epstein been photographed together many times over the years? Answer, yes. Question, based on your participation in this investigation and your review of public materials, where is Maxwell from? Answer, Maxwell was born in France. She grew up in the United Kingdom, was educated in Oxford, and is from a wealthy family. Question, is she a citizen of France, the United Kingdom, and the United States? Answer, yes. Question, how old is she currently? Answer, 58. Question, has the FBI investigated Maxwell and Epstein's conduct with minors during the 1990s? Answer, yes. Question, generally speaking, what have you learned about the relationship between Maxwell and Epstein during the 1990s? Answer, Epstein and Maxwell had a romantic relationship, and she also worked for him, managing his homes, hiring and firing individuals. Question, during that time period, was she one of his closest associates? Answer, yes. Question, during the course of this investigation, have you learned where Epstein maintained properties in the 1990s? Answer, yes. Question, where did he maintain properties? Answer, New York, Palm Beach, and New Mexico. Question, turning to the next slide, did he maintain an address in Manhattan located at 9 East 71st Street? Answer, yes. Question, does this slide fairly and accurately depict the residence? Answer, yes. Question, can you please describe that property for the grand jury? Answer, it's a 7-story home. It's located near Central Park. It's reportedly the largest residence in Manhattan. Question, based on your participation in this investigation, did that house include a room that was used as a massage room? Answer, yes, it did. Question, all right, we'll talk more about that later, but for now, moving on to other properties. Did he maintain an address in Palm Beach, Florida, located at 358 El Brillo Way? Answer, yes. Question, turning to the next slide, does this slide fairly and accurately depict that residence? Answer, yes, it does. Question, could you please describe that property for the grand jury? Answer, it's a waterfront estate. It has an in-ground pool and a detached dwelling or pool house on the property as well. Question, and from your participation in this investigation and your review of other materials, did that house include a room that was used as a massage room? Answer, yes. Question, turning to the next property, did Epstein also own a ranch in New Mexico? Answer, yes, he did. Question, and turning to the next slide, was that property located at 49 Zorro Ranch Road in Stanley, New Mexico? Answer, yes. Question, looking at the photograph on this slide, does this accurately depict that property? Answer, yes, it does. Question, and we've been talking about the properties that Epstein owned during this period. Did he also own a private jet? Answer, yes. Question, is it fair to say that he was a multimillionaire during this time period? Answer, yes. During the 1990s, did Epstein have an employee, redacted, who ran his house in Palm Beach? Answer, yes, he did. Question, what was his job? Answer, his job was making sure that everything in the house ran smoothly. He described that Epstein liked to have his house run like a 5-star hotel, that everything had to be in its proper place. So he was responsible for managing that. Question, have you interviewed redacted? Answer, yes. Question, how many times? Answer, twice. Question, and is the information you're about to provide based on your interviews with redacted? Answer, yes. Did redacted begin working for Epstein in the early 1990s? Yes, he did. And at the time redacted came to work for Epstein in Palm Beach, was Epstein dating Ghislaine Maxwell at that point? Answer, not at that time. Question, was it a few years before Epstein began dating Maxwell after blank started working there? Answer, yes. From what blank told you, how did blank's work change once Maxwell arrived on the scene? Blank described Epstein as being more pleasant to work with prior to Maxwell coming into the picture. Once she came into the picture, he said things became more secretive. He wasn't allowed to be in the room with guests, wasn't allowed to talk with them, associate with them. It became a different environment. Question, you talked about some of the rules that were placed changing. Were there any rule changes about eye contact once Maxwell began staying in the Palm Beach house? Answer, yes. Blank wasn't allowed to make eye contact with Epstein and others. Question, in general, how did he describe what it was like to work for Maxwell? Answer, he said she was very demanding. She was on top of him all the time. He described her as a, quote, bitch. Is that the word he used? That's the word he used. Shifting gears, I want to talk about someone else you've interviewed during this investigation. During the course of this investigation, have you participated in interviews with an individual named blank blank? Yes. So for these purposes, I'm just going to refer to her as blank, okay? Yes. How many times have you interviewed her? Approximately 5 times. If you could please just page through the next 2 slides in front of you. Are these photographs of blank? Answer, yes. Question, is it your understanding that these photographs depict blank from approximately ages 13 to 17? Answer, yes, it does. Question, okay, let's take a look at some of those photographs. I'm going to publish the next slide. Is blank's date of birth blank? Yes. And are these 2 photographs of blank? Answer, yes, they are. Question, if you could turn to the second slide of the photographs, are these also photographs of blank? Answer, yes. Question, based on your participation in this investigation and your interviews with blank, where was she living when she was approximately 14? Answer, she was living in Palm Beach, Florida. Question, who was she living with when she was 14? Answer, her mother and her siblings. Question, what was her whole life like at that time? Answer, at that time, her father had passed away the year prior, so the family was struggling financially and having some difficulties. Question, what did blank's father do before he passed away? What was his profession? He was involved in redacted, redacted, redacted. There are 2 lines redacted here. Was blank involved in blank? Yes, she was. Were her siblings? Yes. What kinds of blank were they involved in? Blank, blank. Answer, singing. She was a singer. Question, what kind of singer? Answer, opera. In the summer of 1994, how old was blank? Answer, she was 13, going on 14. You testified earlier that her birthday is blank, so did she turn 14 in blank of 1994? Answer, yes. What did she do that summer? Answer, she attended an arts camp at Interlochen Center for the Arts. Question, and is Interlochen Summer Arts Program located in Michigan? Answer, yes. Question, did blank meet Jeffrey Epstein and Ghislaine Maxwell that summer? Answer, yes, she did. Question, did she meet them at summer camp? Answer, yes. What did she tell you about that? She said that she was sitting at a picnic table with friends when Epstein and Maxwell walked by. They stopped to talk to her, engaged her in conversation, asked her if she liked her classes, her teachers. During that conversation, they found out she was also from Palm Beach, and that he said he gives scholarships to students. Question, how did they leave the conversation? Was there any contact information exchanged? Answer, they asked blank for her phone number. Question, as part of your investigation, have you attempted to gather records to corroborate that blank, Maxwell, and Epstein were all at the summer camp that summer? Answer, yes. Question, if you could turn to the next slide, please. Have you obtained records from Interlochen for the summer of 1994? Answer, yes. Question, and what are we looking at on this slide? Answer, this shows who some of the individuals that were there were present for that camp in 1994. On here is blank, 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 blank. The rest of the line is redacted. Question, and have you investigated whether Maxwell and Epstein were also at Interlochen that summer of 1994 as described? Answer, yes. Question, based on your review of records from Interlochen, what is your understanding of Epstein's relationship with Interlochen? Answer, my understanding is that he was a donor to the school. Question, did he make any substantial donations? Answer, yes, he did. Question, did he donate a lodge to the camp in the summer of 1994? Answer, yes, he did. Question, did he have a long-standing relationship as a donor to Interlochen? Answer, yes. Question, turning to the next slide, is this an excerpt of a letter from Interlochen to Epstein? Answer, yes, it is. Question, and does this letter thank Epstein for donating a scholarship lodge? Answer, yes. Question, does it invite Epstein to visit in August of 1994? Answer, yes. In 1994, did Epstein have a private jet? Answer, yes, he did. Question, have you obtained the flight logs for that jet? Answer, yes. Question, do those logs include passenger lists and the airport code for the airports that the plane flew into and out of? Answer, yes. Question, turning to the next slide, is this a page of the flight logs that you've reviewed? Answer, yes. Question, and on this excerpt of the flight logs, where the red arrow is that a log entry showing an August 18th, 1994 flight to an airport with the airport code TVC? Answer, yes. Is the TVC airport code for Cherry Capital Airport in Traverse City, Michigan? Answer, yes, it is. Question, about how far is that airport from Interlochen by car? Answer, it's about 25 minutes, give or take. Question, and who were the listed passengers on this flight? Answer, Jeffrey Epstein, redacted, and redacted, redacted. Question, turning to the next slide, is this the same excerpt but with a different arrow? Answer, yes. Okay, so a few lines down, is there a flight out of Traverse City just 2 days later on August 20th, 1994? Answer, yes. Question, and do the passengers listed in the flight out of Traverse City include the initials GM? Answer, yes, they do. Are those Ghislaine Maxwell's initials? Answer, yes. Have you obtained any records from Interlochen to indicate that Maxwell was at Interlochen in 1994? Answer, yes. Question, if we could turn to the next slide, can you please explain for the grand jury what we're looking at on this slide? Answer, this was a letter from Interlochen explaining, well, addressed to Maxwell telling her that they had found an envelope in the lodge that they had been staying in. Question, all right, we were talking a few moments ago about how blank described meeting Maxwell and Epstein at summer camp, and you testified that she provided them with her phone number. Did blank explain to you whether or not she had any contact with Epstein or Maxwell after she returned home to Palm Beach? Answer, yes. When was the next time that happened? Shortly thereafter. And how did that occur? She was invited to his house, so her and her mother went to Epstein's house to visit. What did blank tell you about that visit to Epstein's house with her mother? She said it was, wait, can you rephrase that? Of course. Did blank go to the house by herself or with her mother? With her mother. Okay, and when they went to the house, what did they do there? They had tea. Who was there when they had tea at the house? Epstein and Maxwell. What did they discuss as they had tea? They just talked about her life and, what she wanted to do. Did Epstein make any offers? He said that he gives scholarships. He likes to mentor people. How did blank's mother react when Epstein said this? She was happy for her daughter and oftentimes referred to Epstein as blank's godfather. Question. After that occasion, when they went over to the house, thereafter, did blank subsequently begin regularly spending time with Maxwell and Epstein at Epstein's house in Palm Beach? Answer, yes. Question, and did that start when she was approximately age 14? Answer, yes. Did it continue until she was about age 17? Answer, yes, it did. Question, and during those years, did she regularly go over to Epstein's house in Palm Beach and spend time with Maxwell and Epstein? Answer, yes. What happened in the summer of 1997 when blank was 17 and about to turn 18? Answer, she moved to New York City. Question, why did she move to New York City? Answer, she wanted to pursue a career in acting and modeling. Question, we'll talk about that in a moment, but for now, I want to focus on the years you talked about in Palm Beach from ages 14 to 17, when blank would regularly go to Epstein's house. In the beginning, in the first few months when she went there, what kinds of things did she do when she would visit the house when Maxwell and Epstein were there? Answer, they'd hang out by the pool. They would take her to movies, take her shopping. She described the behavior as grooming. Question, when you say grooming, did she explain what she meant by that? Answer, she meant that they were building a relationship with her, giving her things, taking her places, and then usually when the grooming happens, an offender will, once they gain that trust, they will make the relationship turn sexual. Question, now you testified a moment ago that blank described to you that she felt at this time period that they were grooming her, is that right? Answer, yes. Question, is that something that she realized at the time when she was 14, or is that something that she's described to you now? Answer, she's described now. She didn't realize it at the time. So we'll talk a little bit more about grooming in a moment, but to give context, are you familiar with the term grooming based on your experiences investigating crimes involving sexual exploitation of minors? Answer, yes. Question, generally speaking, you were touching on this a moment ago, but if you could explain in full, what is grooming? Answer, grooming is when someone builds a relationship with a child. They find vulnerability or a need, and then they work on gaining the child's trust, and then oftentimes gaining a parent's trust. Once they have that trust, they show that in a way that they care about them by giving them gifts and promises. Are you guys talking to me? Okay. Yeah, okay, sure. Sorry. And once that's established, they turn the relationship sexual, oftentimes making sexual comments and normalizing the behavior. Now, during these visits that you've been describing that blank told you about, did blank say whether Epstein ever gave her anything? Answer, yes, she did. What did he give her? He gave her cash. Sometimes he'd tell her to give the cash to her mom because he knew they needed it. He paid for her voice lessons as well. Now, you were describing how blank characterized these visits now, but based on your conversations with her, at the time, did she feel that these visits were strange at all? Answer, she thought they were strange, but Maxwell normalized it for her. She was like a cool older sister and made comments like, this is what grown-ups do. Question, you used the phrase cool older sister. Is that a phrase that blank used to describe how she felt about Maxwell at the time and what Maxwell was like? Answer, yes, those are her words. Anything? Okay. Question, did there come a time, these visits, when blank saw Maxwell topless by the pool? Answer, yes. What did she tell you about that? Answer, she was a little taken back, but Maxwell just acted normal. Question, did blank tell you about an incident several months into this arrangement when she lived alone, when she was alone with Epstein in the pool house? Answer, yes. Question, and when they were alone together, did Epstein ask what she wanted to do with her life? Answer, he did. Question, what did she say? Answer, she said she wanted to be an actress and a model. Question, how did Epstein respond? Answer, he told her that he was best friends with the owner of Victoria's Secret. Told her that she would have to have photographs taken and that she got to be comfortable in her underwear and not to be a prude. When she asked what that meant, he pulled her onto his lap and masturbated. What was her reaction? Answer, she felt paralyzed. She froze. Question, after this incident, did blank encounters with Epstein begin to include sexual contact? Answer, yes. Question, over time, did the sexual abuse escalate? Answer, it did. Question, from what she's described to you, did the abuse include Epstein digitally penetrating her? Answer, yes. Question, did it include Epstein using a vibrator on her? Answer, yes. Question, did she describe to you that there were times when Epstein would direct blank to massage him while he masturbated? Answer, yes. Did blank explain to you what her memories are like of the abuse? Answer, yes. Did blank explain to you, what did she say about that? Answer, she said that it happened so often that it all kind of runs together for her, that it's hard to separate out some of the different instances of abuse. Question, you were describing how blank explained to you that the abuse began. Did that occur based on what blank told you within the first year that she met Epstein and Maxwell? Answer, yes. Question, now, did blank also describe to you that once this abuse started, Epstein would also bring her into the massage room in the house? Answer, yes. Question, and were there times when he did this where there were other women present, including Maxwell? Answer, yes. Question, was blank abused during those episodes? Answer, yes, she was. Question, during these group encounters, what were blank and the adult women wearing? Answer, they were usually just in their underwear. I think we have a couple guests here in person and also online, so I might pause right here. I also did not bring water up with me, and no one, despite my eye motions, have been bringing me water. And so I'm actually going to take a pause, but I know that we have other people ready to participate in the live stream. And so joining me now, who's joining? Okay. I saw like 2 different people walk in who I know are here in person to participate, and okay. So now I'm joined by writer and investigative journalist Nina Burley,
Hi, everybody. I am Nina Burley. I am a journalist and an author and the publisher of a Substack called American Political Freak Show, which I've been writing for the last few years about the abnormal behavior of our leaders and their pals. And I've been investigating the Epstein case since 2019 when I did a documentary on Ghislaine Maxwell and really learned a lot about their operation. And at the Freak Show and at Courier, which syndicates the Freak Show, Courier News, we do a lot of work on the cover up that's going on right now. So I'm very proud to be here and to be reading this file, which is, I think, I think it's from the Ghislaine Maxwell trial, actually, and it's a survivor's testimony. So I'm just going to start with the court saying, thank you so much, and then Sigrid McCauley, who was an attorney for the survivors. Our next client who's going to address the court is DOJ Redacted. She says it much more beautifully than I do, so I'll let her say it. DOJ Redacted comes on. My first name is spelled blank, last name is blank. My name is blank. And I am a victim of Jeffrey Epstein and the sophisticated sex trafficking operation he ran, where he allegedly was to be a financier. I was 20 and blank. I met a young woman named blank through a mutual friend. We were friends for a few months. She was an amazing artist and liked to party. One day she called me and asked if I was interested in meeting a friend of hers. She told me he wanted to meet me and really liked blondes. And I thought he was our age and liked to do the same things we did at that age. So I agreed. On a sunny, crisp day, we took the train together to the Upper East Side. She then began to talk a little bit about him on our way to his house. I was at his house. I was sexually assaulted by both blank and Jeffrey Epstein in his mansion. It left me feeling both disgusted and betrayed. As we walked home to the subway afterwards, she continued to tell me about the man who had just abused me with her participation. She seemed exhilarated from the horrific experience. I was shocked and in a daze. This is a few things that she told me. She told me he went to Cooper Union. He was a mathematical genius, that he had favorite girls that he would take to Chanel for 15-minute all-you-can-buy shopping trips. She told me his right-hand person had connection to the arts and the fashion world, and she could help me. This is not my complete story. I'll stop here. I'm in a good, stable place in my life, and I had decided to come forward to be a voice to the victims who may not be able to tell their story, or at least not yet. I feel like I am a survivor. Thank you, Judge Berman, for inviting victims to speak today before you. We hope the government is listening very closely to the words we are saying. The court, thank you very much. Mr. Boyce, that's David Boyce, the attorney. Your Honor, just very briefly, the court, sure. Mr. Boyce, I would like to express to the court how proud I am of all these women who have come forward. It's taken an enormous amount of strength and courage for them to do this. Thank you. The court. Thanks, Mr. Boyce. Hold on 1 second. Pause. A long redaction. And Your Honor, with your permission, I would like my client, redacted, to stand next to me. The court, sure. Redacted, would that be okay? The court, absolutely. Redacted. Your Honor, I would like to begin by saying that I am in awe of all these beautiful women. I just want to let you know, on behalf of Redacted and myself, we admire you, we respect you, and we applaud you. And on behalf of Redacted myself, you are brave survivors, and Redacted's heart is with all of you. And we thank you so much for coming forward. Redacted, when she went public, she thought she was one of the only ones. And to see all of these faces is, I know, amazing for her. Jeffrey Epstein was a predator, a pedophile, and a sick individual. However, he was also a thief. He stole Redacted's childhood dreams, her innocence, and her self-confidence. She was 14 years old. What he could not buy, he forcibly took. Why? Because he surrounded himself with a network of powerful people who actively facilitated and participated in his sexual abuse of women, of children. Jeffrey Epstein thought he was above the law. And essentially he was until now. The system let Redacted and the other victims down, but it does not have to end here. We ask the U.S. Attorney's Office and the FBI to bring all of Epstein's enablers and co-conspirators to justice. It has taken Redacted 18 years to find her voice. And again, Jeffrey Epstein has tried to silence her. While she will never have her chance to face him in court, he no longer has any power over her. Today, this brave survivor will be heard. Redacted. Thank you for allowing me to be able to have my chance in court today, to be able to tell you what this horrific man did to my life. You can't even imagine how much it affected my childhood, all the way through my adult life. He robbed me of my dreams. He robbed me of my chance to pursue a career I always adored. He stole my chance at really feeling love because I was so scared to trust anyone for so many years that I had such severe anxiety. I didn't want to leave my house, let alone my bed. The fact that he felt entitled to take away my innocence, the fact that he felt that he could do whatever he wanted, regardless of the laws, hurts me so very much. It took me years to tell anyone what Epstein did to me because I was so ashamed and embarrassed at what people would say or think of me, until I found out there were other victims, girls just like me. I knew I could no longer keep my silence, no matter how ruthless and powerful Epstein was, and still is, even after his death. The fact I will never have a chance to face my predator in court eats away at my soul. Even in death, Epstein is trying to hurt me. I had hoped to at least get an apology, but this evil man had no remorse or caring for what he did to anyone. I felt let down by the people who were supposed to watch him in prison. They let this man kill himself and kill the chance of justice for so many others in the process, taking away our ability to speak. Out of all the damages and side effects that Epstein caused by his heartless and selfish acts, it's very hard to put my feelings and emotions into words, trying to let his horrendous actions go and attempting to forgive him has been so difficult for me. Yet, as hard as it's been to come so publicly forward, I refuse to let Epstein take me as a victim anymore. I am a survivor. The many that stand before me here today that have shared the horrific experiences with this deplorable human being, because even though this week, evil coward tried to steal all of our childhoods, tried to steal all of our innocence, and tried to steal all of our means of justice, he will never steal our inner strength. And he will never, ever, ever steal our voice. Thank you so much. the court. You're welcome. Sure. Are they coming on? Okay. Yeah, I mean, I would just say, we're talking about 1,000 women who've had this, girls and women who've had this experience. Um, these people were monsters. And even here, even just in this little bit of reading, I can see that they are still redacting the names of the co-conspirators. You can see that in the redaction. So it's outrageous. But unfortunately, we have a Justice Department that is verging on lawless. Today's news about the $1.776 billion slush fund being set up for the coup plotters and thugs and criminals who participated in January 6th. That's taxpayer money. So we're a long way from getting, cleaning house here, but we need to keep our eyes on this. And I appreciate that you're giving me the chance to participate in this. And also, I really appreciate the Donald J. Trump, Jeffrey Epstein Memorial Library. And I hope it goes around the country and that everybody gets a chance to understand what happened here. And wrapped unless you want me to read more. Yep. Would you like me to read more?
No problem. We are? Okay. Thank you so much, Nina. And also, I want to announce we officially hit 10 hours of live streaming. So nice work, everyone. And thank you, everyone who is watching this stream, because we are streaming for 24 straight hours from cover to cover up. We are at the Donald J. Trump and Jeffrey Epstein reading room in Lower Manhattan. And while we read, we're raising money for World Without Exploitation. So you can scan the QR code on your screen to give to support the important work. Joining me now, live from Montana, are two wonderful guests, the hosts of the Grounded podcast, former U.S. Senator John Tester and Maritza Giorgio.
I think we'd learned the unmuting thing by now after all these years of Zoom. Thanks so much, Eliza. I'm Maritza Giorgio alongside former Senator John Tester, and we host the Grounded podcast Substack. And we are so honored to participate in this cover to cover up marathon of leading these files, because as we've seen, there is no shortage of news and headlines from this administration. And there's been such an effort to make this story go away. And we, the people, are not going to let it go away. Senator?
Yeah. Why is it doing that? Okay.
Any headphones, Senator?
So.
Room, if you want to weigh in on what we should do here. I will get us
Let's just keep going, Maritha. You keep driving and we'll see.
And then I keep driving the bus here. So we just heard Nina read from some court documents, some testimony. And the pages that we have to read from are excerpts from a court hearing that took place on August 27th. 2019 at 10:30 a.m. That date is important because it was 8 days after Jeffrey Epstein's death. So this was a hearing to consider the government's motion to dismiss the indictment in this case. And what's remarkable and historic is that the judge allowed survivors to speak in open court during this hearing. More than 15 women who accused Epstein of abuse testified and confronted an empty chair. And it was really their only chance to speak in open court because Epstein's death removed the possibility of a criminal file. So we are picking this up mid-sentence, mid-testimony from a survivor who addressed the court on that day. And I will start us off, and hopefully we can get Senator Tester's microphone working so it's not echoing. So we're going to start here. To continue, because I had been taken advantage of my entire life and had been conditioned to just accept it. It took me a long time to come forward, too long maybe, and all that it took to bring this man to justice has been robbed by his death. Every day, every week I've spent in the hospital since, I've suffered and he has won. Every job offer that's been offered to me and then retracted because of my connection to this case, I have suffered and he has won. Every public humiliation I've endured, I have suffered and he has won. Every relationship that I've had to end because of the abuse that I have endured by the hands of this man, I have suffered and he has won. Every woman sitting in this room today and all of the women who have yet to come forward and who have not yet to come forward and whose lives have been affected by Jeffrey Epstein's sick abuse of young girls, we have all suffered and he is still winning in death. I refuse to let this man win in death. I couldn't fight back when Jeffrey Epstein sexually abused me because I hadn't yet found my voice. Well, I have found my voice now. And while Jeffrey may no longer be here to hear it, I will not stop fighting and I will not be silenced anymore. I needed him to hear the pain he's caused, what I've gone through because of him. I wrote a 350-page book of all that pain that I have endured at the hands of this man that I really needed him to hear. His death has robbed me of that justice. Please don't rob us of justice again. Thank you. Senator, did we figure your microphone out?
I don't know. Does it work? Mr. Edwards says, Your Honor, I think I have one more client that is going to speak today, and that client is redacted. The court says, would you prefer to spell that? And obviously it was spelled and redacted. Good morning, Your Honor. The court says, good morning. A redaction. My name is spelled and it's redacted. Thank you, Your Honor, for giving us this opportunity to be heard this morning. And the court responds, sure. A redaction. And then when I was introduced to Jeffrey Epstein, I was young and full of hope and the foolishness of a teenager. I was idealistic and I saw the good in people. Jeffrey Epstein manipulated me, coerced me, and sexually abused me. Something I think is very important to communicate is that loss of innocence, trust, and joy is not recoverable. The abuse, spanning several years, was devaluating beyond measure, and affected my ability to form and maintain healthy relationships, both in my work and my personal life. He could not begin to fathom what he took from us. And I say us because I am every girl he did this to, and they're all me. And today we stand. You're going to have to go, Marisa.
I'll pick it up. Today we stand together, those that are present and those that aren't. I was a victim, and it has taken me many, many years to stand here and say, yes, it was me. I was a victim, but I will not remain a victim and be silent for one more day. Although I think it's tragic when anybody dies before their time, I'm extremely relieved that Jeffrey Epstein will not be in a position to hurt any more children or any more women. And I'm glad to be part of a group of women who are now bonded forever in the trauma that we endured at the hands of this man. Thank you. The court says, thank you. And Mr. Edwards says, Your Honor, we had one client who is not able to be here, but sent a message through a letter. Her name is redacted, last name, redacted. And Brittany Henderson of my office is going to read her letter as instructed. The court says, sure. And Miss Henderson says, thank you, Your Honor. The court says, yep. And Miss Henderson says, she starts to read the letter. What happened to me occurred many years ago when I was in high school, but it still affects my life. I was told that when Jeffrey Epstein was going to be held accountable, but he was not. In fact, the government worked out a secret deal and didn't tell me about it. The case ended without me knowing what was going on, without him being held responsible, without any explanation, without a chance for my voice to be heard. I was treated like I did not matter. Did you find it, Senator?
Many years later, he was arrested again. These investigators and attorneys representing the United States have been completely different. I am still mad, concerned, and confused about how he committed suicide and escaped responsibility again. But I know it is not the fault of the judge or the government attorneys. I was allowed to be a part of the process this time. My attorney was able to tell me what was going on at every stage because they kept him informed. Thank you for inviting me. It means more to me than you can ever know. I was not able to be here this time, but I know that I was allowed to be, and I had the chance to attend this hearing, which is helping me in my healing process. The fact that I mattered this time and the other victims mattered is what counts. For that, I'm grateful. And the court responds, thank you. Mr. Edwards says, Your Honor, finally in 2008, when I filed this case under the Crimes Victim Rights Act, it wasn't me alone. I did it with Paul Cassell and Jay Howell. Paul Cassell is here today, and I think Your Honor even cited to a piece of an opinion of his from when he was on the bench, and he has some remarks to make. Once again, Your Honor, I really do believe that this is a model for how victims should be treated in the criminal process, and we really do appreciate it. Thank you. And the court responds, thank you. Go ahead, Marisa.
Cassell says, I'll be very brief because I know there are others that want to speak here. I'm Paul Cassell, Cassell, previously served as a federal judge at the District of Utah, currently a law professor where I teach crime victims' rights at the University of Utah College of Law. I just wanted to take 1 minute to address some suggestion that there would be no need for a hearing this morning. I think, having heard already from these powerful victims and recognizing how important giving those statements will be in the trajectory of their lives, makes clear that Your Honor has followed exactly the right path. Legally, there is one precedent, which is U.S. v. Heaton, a case that you cited that I wrote about a decade ago. And as explained in that opinion, victims have important interests in the criminal justice system that can only be recognized if they're given their day in court. With all due respect to other law professors that have recently written an article, I think transparency is one of the overriding objectives in our criminal justice system. And the one substantive action that I would urge Your Honor to take today is to publish your remarks as a published opinion. The Heaton case is, to my knowledge, the only reported decision on this particular issue, even though it's more than a decade old, and yet we can see today that these problems recur in many other cases. Your remarks today, I think, should be published so that they can serve as a guide for other judges around the country.
I encourage you to add into your remarks a reference to the Crime Victims' Rights Act. The Crime Victims' Rights Act promises victims the right to be treated with fairness, dignity, and respect. And the process that we see unfolding this morning is a clear example of how victims can be treated with fairness, dignity, and respect. So I know that Your Honor is wondering, what is the appropriate action here? Unfortunately, it seems like there are no other legal options, but there was a legal option for you to decide to exercise, which was to allow these victims to come forward. And if there's been one positive thing that has come out of these tragedies, the abuse and other events of this case, it's been your decision to allow these victims to be heard this morning. And I encourage you to publish your decision and to encourage other judges to follow what is clearly a model for crime victims' rights and is clearly an example that should be followed in other cases down the road. The court responds, thank you very much. I appreciate your being here. I had no idea that you would be here when I wrote the remarks, but it was clear from the literature that you are the leading expert formerly of the District Court of Utah, I believe. And it's a pleasure to have you here today. Mr. Cassell says, "Thank you, Your Honor." The court responds, "Thank you." And then Mr. Boys is called.
Mr. Boyce says, "Thank you, Your Honor." David Boyes of Boyes, Schiller, Flexner. We have with us today 5 of the victims that we represent. There are a number of additional victims who either were unable to attend or are still unwilling to come forward publicly. This has been an enormously traumatic aspect of their lives, something that, as you've already heard and will hear more today, is something that they can never entirely escape from. I want to, as prior counsel have, commend both the court and counsel for the Department of Justice for the consideration and respect and attention that they have paid to the victims. We believe that it is not only right as a matter of human dignity, but we think that it is exactly what the law requires and intends. I will be more blunt than the court has been, or Professor Cassell has been, about Professor Green's article. I'm going to pause here for a moment and explain Professor Green's article. So there's a Fordham Law professor, Bruce Green, who co-authored this article with attorney Alan Dershowitz, and they were criticizing this federal judge for allowing Jeffrey Epstein's victims to speak in court following his death. I'll continue with this document. Mr. Boyce continues, "That is an article that cites no authority, and I believe there is no authority for his proposition. I entirely respect his right to advocate on behalf of his client, Alan Dershowitz, who has retained him in connection with litigation that we've brought against Mr. Dershowitz. But why I would have expected that the law journal or Professor Green himself would have disclosed that connection, which I think is a conflict. But regardless of the appropriateness of his disclosure or lack of disclosure, I think that his article opposing allowing the victims to have a voice in this proceeding is inconsistent not only with the policy that underlies the Crime Victims' Rights Act and the very statute that Mr. Epstein is being prosecuted under, but it ignores the actual language of those statutes and many other statutes in which Congress has made clear that the purpose of the criminal law is no longer simply to punish the individual defendant, but it is to find some way of trying to mitigate the damage that has been done to the victims through restitution and economic mitigation, but also through the ability to confront and to have the court system and justice system and prosecutors treat these victims, as they are human beings, and they are entitled to the respect that our society needs to give every human being. So I think this is not only commendable, but I think it is what the law requires."
In response to the question the court asked, I have discussed this hearing with my clients. I have told them that under the applicable law, the government has no alternative but to dismiss this case. And I believe under the applicable law in this circuit, the court has no alternative but to grant that motion. Suggested in some of its remarks, I think there will come a time when either an appellate court or the Congress will make clear that just as it's possible to continue civil cases against someone after they have deceased, it is possible, at least for the purposes of things like restitution, to continue criminal cases, but we are not there now. And fortunately, in this case, there are other ways, and perhaps even more efficient ways, to vindicate the interests of the victims here. We greatly appreciate the remarks of the representative of the Department of Justice today, and we, too, on behalf of the victims, are not going to stop while we walk out of this courtroom. We're going to continue to seek vindication against Mr. Epstein's estate, and in some senses, perhaps even more important, against the people who worked with him and enabled him. As you have already heard, and will hear more, Mr. Epstein did not act alone. He could not have done what he did on the scope and scale of what he did for as many years as he did without the activities and support and the co-conspirator activities of a number of other key individuals. And these individuals also need to bear their share of responsibility, and those people need to have a reckoning as well. My partner, Sig McCauley, who's been working with me for more than 5 years on this case, is going to, with the court's permission, introduce 5 of our clients who will speak briefly to your court. Thank you very much. The court responds, "Thank you very much, Mr. Boyes. Pleasure to have you here."
Ms. McCauley, starts speaking and says, "Thank you, Your Honor. The first victim that would like to speak today is," and their name is redacted. The court asks, "Can we have the spelling of your name?" Miss McCauley says, "Sure. Sigrid, Sigrid, and the last name is McCauley, Mccawley, and I'm a partner at Boies Schiller Flexner." The court says, "Thank you." The redacted name, the victim says, "Good morning." The court says, "Good morning." And the survivor goes on to say, "Thank you, prosecutors and judge and the court. My name is redacted. I note today I do feel respected and listened to. So I appreciate that. And I have to say that I commend the boldness of the New York prosecutors for pursuing a man that has, and others that have clearly taken a lot from a lot of people. 17 years ago, I knew him only as Jeffrey. I was recruited and brought from redacted to New York. And that experience for the last 17 years has been a dark corner in my story, in my life story. And that has been definitely made worse by my own self-shame and anger for normalizing all of the red flags. I feel like we are conditioned to do that. And that's something that needs to change. So I'm here today, I'm coming forward because it is time to bring light to that darkness, and it's time to replace that darkness with light. And I am a survivor of this, and I do aim to progress further from being a survivor. I feel like I've worked hard, quite hard, to get where I am at now. And I'm definitely at a place in my life where I will no longer cover up. I'll no longer cover up what needs to be brought to light. Jeffrey's no longer here, and the women that helped him are Ghislaine Maxwell. My experiences with Ghislaine Maxwell and redacted. And they definitely need to be held accountable for helping him, helping themselves, helping one another carry on this huge, almost like a system. So they need to be held accountable, all of them. And I would like to see that certainly on behalf of myself and for everyone here. Thank you. I will send it to you, Senator Tester, but I want to note again that we have a name of somebody that this survivor is naming as a conspirator, a co-conspirator. That name is redacted in this file. Go ahead, Senator.
The court responds, "Thank you so much, Ms. McCauley.